As always, such classifications are a bit neater than reality, and so they should not be taken as rigid. 131. Compartments. Many of the distorting processes operate at all criminal justice decision points. The section in which a given issue is treated is a reflection of the point in the criminal justice process at which the disparities are the most striking. Third, the movement from arrest to sentencing is a funneling process so that discrimination that occurs at any early stage shapes the population that reaches later stages. Thus, for example, some studies find little economic bias in sentence length for people convicted of similar crimes. When reading such studies, remember that the population that reaches the point of sentencing has already been subject to whatever discrimination exists at earlier stages. If, for example, among people with similar offenses and records, poor people are more likely to be charged and more likely to be convicted, then, even if the sentencing of convicted criminals is even-handed, it will reproduce the discrimination that occurred before arrest and charging. Most official records of who commits crime are really statistics on who gets arrested and convicted. If, as we will show, the police are more likely to arrest some people than others, these official statistics tell us as much about police behavior as of criminal behavior. In any event, they give us little reliable data about those who commit crimes and do not get caught. Some social scientists, suspicious of the bias built into official records, have tried to devise other methods of determining who has committed a crime. Most often, these methods involve an interview or questionnaire in which the respondent is assured of anonymity and asked to reveal whether he or she has committed any offenses for which he or she could be arrested and convicted. Techniques to check the reliability of these self-reports also have been devised. However, if their reliability is still in doubt, common sense dictates that they would understate rather than overstate the amount of crime that never comes to official notice. In light of this, the conclusions of these studies are rather astounding. It seems that crime is the national pastime. The President's Crime Commission conducted a survey of 10,000 households and discovered that 91% of all Americans have violated laws that could have subjected them to a term of imprisonment at one time in their lives. 31. A number of other studies, some dating back to the 1940s, support the conclusion that serious criminal behavior is widespread among middle and upper-class individuals, although these individuals are rarely, if ever, arrested. 32. The authors of a 1990 review of literature on class and delinquency conclude research published since 1978, using both official and self-reported data suggests that there is no pervasive relationship between SES socioeconomic status and delinquency. 33. Other studies suggest that some forms of serious crime forms usually associated with lower-class youth show up more frequently among higher-class persons than among lower-class ones. 34. The simple fact is that for the same offense, poor people are more likely than better-off people to come to the attention of the police. Once that happens, a poor person is more likely to be arrested and, if arrested, charged than a middle or upper-class person. 35. Gold writes that at each stage in the legal process, from charging a boy with an offense to some sort of disposition in court, boys from different socioeconomic backgrounds are treated differently, so that those eventually incarcerated in public institutions, that side of most of the research on delinquency, are selectively poorer boys. 36. When individuals were apprehended, if the offender came from a higher status family, police were more likely to handle the matter themselves without referring it to the 132 court. 37. Terence Thornberry reached a similar conclusion in his study of 3,475 delinquent boys in Philadelphia. He found that among boys arrested for equally serious offenses and who had similar prior offense records, police were more likely to refer the lower-class youths than the more affluent ones to juvenile court. The police generally dealt with the wealthier youngsters informally, for example, by holding them in the station house until their parents came rather than instituting formal procedures. Of those referred to juvenile court, Thornberry found further that, for equally serious offenses and with similar prior records, the poorer youngsters were more likely to be institutionalized than were the affluent ones. The wealthier youths were more likely to receive probation than the poorer ones. As might be expected, Thornberry found the same relationships when comparing the treatment of black and white youths apprehended for equally serious offenses. 38. Later studies continue to show similar effects. For example, Sampson found that, for the same crimes, juveniles in lower-class neighborhoods were more likely to have some police record than those in better-off neighborhoods. 39. A study of youth in Seattle, Washington, also found that regardless of race and self-reported criminal behavior, youth from poorer families are more likely to be arrested. 40. In some studies, court officials acknowledge that they consciously and affirmatively take steps to direct low-income families into the juvenile justice system, because they believe that the court will help the youth and facilitate the services, accountability, and discipline needed to become a productive adult. 41. Unfortunately, such hopes all too often fail to be realized and leave the youth with all of the stigma and burdens of contact with the criminal justice system. 42. If you think these differences are not so important because they are true only of young offenders, remember that this group accounts for much of the crime problem. Moreover, other studies not limited to the young tend to show the same economic bias. McCarthy found that, in metropolitan areas, for similar suspected crimes, unemployed people were more likely to be arrested than employed people. 43. As indicated earlier, we take racial bias as a proxy for bias against the poor, and blacks are more likely to be suspected or arrested than whites. A 1988 Harvard Law Review overview of studies on race and the criminal process concludes that most studies reveal what many police officers freely admit, that police use race as an independently significant, if not determinative, factor in deciding whom to follow, detain, search, or arrest. 44. Furthermore, according to Jerome Miller, a 1994 study of juvenile detention decisions found that African American and Hispanic youths were more likely to be detained at each decision point, even after controlling for the influence of offense seriousness and social factors, example single-parent home decisions by both police and the courts to detain a youngster were highly influenced by race. 45. The study states that not only were there direct effects of race, but indirectly, socioeconomic status was related to detention, thus putting youth of color again at risk for differential treatment. 46. And there is some evidence that charges against blacks are thrown out more frequently than charges against whites because blacks are arrested on the basis of less evidence. 47. In a 2007 research report, criminologists first reviewed recent high-quality research on disproportionate minority contact with the juvenile justice system. They concluded that minority youth are more likely to have contact with the system and to penetrate further into it than non-minority youth. The same researchers then analyzed their own data from 3 U.S. cities and found that for most offenses, African Americans, 133, have somewhat higher prevalence rates of delinquent behavior than whites, but their contact/referral rates far exceed those of whites. 48. Specifically, in Pittsburgh, 38.1% of white offenders, individuals who committed an offense, were apprehended and referred to court, but 66.3% of African American offenders were apprehended and referred to court. In Rochester, 19.2% of white offenders and 51.3% of African American offenders were contacted/arrested. And, in Seattle, 33.2% of white offenders were apprehended and referred to court, while 64.4% of African American offenders were apprehended and referred to court. 49. This analysis is based on the number of offenders and thus already controls for the higher amount of crime committed by blacks. Further, 32 of 44 states that have studied disproportionate minority contact, DMC, found evidence of ethnic or racial differences in juvenile justice system decision-making that was unaccounted for by differential criminal activity. 50. The National Academy of Sciences Panel on Incarceration indicates an increasing disjunction between racial patterns in crime and imprisonment. 51. There is also the disturbing finding that many black people are arrested for the crime of driving while black. John Lamberth of Temple University set out to study whether the police arrest black drivers on the New Jersey Turnpike out of proportion to their percentage in the driving population and to their rate of committing traffic violations. Lamberth and his team recorded data on more than 42,000 cars. They found that blacks and whites violated the traffic laws at almost exactly the same rate, but 73.2% of those stopped and arrested were black, while only 13.5% of the cars on the road had a black driver or passenger. Lamberth notes that the disparity between these two numbers is statistically vast. 52 similar studies, with similar results, were carried out in Maryland and Ohio. For reasons mentioned earlier, a disproportionately large percentage of the casualties in the recent war on drugs are poor inner-city minority males. In contrast, the authors of Dorm Room Dealers report on the anti-targets of the drug war a network of affluent, mostly white, college students in Southern California who had $80,000 to $160,000 a month in drug sales. Almost all the dealers were from middle-upper class to affluent/upper class families and had parents of considerable economic standing, mayors, business people, and doctors. 53 Because of their class status, they operated with relative impunity despite the near-absent or, perhaps more accurately, pathetic risk minimization strategies. 54 The authors, while fully aware of class biases in the criminal justice system, were still taken aback by the lack of criminal justice and university administration attention paid these dealers, despite the brazenness, incompetence, and general dearth of street smarts that tended to characterize the dealers' daily practices. 55. In contrast, Victor Rios' research in Oakland, California, describes a youth control complex, in which a range of criminal justice, community, media, and business institutions treat young people's everyday behaviors as criminal activity. 56. Rios points to a citation for not wearing a properly fitted bicycle helmet, and describes how talking back or looking at them crazy can lead to a citation for disorderly conduct. 57. This hypercriminalization is not confined to Oakland. An analysis of 10,000 tickets issued to bicyclists by Tampa, Florida, police found that even though blacks make up about a quarter of the city's population, they received 79% of the bike tickets. The investigation found that Tampa police are targeting poor, black neighborhoods with obscure subsections of a Florida statute that outlaws things most people have tried on a 134 bike, like riding with no light or carrying a friend on the handlebars. 58 These practices and others like them spread across other jurisdictions steered the boys deeper into the system because missed court dates lead to arrest warrants, and an inability to pay their fines lead to probation, which entailed more intense police scrutiny. 59. More generally, the war on drugs disproportionately targets racial minorities, even though surveys dating back to the 1990s show blacks do not use drugs more than whites, and more recent studies show whites are more likely than non-whites to have sold drugs. 60. A study conducted by the Sentencing Project, based mainly on Justice Department statistics, indicates that while African Americans constitute 14% of the nation's monthly drug users, they represent 37% of those persons arrested for drug offense and 56% of those in state prison for a drug conviction. 61. Consider that New York City police stopped 685,000 people in 2011. And 85% of them were black or Latino. 62. So it is no surprise that 86% of people arrested for marijuana possession were black or Latino, despite data showing that whites and minorities use marijuana at similar rates. 63. Many reasons can be offered to account for the differences in police treatment of poor versus well-off citizens. Some argue that they reflect that the poor have less privacy. 64. What others can do in their living rooms or backyards, the poor do on the street. Others argue that a police officer's decision to book a poor youth and release a middle-class youth reflects either the officer's judgment that the higher-class youngster's family will be more likely and more able to discipline him or her than the lower-class youngsters, or differences in the degree to which poor and middle-class complainants demand arrest. Many argue that police training and police work condition the officers to be suspicious of certain kinds of people, such as lower-class youth, blacks, Hispanics, and so on. 65. And thus more likely to detect their criminality. Still others hold that police mainly arrest those with the least political clout. 66. Who are least able to focus public attention on police practices or bring political influence to bear, and these happen to be the members of the lowest social and economic classes. Regardless of which view one takes, and probably all have some truth in them, one conclusion is inescapable: one of the reasons the offender at the end of the road in prison is likely to be a member of the lowest social and economic groups in the country is that the police officers who guard the access to the road to prison make sure that more poor people make the trip than well-to-do people. Differences in policing not only apply to the rich and the poor who commit street crimes, but it is also noticeable when street crime is compared to white-collar and corporate crime. As with crime on the streets, crime in the suites is also rampant. Sutherland, in a classic 1949 study, analyzed the behavior of 70 of the 200 largest U.S. corporations over a period of some 40 years. The records reveal that every one of the 70 corporations had violated one or more of the laws, with an average of about 13 adverse decisions per corporation and a range of from 1 to 50 adverse decisions per corporation. Thus, generally, the official records reveal that these corporations violated the trade regulations with great frequency. The habitual criminal laws of some states impose severe penalties on criminals convicted the third or fourth time. If this criterion were used here, about 90% of the large corporations studied would be considered habitual white-collar criminals. 67. 135. What Sutherland found in 1949 continues up to the present. In his 1990 book, Corporate Corruption, The Abuse of Power, Marshall Clinard notes the extensive law violations in many industries and how over one 2-year period, the federal government charged nearly 2/3 of the Fortune 500 corporations with law violations, half were charged with a serious violation. 68. Nevertheless, corporate executives rarely end up in handcuffs or at the police station, mixing with poorer persons who had stolen much less from their fellow citizens. At subsequent stages of the criminal justice process, white-collar criminals accumulate advantages so that a study of sanctions imposed for corporate law violations found that administrative, that is, non-criminal Penalties were employed in 2/3 of serious corporate law violations, and that slightly more than 2/5 of the sanctions consisted simply of a warning to the corporation not to commit the offense again. 69. The regulatory agencies that police white-collar and corporate crime are not given the same tools and resources as those given to police fighting smaller-scale and less sophisticated crime. For example, under federal law, the SEC isn't permitted to listen to live wiretaps, just recordings delivered somewhat after the fact. Notes one SEC employee: the U.S. Fish and Wildlife Service has access to wiretaps, but the SEC doesn't. And somehow you expect us to oversee Wall Street. 70 SEC staff attorneys do not get issued work smartphones, only managers do. Further, both the federal and state governments are potential police for wage theft, which occurs when employers do not pay their employees all the money they have earned under the laws covering minimum wage, overtime pay, and breaks. Although the workforce and number of workplaces has increased, the number of Federal Wage and Hour Division investigators is less than in the 1970s under President Carter. In response to political pressures, several states totally or partially defunded those divisions for 1 or more years. Idaho had 3 employees to police employer compliance with wage laws, and other states relied partly on senior citizen volunteers. Further, agencies in Michigan, Oklahoma, and Texas lacked authority to initiate investigations, so all their activity was in response to worker claims, which is much less efficient than investigating businesses that are typically at the highest risk for wage theft. 71 Even in states where an agency has the power to investigate wage and hour violations, many are so understaffed that they simply respond to calls and help an individual rather than seeing if other employees at that workplace have similar problems. When prosecutors select cases where they will bring charges, they add to the cumulative advantage and disadvantage. The Harvard Law Review overview of studies on race and the criminal process asserts prosecutors are more likely to pursue full prosecution, file more severe charges, and seek more stringent penalties in cases involving minority defendants than in cases involving non-minority defendants. 72 This pattern is found by Susan Shapiro and reported on in The Road Not Taken, The Elusive Path to Criminal Prosecution for White-Collar Offenders. Focusing on the enforcement practices of the SEC, Shapiro writes that while criminal dispositions are often appropriate, they are rarely pursued to the sentencing stage. Out of every 100 suspects investigated by the SEC, 93 have committed securities violations that carry criminal penalties. Legal action is taken against 46 of them, but only 11 are selected for criminal treatment. 6 of these are indicted, 5 will be convicted, and 3 sentenced to prison. Thus, for Securities and Exchange Commission enforcement, criminal prosecution most often represents the road not taken. Of those found to have engaged in securities fraud, 88% never have to contend with the criminal justice. 136. System et al. 73. We shall see later that a large number of potential criminal cases arising out of the savings and loan scandals were dismissed by federal law enforcement agencies because they lacked the personnel to pursue them, even as thousands of new police officers were being hired to fight street crime. With upper-class lawbreakers, the authorities prefer to sue in civil court for damages or for an injunction rather than treat the wealthy as common criminals. Judges have, on occasion, stated in open court that they would not make criminals of reputable businessmen. One would think it would be up to the businessmen to make criminals of themselves by their actions, but alas, that privilege is reserved for the lower classes. To a greater extent than with individuals, corporations can join Club Fed deferred by getting a non-prosecution agreement, NPA, or Deferred Prosecution Agreement, DPA, which provide that the Department of Justice will not prosecute if the company agrees to implement certain reforms. 74. According to the General Accounting Office, DOJ intends for these agreements to promote corporate reform. However, DOJ does not have performance measures in place to assess whether this goal has been met. Therefore, it could be difficult for DOJ to justify its increasing use of these tools. 75. Nevertheless, DOJ has expanded their use, even though one judge argues that the future deterrent value of successfully prosecuting individuals far outweighs the prophylactic benefits of imposing internal compliance measures that are often little more than window dressing. 76. Even where a negotiated settlement is preferable to a trial, plea bargains can achieve the same reforms in a way that is reviewed and recorded by the court in a public record rather than being a private contract between the government and a wrongdoer. 77. The clientele of the criminal justice system forms an exclusive club. Entry is largely a privilege of the poor. The crimes they commit are the crimes that qualify one for admission, and they are admitted in greater proportion than their share of those crimes. Curiously enough, the crimes the affluent commit are not the kind that easily qualify one for membership in the club. Adjudication and conviction. Between arrest and imprisonment lies the crucial process that determines guilt or innocence. Studies of individuals accused of similar offenses and with similar prior records show that the poor defendant is more likely to be adjudicated guilty than is the wealthier defendant. 78. In the adjudication process, the only thing that should count is whether the accused is guilty and whether the prosecution can prove it beyond a reasonable doubt. Unfortunately, at least two other factors that are irrelevant to the question of guilt or innocence significantly affect the outcome. One is the ability of the accused to be free on bail prior to trial. And the second is access to legal counsel able to devote adequate time and energy to the case. Because both bail and high-quality legal counsel cost money, it should come as no surprise that here, as elsewhere, the poor do poorly. Being released on bail is important in several respects. First and foremost is that those who are not released on bail are kept in jail like individuals who have been found guilty. They are thus punished while they are still legally innocent. The Bureau of Justice Statistics reported that local jails held 744,600 inmates at mid-year 2014, and 62.8% of inmates had not been convicted, up from 56% in 2079. While some detainees may be dangerous or a flight risk, 75% of pretrial detainees are charged with 137 relatively minor property crimes, drug offenses, or other nonviolent acts, and remain in jail simply because the money bond was set in an amount they cannot afford to pay. 80. Beyond the obvious ugliness of punishing people before they are found guilty, confined defendants cannot actively aid in their own defense by seeking out witnesses and evidence. Studies confirm that those held on bail are more likely to be convicted than those who are released. 81. Research finds that an unemployed defendant was 3.2 times more likely to be incarcerated before trial than his employed counterparts. 82. And that being lower class is a greater disadvantage for African Americans than for whites. 83. Further, nearly every study on the impact of race in bail determinations has concluded that African Americans are subjected to pretrial detention at a higher rate and are subjected to higher bail amounts than are white arrestees with similar charges and similar criminal histories. 84. Furthermore, because the time spent in jail prior to adjudication of guilt may count as part of the sentence, the accused are placed under situational coercion. Suppose you are innocent and have been in the slammer for several months awaiting trial. The prosecutor offers a deal: if you plead guilty to such and such, usually a lesser offense than has been charged, say, disorderly conduct instead of resisting arrest, the prosecutor promises to ask the judge to sentence you to time served. In other words, plead guilty and walk out of jail. Today, free, but with a criminal record that will make finding a job hard and ensure a stiffer sentence next time around, or maintain your innocence, stay in jail until trial, perhaps in a year, and then be tried for the full charge instead of the lesser offense. Not only does the prosecutor threaten to prosecute for the full charge, but he may also threaten to press for the most severe penalty as well for taking up the court's time. Contrary to the image conveyed by dramatic courtroom arguments in televised crime dramas, about 95% of convictions are the result of a negotiated plea. 85% there's no trial, just a bargain in which the accused agrees to plead guilty, usually to a lesser offense than he or she is charged with or to one offense out of many he or she is charged with, in return for a promise of leniency from the prosecutor with the consent of the judge. If you were the jailed defendant offered a deal like this, how would you choose? Suppose you were a poor black man not likely to be able to retain a high-profile private attorney. The advantages of access to adequate legal counsel during the adjudicative process are obvious but still worthy of mention. In 1963, the U.S. Supreme Court handed down the landmark Gideon v. Wainwright decision, holding that the states must provide legal counsel in all felony cases to those who cannot afford them. As a result, no person accused of a serious crime need face his or her accuser without a lawyer. However, the Supreme Court has set the standard for ineffective assistance of counsel so low that even sleepy, drunk, or bad lawyers are acceptable. The problem of adequate legal representation is particularly acute in death penalty cases. According to Robert Johnson, most attorneys in capital cases are provided by the state. Defendants, as good capitalists, routinely assume that they will get what they pay for, next to nothing. Their perceptions, he concludes, may not be far from right. 86 Indeed, Stephen Gettinger maintains that an inadequate defense was the single outstanding characteristic of the condemned persons he studied. 87. Robert Wayne Halsey was an African American with a low IQ who was severely beaten as a child. He was convicted of murder and his trial lawyer later admitted that at the time the lawyer was drinking up to a quart of vodka daily and facing theft charges that would land him in prison. He said he should not have been representing a client. 88 Even though he was later disbarred and criminally convicted, the lawyer's defense was 138 found to be adequate, and Halsey was executed. The problem is that Halsey's case had some exceptional elements, but it's difficult to shock the courts, notes John H. Bloom, director of the Death Penalty Project at the Cornell Law School. 89. A Time magazine article on this topic noted, because the majority of murder defendants are broke, many of them get court-appointed lawyers who lack the resources, experience, or inclination to do their utmost. Some people go to traffic court with better prepared lawyers than many murder defendants get. 90. A 2011 study of Pennsylvania's death penalty cases found similar problems. Lawyers often spend little time preparing their cases and put on only the barest defense. They neglect basic steps, such as interviewing defendants, seeking out witnesses, and investigating a defendant's background. It found that court-appointed lawyers for death penalty cases get $2,000 for trial preparation and $400 a day in court to handle cases that a veteran defense attorney said required a minimum outlay of $35,000 to $40,000. 91. The upper-class campus drug dealers studied in dorm room dealers had substantially better attorneys than most people facing the death penalty. While authorities generally turned a collective blind eye to brazen illegality, a few dealers did end up in the criminal justice system. 92 One dealer was caught with over 100 marijuana plants and $30,000 in growing equipment, but his parents hired a high-profile private defense attorney and horticultural and biological sciences experts, plus various psychiatrists. He ended up with an 18-month diversion program that resulted in no jail time. And all records were expunged when he successfully completed the program, so someone running a criminal history check would find nothing about this incident. 93. Needless to say, the distinct legal advantages that money can buy become even more salient when we enter the realm of corporate and other white-collar crime. Indeed, it is often precisely the time and cost involved in bringing to court a large corporation with its army of legal eagles that is offered as an excuse for the less formal and more genteel treatment accorded to businessman crooks. This excuse is, of course, not equitably distributed to all economic classes, any more than quality legal services. This means that, regardless of actual innocence or guilt, one's chances of beating the rap increase as one's income increases. Sentencing. In 1990, the House Subcommittee on Financial Institutions Supervision, Regulation, and Insurance met to hold hearings on the prosecution of savings and loan, S&L, criminals. The chairman of the subcommittee called the meeting to order and said, "The American people are furious with the slow pace of prosecutions involving savings and loan criminals. These crooks are responsible for 1/3, 1/2, or maybe even more, of the savings and loan cost. The American taxpayer will be forced to pay $500 billion or more over the next 40 years, largely because of these crooks. For many Americans, this bill will not be paid until their grandchildren are old enough to retire. We are here to get an answer to one question: when are the S&L crooks going to jail?" The answer from the administration seems to be, probably never. Frankly, I don't think the administration has the interest in pursuing Gucci-clad, white-collar criminals. 139. These are hard and complicated cases, and the defendants often were rich, successful prominent members of their upper-class communities. It is far easier putting away a sneaker-clad high school dropout who tries to rob a bank of $1,000 with a stick-up note, than a smooth-talking S&L executive who steals $1 million with a fraudulent note. 94. Later in the hearing, the chairman questioned the administration's representative. "You cited, Mr. Dennis, several examples in your testimony of successful convictions with stiff sentences. But the average sentence so far is actually about 2 years, compared to an average sentence of about 9 years. For bank robbery. Why do we throw the book at people who rob a bank in broad daylight but we coddle people who rob the bank secretly?" 95. 12 years later, in 2002, at a hearing of the Crime and Drugs Subcommittee of the Senate Judiciary Committee on the subject of penalties for white-collar crimes, "Are we really getting tough on crime?" Then Senator Joseph Biden Jr. said, "Under federal law, if you steal a car out of my driveway and you drive it across the state line into Pennsylvania, 10 years. 10 years, federal guideline. You take a pension by violating ERISA, the federal system to safeguard pensions, misdemeanor, maximum 1 year. The pension may be worth $1,800,000. My car may be worth $2,000. 96. The simple fact is that the criminal justice system reserves its harshest penalties for its lower-class clients, and puts on kid gloves when confronted with a better class of crook. We will come back to the soft treatment of the S&L crooks shortly. For the moment, note that the tendency to treat higher-class criminals more leniently than lower-class criminals has been with us for a long time. In 1972, the New York Times did a study on sentencing in state and federal courts. The Times stated that crimes that tend to be committed by the poor get tougher sentences than those committed by the well-to-do, that federal defendants who could not afford private counsel were sentenced nearly twice as severely as defendants with private counsel, and that a study by the Vera Institute of Justice indicates a similar pattern. In the state courts. 97. The juvenile justice system also has a long history of deciding to remove youth from their families and incarcerate them because of concentrated disadvantages in their neighborhoods. Research in the 1980s found that families faced with economic strain were perceived as unstable or inadequate, a pattern that continues to the present, where the economic struggles of these families often translated into negative attributions of parents, mostly mothers, and provided a basis for the removal of youth from the community. 98. Little effort has gone into fixing disadvantaged neighborhoods, so attributions based on socioeconomic status provided the basis for removal of youth from their homes and neighborhoods, and as a result, young people were treated more severely merely because they face economic strain. 99. Research on adult offenders consistently finds economic discrimination. D'Alessio and Stolzenberg's study of a random sample of 2,760 Florida offenders found that poor offenders received longer sentences for violent crimes, such as manslaughter, and for morals offenses, such as narcotics possession. 100. A study of individuals convicted of drunk driving found that increased education, an indicator of higher economic status. 140. Increase the rate of movement from case filing to probation and decrease the rate of movement to prison. 101. Chiricos and Bales found that, for individuals guilty of similar offenses and with similar prior records, unemployed defendants were more than twice as likely as their employed counterparts to be incarcerated if found guilty. 102. McCarthy noted a similar link between unemployment and greater likelihood of incarceration. 103. In his study of 28,315 Southern felony defendants, Champion also found that offenders who could afford private counsel had a greater likelihood of probation and received shorter sentences when incarceration was imposed. 104. A study of the effects of implementing Minnesota's determinate sentencing program shows that socioeconomic bias is more subtle, but no less real than before the new program. 105. Tillman and Pontel examined the sentences received by individuals convicted of Medicaid provider fraud in California. Because such offenders normally have no prior arrests and are charged with grand theft, their sentences were compared with the sentences of other offenders convicted of grand theft who also had no prior records. While 37.7% of the Medicaid defrauders were sentenced to some jail or prison time, 79.2% of the others convicted of grand theft were sentenced to jail or prison. This was so even though the median dollar loss due to the Medicaid frauds was $13,000, more than 10 times the median loss due to the other grand thefts, $1,149. The authors point out that most of the Medicaid defrauders were health professionals, while most of the others convicted of grand theft had low-level jobs or were unemployed. They conclude that differences in the sentences imposed on the two samples are indeed the result of the different social statuses of their members. 106. Data on racial discrimination in sentencing tell the same story of the treatment of those who cannot afford the going price of justice. A study of 9,690 males who entered Florida prisons in 1992 and 1993, and who were legally eligible for stricter sentencing under the habitual offender statute, shows that for similar prior records and seriousness of crime, race had a significant and substantial effect. Black defendants were particularly disadvantaged for drug offenses and for property crimes. 107. Based on a total of 40 recent studies Of both federal and state data, Spahn concludes that Black and Hispanic offenders, particularly those who are young, male, or unemployed, are more likely than their white counterparts to be sentenced to prison. They also may receive longer sentences than similarly situated white offenders. 108 The National Academy of Sciences Panel on Incarceration finds that the racial disparities are enormous, not only with incarceration but also capital punishment and life sentences. 109. Here mention must be made of the notorious 100-to-1 disparity between sentences for possession of cocaine in powder form, popular in the affluent suburbs, and in crack form, popular in poor, inner-city neighborhoods. From 1986 until 2010, federal laws required a mandatory 5-year sentence for crimes involving 500 grams, about a pound, of powder cocaine or 5 grams, about 1/6 of an ounce, of crack cocaine. This yields a sentence for first-time crack offenders with no aggravating factors, such as possession of a weapon, that is longer than the sentence for kidnapping and only slightly shorter than the sentence for attempted murder. 110 About 82% of those convicted of federal crack offenses are Black, about 8% are white. 111 In 1995, 1997, and 2002, the U.S. Sentencing Commission recommended ending the 100-to-1 disparity between powder and crack penalties, and in an unusual display of bipartisanship, Congress rejected their recommendation and kept the law. 112 In his 2007 testimony to Congress, the chair of the 141 Sentencing Commission stated, "The Commission believes that there is no justification for the current statutory penalty scheme and reiterated its recommendation that any ratio be no more than 20-to-1. The Fair Sentencing Act of 2010 reduced the 100:1 disparity to 18:1. Says sociologist Nikki Jones, "What the act suggests is that it's better for our criminal justice system to be somewhat racist rather than very racist." 113. The federal government has introduced sentencing guidelines and mandatory minimum sentences that might be expected to eliminate discrimination, and many states have followed suit. The effect of this, however, has been not to eliminate discretion but to transfer it from those who sentence to those who decide what to charge, that is, from judges to prosecutors. Says U.S. District Judge J. Lawrence Irving of San Diego. The system is run by the U.S. attorneys. When they decide how to indict, they fix the sentence. 114 While judges need to justify their sentencing decisions, there is no review of discretion, transparency, or public accountability for prosecutors, so discrimination persists. Barbara Meyer-Hoefer studied 267,178 offenders sentenced in federal courts. She found that both Black and Hispanic offenders now receive notably more severe sentences than their white counterparts. 115. Although many mandatory sentences are still in place, the Supreme Court has ruled that the sentencing guidelines are only advisory. It remains to be seen how much discretion this will actually return to judges and how that discretion will be exercised. But during the time when guidelines were imposed and then made advisory, the National Academy of Sciences panel on incarceration noted that racial disparities in imprisonment have worsened substantially since the early 1990s relative to racial patterns of involvement in serious crime. 116. There is also considerable evidence that double discrimination by race of victim and offender affects death penalty sentencing. In Florida, for example, Blacks who kill whites are nearly 40 times more likely to be sentenced to death than those who kill Blacks. Moreover, among killers of whites, Blacks are 5 times more likely than whites to be sentenced to death. This pattern of double discrimination was also evidenced though less pronouncedly, in the other states surveyed, which account for the vast majority of American death sentences. 117 On the basis of such research, what may have been the last major constitutional challenge to the death penalty in our era was raised and rejected. In the 1987 case of McCleskey v. Kemp, evidence of discrimination on the basis of the victim's race was provided by Professor David Baldus, who examined 2,484 Georgia homicide cases that occurred between 1973, when the current capital murder law was enacted, and 1979, a year after McCleskey received his death sentence. 118 After controlling for non-racial factors such as severity of crime and the presence of aggravating factors, Baldus found that murderers of white victims are still being sentenced to death 4.3 times more often than murderers of black victims. 119 The justices of the Supreme Court acknowledged the systemic disparities, but a majority held that the disparities would not invalidate death penalty convictions unless discrimination could be shown in the individual case at hand. These disparities persist. A 2003 study by criminologists at the University of Maryland looked at some 6,000 homicides in the state of Maryland and concluded the following. Black offenders who kill whites are twice as likely to get a death sentence as whites who kill whites. Black offenders who kill whites are 4 times as likely to get a death sentence as blacks who kill blacks. 120. 142. Note that all these discriminatory sentences were rendered under statutes that had passed constitutional muster and were, therefore, presumed free of the arbitrariness that led the Supreme Court to invalidate all American death penalty statutes in Furman v. Georgia in 1972. Another study has shown that whites on death row were more likely to have their sentences commuted than blacks. Also, blacks or whites who have private counsel are more likely to have their executions commuted than condemned persons defended by court-appointed attorneys. 121 A study appearing in the American Bar Association's Criminal Justice magazine examined 107 cases of people on death row who were wrongfully convicted. Of these exonerated inmates, 45% were black and another 13% were other minorities. In short, 58% of wrongful convictions were of minority defendants. 122. As this chapter has already pointed out, justice is increasingly tempered with mercy as we deal with a better class of crime. The Sherman Antitrust Act is a criminal law. It recognizes that a free market economy depends on real competition by businesses to drive consumer prices down, so agreements by competing firms to refrain from price competition is the equivalent of stealing money from consumers' pockets. Although such conspiracies cost consumers far more than lower-class theft, price fixing was a misdemeanor until 1974. 123 In the historic electrical equipment cases in the early 1960s, executives of several major firms met secretly to fix prices on electrical equipment to a degree that is estimated to have cost the buying public well over $1 billion. At that time, the executives involved knew they were violating the law. They used plain envelopes for their communications, called their meetings choir practice, and referred to the list of executives in attendance as the Christmas card list. This case is rare and famous because it was an early example in which the criminal sanction was actually imposed. 7 executives received and served jail sentences. In light of the amount of money they had stolen from the American public, however, their sentences were more an indictment of the government than of the executives, 30 days in jail. Since then, progress in making sentences reflect the degree of harm done by white-collar crimes has followed a zigzagging course. 124 In 2013, the global financial institution HSBC was caught helping Mexican Drug traffickers, rogue regimes, and terrorist organizations launder money. Additionally, the Senate Subcommittee on Investigations found that HSBC actively worked to get around the rules regarding the provision of banking services for the Iranian government or its citizens to enable 25,000 transactions worth about $19 billion, though without disclosing that the money came from that country, a violation of the Trading with the Enemy Act. The subcommittee also found a failure to monitor for money laundering $60 trillion in wire transfer and account activity, and a backlog of 17,000 unreviewed account alerts regarding suspicious activity. 125 HSBC deliberately understaffed compliance and anti-money laundering positions so they could save in costs while profiting from the financial services they offered to big-time global criminals. In 2013, they received a fine of $1.9 billion, compared with 2011 profits of $22 billion. Under the DPA, the government agreed to drop all criminal charges if certain organizational reforms were made over the next 5 years, so it's likely that no one at HSBC will go to jail for profiting from and helping out drug traffickers, organized crime syndicates, and terrorist organizations. 126. Further, white-collar offenders find ways to manipulate programs in the federal system that reduce their sentences, according to an article in Forbes titled "How Corporate Crooks Cut Their Jail Time." It notes that offenders who participate in the residential drug abuse program are eligible for up to a year off their 143 sentences, and it's funny how many suddenly discover they have substance abuse problems. Enron executives actually joked from the witness stand about getting early release for a rehab stint despite being only a social drinker. 127. Even after the heightened public awareness of white-collar crime that came in the wake of Watergate and the SNL scandals, it remains the case that the crimes of the poor lead to stiffer sentences than the crimes of the well-to-do. See Table 3.1. Keep in mind while looking at the figures in Table 3.1 that each of the crimes of the affluent costs the public more than all of the crimes of the poor put together. Financial frauds. In this section, we present several examples of major financial fraud that can serve as case studies for the economic bias that the previous sections reviewed. During the 1980s, the savings and loan scandal occurred, costing taxpayers $500 billion. The major portion of this amount was attributed to fraud at financial institutions. In December 2001, Enron filed the largest corporate bankruptcy in U.S. history to that point. This was followed by revelations of significant fraud in a large number of companies, costing shareholders hundreds of billions of dollars in losses. Then in 2008 the financial meltdown was so severe that President George W. Bush announced that our entire economy is in danger, 128, and urged Congress to quickly pass a $700 billion bailout on top of trillions of dollars committed by the Federal Reserve. A final accounting is still in the works, but ordinary people will directly and indirectly pay a substantial Wall Street incompetence tax. 129. These financial meltdowns were not natural disasters, they were caused by human beings who were responsible for the harms that resulted from their actions. All of these episodes involved control fraud, which is where executives abuse their positions of trust by working together to override financial controls and allow collective embezzlement. Rather than run the business for longer-term growth, they loot it by using fraud to take wealth from and through the institution. Firms victimized by control fraud typically report sensational profits, followed by catastrophic failure and bankruptcy. 130. In each of the cases below, control fraud was responsible for massive financial losses and damage to the wider economy. In each case, offenders generally received minor, if any, criminal punishments for causing mass financial victimization. By briefly presenting each episode, we show how changes in laws and limitations in policing and adjudication led to minimal criminalization for white-collar crime in a nation that otherwise 144 leads the world in imprisonment. The Savings and Loan Scandal. The Federally Insured System of Savings and Loan Banks, SNLS, also known as thrifts, was created in the 1930s to promote the building and sale of new homes during the Great Depression. The system had built into it important restrictions on the kinds of loans that could be made and was subject to federal supervision to prevent the bank failures that came in the wake of the Depression of 1929. Starting in the 1970s and speeding up in the early 1980s, this entire system of regulation and supervision was first loosened and then essentially dismantled. Although SNLS could now make riskier investments, their deposits were still insured by the Federal Savings and Loan Insurance Corporation. FSLIC. Translation: the SNLS could make risky investments shooting for windfall profits, with the taxpayers paying for losses. This combination proved to be financial dynamite. The thrifts made high-risk investments and then made fraudulent loans to their friends, family, and business partners that left everybody substantially richer. In 1996, a government accounting office report put the total cost to the American taxpayer of the SNL bailout at $480.9 billion. 131. Not all these losses are due to crime, but fraud was a central factor in 70 to 80% of the SNL failures. 132. Much of this fraud took the form of looting bank funds for the personal gain of bank officers at the expense of the institution. The commissioner of the California Department of Savings and Loans is quoted as saying in 1987, "The best way to rob a bank is to own one." 133. Says Fortune magazine, S&L fraud dwarfs every previous carnival of white-collar crime in America. 134. In response to the enormity of this scandal, American public opinion hardened toward white-collar crime. And federal law enforcement agencies were prosecuting, fining, and even jailing offenders at unprecedented rates. Nonetheless, considering the size of the scandal and the far-reaching damage it did to the American economy and public trust in the banking system, the treatment was still light-handed compared with that of even nonviolent common crimes. According to one study, the average prison term for savings and loan offenders sentenced between 1988 and 1992 was 36 months, compared to 56 months for burglars and 38 months for those convicted of motor vehicle theft. The study goes on to point out that SNL offenders were given lengthier sentences than first-time property crime offenders, who received an average sentence of 26 months, but the average loss in an SNL case was $500,000 135 and the average loss per property offense in 1995 was $1,251. 136. David Friedrichs notes that the fines imposed were less than the total amount stolen. 137. These sentenced SNL offenders represent just a small fraction of the crooks involved in the SNL looting. From 1987 to 1992, federal bank and thrift regulators filed a staggering 95,045 criminal referrals with the FBI. The volume was so large that more than 75% of these referrals have been dropped without prosecution. 138. At the same time, the Justice Department advised against funding for 425 new agents requested by the FBI and 231 new assistant U.S. attorneys, and the administration recommended against increasing funds from $50 million to $75 million as authorized by Congress for the SNL investigations. 139. But, soon after, we find the President and the Congress ready to spend $23 billion on criminal justice and hire thousands of new police officers to keep our streets safe. To give you a concrete idea of what some of the SNL crooks did and the treatment they received, Table 3.2 presents a roughly representative rogues gallery. In looking at these rogues, their acts, and their 145 punishments, keep in mind the treatment meted out to the typical criminal when he steals a fraction of what they did. Also, soon after the SNL crisis, Congress went on what the authors of Big Money Crime describe as a wave of cavalier financial deregulation, creating a paradox of increasing financial deregulation coming on the heels of the most catastrophic experiment with deregulation in history 140, up to that point in time. Table 3.2 The Savings and Loan Roster. Michael Hell Ehrman, aka Michael Rapp, defrauded Flushing Federal SNL, New York, of $8.4 million, and Florida Center Bank of $7.5 million. Received 15 years and a fine of $100,000. Released on parole after serving 5.5 years. Charles Bozerian, convicted for swindling $20 million from 2 California SNLs and skimming at least $100,000 from a low-income HUD project. Also convicted with Rapp in Florida case. Served less than 2 years for cooperating with authorities. And has paid $18,000 of $110,000 in fines. Mario Renda as partner in a brokerage business, he stole about $16 million. Served 21 months after pleading guilty to 2 counts of wire fraud, paid a minimal amount of the ordered $9.9 million in restitution and $125,000 in criminal fines. Herman Beebe, involved in widespread loan fraud involving more than $30 million. Served 10 months under plea bargain and is immune from prosecution for other fraud charges. Arthur Kick, president of North Chicago Federal SNL, stole $1.2 million by misappropriating loans. Sentenced to 3 years of probation and full restitution. Edward Jolly Jr., assistant regional vice president and consumer loan manager. Stole $4.5 million through fictitious loan applications. Sentenced to 2 years and 9 months. Ted Musicchio, president of Columbus Marin SNL, California, stole $9.30 million and lied about it on federal disclosure forms. Sentenced to 5 years of probation and required to make immediate restitution of $9.3 million but had only paid $1,000 by the time of his death 3 years later. Source: Stephen Pizzo and Paul Muolo, Take the Money and Run, a rogues gallery of some lucky SNL thieves, The New York Times Magazine, May 9, 1993, Alan Famhan, S&L Felons, Fortune, November 5, 1990, p. 93, former Columbus president guilty of misapplying funds, American banker, December 26, 1989, and why SNL crooks have failed to pay millions of dollars in court-ordered restitution. 19 case studies, in a staff report for the Subcommittee on Financial Institutions Supervision, Regulation, and Insurance of the Committee on Banking, Finance, and Urban Affairs, House of Representatives, 102nd Congress, 2nd Session, April, Washington, D.C., U.S. Government Printing Office, 1992. Enron and a Year of Corporate Financial Scandals. In 2001, 02, corporate financial shenanigans caused corporate bankruptcies, unemployment, economic turmoil, and a significant drop in stock market prices. Although the economic losses were widespread, Fortune magazine notes, the not-so-secret dirty secret of the crash is that even as investors were losing 70%, 90%, even in some cases all of their holdings. Top officials of many of the companies that have crashed the hardest were getting immensely, extraordinarily, obscenely wealthy. 141. At center stage was Enron, a multibillion-dollar energy rights trading company, which declared one of the largest bankruptcies in history on December 2, 2001, with debts of over $31 billion. Enron was subsequently accused of having perpetrated massive accounting fraud, hiding the degree of its indebtedness from investors by treating loans as revenue and camouflaging company losses by creating special purpose vehicles 142 with company capital and then attributing losses to them rather than Enron. As Enron shares were tanking, then CEO Ken Lay was emailing concerned employees, advising them to hold their shares and buy new ones. 146. Meanwhile, he himself cashed in $103 million of his own shares in the company. Enron executives unloaded nearly $1 billion worth of stock. Employees, however, were locked out of selling the holdings in their pensions during much of the period in which the company's stock fell from $80 a share to 30 cents. Enron investors collectively lost about $60 billion, ruining many large pension plans and the retirement savings of nearly 20,000 employees. 143. Enron was not an isolated incident. The list of companies touched by financial scandal soon included Tyco, Global Crossing, Quest, WorldCom, Xerox, Adelphia, AOL, Time Warner, Kmart, and some major banks, such as Citigroup and J.P. Morgan Chase. About 1/10 of publicly traded companies announced at least one restatement, and companies that had to restate earnings in 2000 and 2001 axed anywhere from 250,000 to 600,000 jobs in 2001 and 2002. 144. The misstatements that Enron and others made were not mere technical rule violations without real victims. One important consequence of this corporate crime and financial trickery is the elimination of many people's retirement nest eggs, forcing many older people to put off retirement and many retirees to go back to work. Other families had college tuition money tied up in stocks, along with their dreams of a more comfortable and secure future. The scams perpetrated by executives and companies during 2002 were a diverse collection. Some, like those of Adelphia Communications, involved relatively straightforward looting by the founding family, which used the company as its personal bank to enrich themselves. Others, like Enron's, involved complicated financial transactions meant to inflate earnings, and thus stock prices, artificially. The SEC charged Adelphia with fraudulently excluding $2.3 billion in debt from its earnings report. AES, AOL, Time Warner, Cedent, Halliburton, Kmart, Lucent Technologies, MicroStrategy, Rite Aid, and Waste Management are all said to have, in different ways, misstated revenues by more than $100 million in each case. Arthur Andersen accountants served as auditors for Enron while taking in hundreds of millions of dollars from consulting deals with the company. This dual role of auditor and consultant created an obvious conflict of interest. Andersen auditors would surely be reluctant to question the propriety of work that Andersen consultants had been paid hundreds of millions of dollars for by Enron. Andersen is, of course, quite experienced at this sort of thing, having audited such other corporate suspects as Global Crossing, Halliburton Oil, Quest, Waste Management, and WorldCom, and, before that, Charles Keating's Lincoln Savings and Loan, which became a symbol of the nation's savings and loan crisis when it failed in 1989 at an eventual cost to taxpayers of $2.90 billion. 145. Financial service firms like J.P. Morgan Chase and Citigroup earned substantial fees for loaning money to corporations and helping them hide their level of indebtedness. A Wall Street Journal editorial called the banks Enron enablers, and Fortune added, they appear to have behaved in a guileful way and helped their corporate clients undertake unsavory practices. And they appear to have had an entire division that, among other things, helped corporations avoid taxes and manipulate their balance sheets through something called structured finance, which is a huge profit center for each bank. 146 In addition, brokerage firms came under fire because their high-profile analysts enthusiastically endorsed stocks publicly that they were disparaging. Privately, all because their firms derived fees from business with the troubled companies. 147 Merrill Lynch. Analyst Henry Blodgett privately described some stocks as a piece of shit, while recommending them. 147. Publicly to small investors. 148. A summary of the most serious examples of alleged corporate wrongdoing is provided in Table 3.3. Scoundrel Capitalism, 2005. Because of the large amount of such wrongdoing, the table focuses on the most harmful incidents and highlights the multiple dimensions of corporate misbehavior. Thus, the sentences reported here tend to be the most severe and are not necessarily representative of how the criminal justice system treats corporate criminals. The founding Rigas family used the company as their personal bank, improperly took money and loans, created sham transactions and forged financial documents to cover it up, and lied to investors about the company's overall financial condition. A Securities and Exchange Commission, SEC, official describes this as one of the most extensive financial frauds ever to take place at a public company. They found rampant self-dealing, including the use of $252 million in Adelphia funds to repay stock market losses and purchase a $12.8 million golf club, the Buffalo Sabres hockey team, $150 million, and luxury condominiums for the Rigas family. Timothy Rigas grew concerned about his father John's unacceptably large spending of company money and put him on a $1 million a month allowance. John and Timothy were convicted on 18 felony counts each. The judge sentenced Timothy, former chief financial officer, to 20 years and John, founder, to 15 years. John received a lesser sentence because of health problems, but the judge said the sentence was substantial and appropriate for the egregious conduct, so it would send a clear message to other corporate executives. Michael Rigas received 10 months of home confinement after pleading guilty to making a false entry in a company record. Arthur Andersen. Andersen audited many companies that had to restate earnings. They settled with the SEC in numerous other cases. Enron, WorldCom, $8 billion restatement, Global Crossing, Quest Communications, Baptist Foundation of Arizona, $217 million settlement. Sunbeam, $110 million settlement, and Colonial Realty, $90 million settlement. The Waste Management. Andersen officials ordered the shredding of important Enron documents under the guise of reminding employees about the company's document retention policy. To help dispose of 30 boxes of documents, Andersen called a company named Shredded, whose motto is "Your secrets are safe with us." Some 2 tons of documents were destroyed after Andersen executives acknowledged an SEC investigation into Enron's accounting practices was highly probable, but before the SEC formally started. In argument before the Supreme Court, the Deputy Solicitor General said, "It is the equivalent of sending someone to a crime scene, and wiping up the evidence before police get there with the yellow tape." Andersen also deleted large numbers of emails relating to its internal Debates on Enron's financial problems. Arthur Andersen's conviction for obstruction of justice ended the company as an accounting firm. The conviction case, $1 billion overstated earnings, led to a $229 million shareholder settlement and an SEC cease and desist order on misleading accounting was later overturned by the Supreme Court because the jury instruction about the term corruptly persuading the withholding of evidence failed to convey the requisite consciousness of wrongdoing. The court's opinion did not suggest that Andersen was innocent and noted an incident where the head of the engagement team for Enron picked up a document with the word smoking gun written on it and began to destroy it, adding, "We don't need this." 148. Enron. Described by executive Jeffrey Skilling as the world's coolest company. Enron declared the largest corporate bankruptcy in history on December 2, 2001. It restated its earnings and assets downward by $1.5 billion, wiping out 4,200 jobs and $60 billion in market value lost to shareholders. A special committee of Enron's board, the Powers Committee, concluded that partnership arrangements allowed Enron executives to hide the company's losses and liabilities, while earning tens of millions of dollars in fees for themselves. The report was based on a 3-month review without subpoena power and limited access to documents. Nevertheless, it found a systematic and pervasive attempt by Enron's management to misrepresent the company's financial condition, and that Enron employees involved in the partnerships received tens of millions of dollars they should never have received. Investigators concluded that Enron manipulated the California power crisis for financial gain, entered into transactions presenting conflicts of interest, engaged in fraudulent transactions to book revenue, and punished whistleblowers. Enron executives and directors sold $1 billion worth of shares in the 3 years before the company collapsed. Just before the bankruptcy announcement, employees were locked out of selling their shares because of administrative changes to the stock plan. A jury found Skilling guilty on 19 counts, including conspiracy, fraud, false statements, and insider trading. He was sentenced to 24 years, although he could have received more than 30 years based on sentencing guidelines. Ken Lay was convicted of 6 counts of conspiracy and fraud, plus another 4 counts of fraud and false statements at a separate trial. He died of a heart attack before his appeal was final, so his conviction was voided, and could not be used against him in civil suits to recover money from his estate. Chief Financial Officer Andrew Fastow was originally charged with 109 felonies. He pleaded guilty to 2 counts of conspiracy in exchange for a 10-year maximum sentence and his promise to cooperate and testify against his bosses. A judge sentenced him to 6 years, he was released after serving about 5 years. Global Crossing Optical Fiber Company filed the 4th largest bankruptcy ever, with $12 billion in debt. This company is chartered in Bermuda to avoid U.S. corporate taxes, even though it is headquartered and run out of the United States and enjoys all the rights and access to government contracts that U.S. corporations enjoy. Allegedly engaged in capacity swaps with Quest Communications, see next company, to improperly book revenue in order to inflate stock price. In one congressional hearing, Rep. Billy Tauzin, our law, said executives pursued sham transactions to put revenue on the books, to mislead investors, and to prevent further drops in their stock prices. Many of these transactions were done in the last few days, sometimes the last minutes, of the financial quarter to help meet earnings expectations. No criminal charges were filed against any Global Crossing executives. 3 executives agreed to pay a civil fine of $100,000 each in an SEC settlement, but they were not required to admit any wrongdoing. The SEC Enforcement Division recommended a fine against Chairman Gary Winnick, who worked out of a replica of the Oval Office, but SEC commissioners rejected the idea. The expected $1 million fine was small compared to the $730 million he made in stock sales before the company filed for bankruptcy. Qwest Communications, the dominant local telephone company in 14 states, shares dropped to $1 each, from a high of $66, losing $90 billion in value for investors. Qwest restated $2.5 billion in revenue, alleged to have improperly engaged in hollow trades and capacity swaps with Global Crossing and other telecoms to boost revenue and meet earnings expectations. The SEC charged that CEO Joseph Naccio and other executives knew of revenue shortfalls but fraudulently and materially misrepresented Qwest's performance and growth to the investing public. Rep. James Greenwood, RPA, who chaired a congressional investigating committee, said, investors in Global Crossing and Qwest lost billions of dollars when the truth came out about these companies' finances, while insiders walked away with billions of dollars. On several occasions, executives asked that the details of the swaps not be put in writing to avoid scrutiny. A memo by Chief Financial Officer, CFO, Robin Zaliga indicated Qwest would penalize anyone who questioned the company's handling of swaps and followed through by blocking business to Morgan Stanley, which publicly questioned Qwest's reliance on swaps. Naccio was convicted on 19 counts of insider trading and sentenced to 6 years in prison in what has been called the largest insider trading case in history. CFO Robin Zaliga was sentenced to 2 years probation for 1 count of insider trading in exchange for her testimony against Naccio. Qwest paid a $250 million penalty to the SEC. Tyco 149. Asterisk. This large conglomerate is chartered in Bermuda to avoid U.S. corporate taxes, even though it is headquartered and run out of the United States and enjoys all the rights and access to government contracts that U.S. corporations enjoy. Former CEO Dennis Kozlowski and former CFO Mark Swartz looted the company and shareholders of $600 million, $150 million of which was directly stolen through improper loans and unauthorized bonuses, with the rest related to bonuses based on financial misstatements and selling stock at prices artificially inflated by their financial misstatements. The two men used the money to buy houses, art, and luxury items for themselves, including Kozlowski's infamous $6,000 shower curtain and a $2 million birthday party for Kozlowski's wife on an Italian island that included an ice sculpture of Michelangelo's David with vodka pouring from his genitals. Kozlowski also allegedly improperly bought valuable paintings by Renoir and Monet worth $13.2 million, and he evaded $1.1 million in New York state sales tax. Kozlowski and Swartz were convicted of 22 counts of grand larceny, conspiracy, securities fraud, and falsifying business records. The prosecutor described it as the largest larceny ever prosecuted in New York. They were both sentenced to 8 years and 4 months to 25 years in prison, less than the maximum term of 15 to 30 years. Kozlowski settled the sales tax issue relating to the art and income tax liabilities for $21.2 million. WorldCom, now MCI telecommunications giant, announced a series of restatements totaling about $11 billion, and its $107 billion bankruptcy. displaced Enron as the largest bankruptcy filing in U.S. history. The stock price fell from $64 to 9 cents, reducing total shareholder value by $180 billion. 17,000 employees were laid off. The New York State Pension Plan lost $300 million because of WorldCom investments. The Deputy U.S. Attorney General said CFO Scott Sullivan and Controller David Myers systematically flouted rules of accounting and lied outright to investors to perpetuate the false image that WorldCom was succeeding. With business deteriorating, executives put pressure on numerous others to, in Myers's words, engage in accounting adjustments for which there was no justification or documentation and that were not in accordance with generally accepted accounting principles. WorldCom executives pressured whistleblowers to remain quiet, and Myers warned employees who had questions not to discuss their concerns with outside auditors. CEO Bernard Ebbers was removed from his position when WorldCom declared bankruptcy, but he negotiated a severance package worth $1.5 million a year for life. Ebbers received a 25-year sentence after being convicted of securities fraud, conspiracy, and false statement charges. The Court of Appeals upheld the sentence as the large-scale fraud earned it the name WorldCom. Harsh but not unreasonable, noting that the securities fraud here was not puffery or cheerleading or even a misguided effort to protect the company but were specifically intended to create a false picture of profitability. Even for professional analysts, which, in Ebbers' case, was motivated by his personal financial circumstances. Sullivan faced 25 years because he had directed subordinates to inflate revenues but received only 5 years. Because of his cooperation in convicting Ebbers. The sentencing judge described Sullivan as the day-to-day manager of the scheme at WorldCom. As part of plea bargains that included requirements of cooperation with the government, Myers received 1 year, accounting director Yates received 1 year, and director of management reporting Vinson received 5 months in jail and 5 months home detention. In an article on the origins of this crisis, the New York Times said, "Here we go again." In an eerie flashback to the savings and loan scandal a decade ago, it turns out that of the lawmakers and regulators investigating some of the causes behind the Enron Arthur Andersen scandal, Democrats and Republicans alike may need to look no further than a mirror. The 1995 Private Securities Litigation Reform Act, lobbied heavily for by Arthur Andersen, helped shield companies and their accountants from liability. 5 years later, lawmakers succeeded in forcing regulators to dilute proposed restrictions on accountants. The group includes the then current chairman of the Securities and Exchange Commission Harvey Pitt and 3 House and Senate committee chairmen now involved in the cleanup who have been among the accounting industry's largest campaign contribution recipients. 149. In 2002, the Sarbanes-Oxley Act became law and created a new board to oversee the accounting and auditing of publicly traded companies, limited the ability of accounting firms to be both auditors and consultants of the same firms, gave shareholders 5 rather than 3 years to sue companies that mislead them, and increased possible fines and jail sentences for those who violate new and existing corporate laws. Much of the law goes in the right direction. However, political compromises in Congress led to changing the standard for holding executives liable for fraud from reckless to knowing, which makes bringing such cases more difficult for prosecutors. Congress also limited disgorgement, restitution of money taken by fraud, only to those directly involved, not company officers and directors who only knew about misconduct but still profited from it. 150. 151. As soon as the ink was dry on the legislation, the Washington Post reported, members of Congress from Both parties accused the administration of undermining or narrowing the scope of provisions covering securities fraud, whistleblower protection, and punishment for shredding documents. Critics, including the bill's authors, charged that the Justice Department drew up interpretations and prosecution guidelines that contradicted the legislative intent of the reform measure. 151. Following up on Sarbanes-Oxley, the U.S. Sentencing Commission increased the recommended penalties for some white-collar crimes. However, the Justice Department promptly complained that the new guidelines do not go far enough, because the panel failed to crack down harder on lower-level offenders and failed to make it more difficult for white-collar criminals to avoid prison. 152. In March 2002, after the disclosure of Enron's bankruptcy, but before a wave of other frauds was revealed, Fortune magazine observed, "The double standard in criminal justice in this country is starker and more embedded than many realize. Bob Dylan was right, steal a little, and they put you in jail. Steal a lot, and you're likely to walk away with a lecture and a court-ordered promise not to do it again." 153. As a case in point, Enron's chief financial officer Andy Fasto was charged with 109 felony counts including conspiracy, wire fraud, securities fraud, falsifying books, obstruction of justice, money laundering, insider trading, and filing false income tax returns. He agreed to a plea bargain with a maximum of 10 years in prison and was released late in 2011 after serving 5 years. However, at the same time, Leandro Andrade received a sentence of 50 years for 2 counts of stealing videocassettes from Kmart, a sentence upheld by the Supreme Court as not an unreasonable application of a 3 strikes law. 154. A poor guy who steals less than $200 worth of goods to support his drug addiction ends up in jail for life, and a rich guy who masterminds a scam that results in billions of dollars in losses ultimately gets a much shorter sentence, and a year off for participating in the prison substance abuse program because of his dependence on anti-anxiety medication. 155. Some of the sentences handed down to corporate executives who went to trial have been harsher than what Fasto received, and attention has focused disproportionately on a relatively small number of sentences that are in the range of 15 to 30 years. These are harsh punishments and are sometimes taken as evidence that the pendulum has swung to the point of unreasonably harsh sentences. However, such a conclusion ignores the scale of these crimes. These were not run-of-the-mill, white-collar crimes but the largest frauds in U.S. history. To that point, they were systemic and widespread crimes that undermined the public's faith in the financial system and caused extensive harm to employees, communities, and shareholders. The judge sentencing Enron's executive Jeffrey Skilling noted that he had imposed on hundreds if not thousands of people a life sentence of poverty. 156. Further, focusing on the extreme cases gives a distorted sense of the overall picture of sentencing. An article in the Federal Sentencing Reporter tracked 440 of the highest-profile cases of corporate fraud and found that the harshest sentences were reserved for those who went to trial and lost, although the largest concentration of white-collar criminals convicted at trial received 5 to 10-year sentences. Guilty pleas accounted for 57% of the cases, and only 2 of those defendants received sentences of more than 15 years, the vast majority of those who pled received sentences of fewer than 5 years. The beneficiaries of sentencing guidelines that reward cooperation. 157. So, for all the rhetoric about how tough we are on white-collar offenders, a substantial number of those 152 involved in the biggest financial scandal ended up with sentences less than 5 years, which is equivalent to what, at the time, was the mandatory sentence for possession of 5 grams of crack cocaine. Also, remember from Chapter 2 that willful violations of health and safety laws that result in a death are still punishable by 6 months in prison, half the penalty for harassing a wild burro on federal land. So there is only a limited range of crimes of the well-off on which we have genuinely gotten tougher. 158. The financial meltdown of 2008, the best 18 months of grifting this country has ever seen. Just as the final chapters of the Enron saga were being written, the United States started experiencing its worst financial crisis since the Great Depression. At its source were complex securities based on subprime mortgages, which may never be repaid because lax underwriting standards encouraged lenders to give mortgages to borrowers without resources to repay them. These subprime mortgages were in great demand by investment banks that made large profits pooling and reselling them. Credit ratings agencies like Standard & Poor's and Moody's, who are paid by the investment banks, gave the securities higher credit ratings than the borrower's underlying assets would justify. The Federal Reserve had power to regulate mortgage underwriters but failed to do so. A 6-month investigation by the Associated Press concluded that federal regulators charged with protecting consumers have thus far made a conscious decision not to act. 159. To make matters worse, in 2004, the SEC waived its leverage ratio of debt that a bank may take on versus the capital assets it holds, rules for 5 big Wall Street firms, Goldman Sachs, Lehman Brothers, Bear Stearns, Merrill Lynch, and Morgan Stanley, which allowed them to borrow larger amounts of money and take on more risk. Previously, the permitted debt-to-capital ratio was 12-1, but after the SEC's action, firms increased their leveraging to 30-1 and even 40-1, borrowing $30 and even $40 for each dollar of their assets. 160. Further, many companies were involved in buying or selling credit default swaps, which function like insurance against a company's inability to pay its debt. But unlike insurance, there is no federal or state regulation of the swaps, and thus no centralized clearinghouse to keep track of what parties have sold, how much protection they have, and whether they have the assets to cover their bets. Thus, as Wall Street firms started to run into financial trouble, no one knew which ones would have problems due to exposure to the credit default swaps. This lack of transparency caused a lack of trust that helped to freeze up the credit system because no one wanted to lend money in case the borrower turned out to be in deep financial trouble. Barry Ritholtz, CEO of a financial research firm and author of Bailout Nation, stated that a consistent element of the problem has been an abdication of responsibility from the various entities assigned to supervise and regulate our financial system. 161. He suggests that we wouldn't allow the Super Bowl to be played without referees because we know that players would give in to their worst impulses. 162. And the financial system is the same. As investigations were starting, government officials with experience investigating corporate fraud said some of the patterns they were detecting: lying to investors, shifting debt off corporate balance sheets are familiar. A former member of the Enron task force said, "The more things change, the more things stay the same." 163. That makes the story frustratingly familiar. So does the fact that while investors have lost billions, many of those who drove the financial ship of state aground raked in hundreds of millions in pay, severance, and stock sales before the collapse. The CEO of Lehman Brothers, Richard Fuld Jr., sold $490 million in stocks. 153. And had a $34 million annual salary before the 158-year-old firm filed for a record bankruptcy and shares lost 94% of their value. During the previous year, Lehman paid out $5.7 billion in bonuses. Angelo Mazzillo, CEO and founder of Countrywide Financial, cashed in over $400 million in stock before his company, which had been at the forefront of originating problematic subprime mortgages, was sued by several state attorneys general. 164. The New York Times reported that in 1995, bank regulators referred 1,837 cases to the Justice Department, but in a period encompassing the worst of the crisis, an average of only 72 cases a year have been referred for criminal prosecution. 165. Any strengthening of enforcement because of Enron has disappeared. Legal and financial experts say that a loosening of enforcement measures, cutbacks in staffing at the Securities and Exchange Commission, and a shift in resources toward terrorism at the FBI have combined to make the federal government something of a paper tiger in investigating securities crimes. 166. Although FBI officials in 2004 said that mortgage-related problems had the potential to be an epidemic, 167. The FBI devoted no resources to following up this concern. Then Attorney General Michael Mukasey repeatedly rejected calls for an equivalent of the Enron task force that was used to prosecute earlier widespread complex financial crime. 168. As a result, the former lead prosecutor of Enron's Lay and Skilling commented that U.S. attorneys staring at the subprime crisis find scant resources available to pursue sophisticated financial crimes. 169. William Black, a senior regulator who helped oversee savings and loan prosecutions, noted, "If you don't investigate, you don't find." 170. If you don't find evidence, you can't refer cases for prosecution and convict people. And that's just what happened. Further, then SEC Chairman Christopher Cox said, "We've done everything we can during the last several years in the agency to make sure people understand there's a strong market cop on the beat," but he required staff to get approval of many actions from SEC commissioners. According to former SEC Chairman Arthur Levitt Jr., this has effectively handcuffed the Inspection and Enforcement Division. 171. Further, the Commission delayed settlements while commissioners negotiated to impose smaller penalties than the companies had agreed to pay. 172. More enforcement problems came to light when Judge Jed Rakoff rejected a proposed settlement in a case in which the SEC claimed Citicorp sold investors a product it was betting would lose value and did not disclose that information, causing investors $700 million in losses. In the settlement, Citigroup did not admit guilt but agreed to pay $285 million and said it would not violate this provision of the law again. The judge noted that the penalty was pocket change to Citigroup and would have no deterrent effect or make up for investor losses. Further, the promise not to violate the law in the future was the kind of relief that Citigroup, a recidivist, knew that the SEC had not sought to enforce against any financial institution for at least the last 10 years. 173. Indeed, a New York Times investigation found that Citigroup agreed not to violate the very same anti-fraud statute in July 2010 and in May 2006. Also as far as back as March 2005 and April 2000. They found 19 companies were repeat offenders who had promised not to do it again. The cases against executives and big financial firms have been civil suits, not criminal trials. Nobel Prize winning economist Joseph Stiglitz puts these cases into the larger perspective. Yeah, we find them, and what is the big lesson? You're still sitting pretty with your several $100 million that you have left over. After paying fines that look very large by ordinary standards but look small compared to the amount that 154. You've been able to cash in. Ultimately, the fine is just a cost of doing business, and we ought to go do What we did in the SNL crisis and actually put many of these guys in prison. 174. While not all the actions that led to the financial crisis involved a crime, Stiglitz comments that a considerable amount of what was done should have been illegal if it wasn't. 175. But even under existing law, legal experts noted areas where investigation should have been targeted but was not: the extent of disclosure by executives about risk due to various mortgage products, the representations they made to investors about questionable loans that were bundled and sold, excessively optimistic estimates of the value of mortgage assets that created illusory profits for which executives received bonuses, cashing in shares based on inside information about looming problems, even misleading statements to boards and regulators about such problems. 176. Indeed, Judge Rakoff notes that the final report of the Bipartisan Financial Crisis Inquiry Commission uses variants of the word fraud no fewer than 157 times in describing what led to the crisis. 177. As the crisis progressed, rampant fraud appeared in mortgage servicing and especially in the paperwork filed with courts to certify facts necessary for a bank to foreclose on people unable to pay. To deal with the rising number of foreclosures, mortgage servicers for major financial institutions hired low-paid robo-signers who quickly signed documents to be filed with the court without checking the accuracy of any of the information. The result has been due process violations that resulted in wrongful foreclosures, including violations of additional rights granted to military personnel fighting abroad. At stake here is the protection of property rights. If the banks cannot prove they own the loans, they should not be able to claim the property, and the rule of law, that rich and poor should not be allowed to lie to the court. 178. The financial crisis did produce sweeping legislation: the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010. As with the gutting of Sarbanes-Oxley soon after it became law, Dodd-Frank co-author Congressman Barney Frank says the bill is facing a death through 1,000 cuts because of lobbying. 179. Such lobbying aims both at putting loopholes in new rules and reducing the budgets of enforcement agencies. Congress has not increased the SEC budget by enough to allow it to fulfill all the additional responsibilities required of it by Dodd-Frank. The smaller budget does not save taxpayers anything, because the SEC is funded by fees paid by the firms it regulates, so financial institutions pay less to government and have a weaker watchdog on the beat. 180. Ritholtz rightly calls this keeping the SEC defective by design. 181. Former SEC Chairman Harvey Pitt agrees, it's almost as if the commission is being set up to fail. 182. With the 2008 financial crisis, there have been no criminal prosecutions of top-level executives or major financial institutions at all. Notes Stiglitz, when you say the Pledge of Allegiance you say, with justice for all. People aren't sure that we have justice for all. Somebody is caught for a minor drug offense, they are sent to prison for a very long time. And yet, for these so-called white-collar crimes, which are not victimless, almost none of these guys, almost none of them, go to prison. 183. More generally, we have seen in this chapter, and the previous one, that the criminal justice system is triply biased against the poor. First, there is the economic bias among harmful acts as to which get labeled crimes and which are treated as regulatory matters, as we saw in Chapter 2. Second, there is economic bias among crimes that we have seen in this chapter. The crimes that poor people are likely to commit carry harsher sentences than the crimes in the suites committed by well-to-do people. Third, there is economic bias among 155 defendants convicted of the same crimes. Among such defendants, the poor receive less probation and more years of confinement than well-off defendants, assuring us once again that the vast majority of those put behind bars are from the lowest social and economic classes in the nation. On either side of the law, the rich get richer. 156. And the poor get prison. On the morning of September 9, 1971, a group of inmates forced their way through a gate at the center of the prison, fatally injured a guard and took 50 hostages. The Attica prison uprising lasted 4 days, until corrections officers and state troopers stormed the prison and killed 29 inmates and 10 hostages. 184. During those 4 days the nation saw the faces of its captives on television, the hard, black faces of young men who had grown up in urban ghettos. Theirs were the faces of crime in America. The television viewers who saw them were not surprised. These were the faces of dangerous men who should be locked up. Nor were people outraged when the state launched its murderous attack on the prison, killing many more inmates and guards than the prisoners had. Maybe they were shocked but not outraged. Neither were they outraged when two grand juries refused to indict any of the attackers, nor when the mastermind of the attack, New York Governor Nelson Rockefeller, was named Vice President of the United States 3 years after the massacre. 185. They were not outraged because the faces they saw on the TV screens fit and confirmed their beliefs about who is a deadly threat to American society, and a deadly threat must be met with deadly force. How did those men get to Attica? How did Americans get their beliefs about who is a dangerous person? These questions are interwoven. People get their notions about who is a criminal at least in part from the occasional television or newspaper picture of who is inside our prisons. The individuals they see there have been put in prison because people believe certain kinds of individuals are dangerous and should be locked up. This is not a simple process of selecting the dangerous and the criminal from among the peace-loving and the law-abiding. It is also a process of weeding out the wealthy at every stage, so that the final picture, a picture like the one of Attica that appeared on TV screens and that continues in contemporary TV crime shows, is not a true reflection of the real dangers in our society, but a distorted image, the kind reflected in a carnival mirror. We do not claim that the inmates in Attica were innocent of the crimes that sent them there. They, and most of the individuals in prisons in America, are probably guilty of the crimes for which they were sentenced. And maybe more. Rather, the point is that people who are equally or more dangerous, equally or more criminal, are not there, that the criminal justice system works systematically not to punish and confine the dangerous and the criminal, but to punish and confine the poor who are dangerous and criminal. It is successful at all levels. In 1973, there were 204,211 individuals in state and federal prisons, or 96 prisoners for every 100,000 individuals, of all ages, in the general population. By year-end 2014, there were a total of 1,561,500 persons in state and federal prisons, or 470 per 100,000 Americans. Add in the 744,600 in local jails, and the result is about 2.3 million people locked up, a staggering 690 for every 100,000 in the population. This enormous number of prisoners is predominantly from the bottom of society and, near its peak, included 1 in every 15 black men over 18 years old. 186. Of the estimated 1.2 million people in state prisons in 1998, 1/3 were not employed at all, full or part-time, prior to their arrests. Nearly half were without full-time employment prior to arrest. 187 among jail inmates in 2002, 29% were not employed prior to arrest, 15% were looking for work, and 14% had given up. Approximately 45% of jail inmates reported pre-arrest incomes below $7,200 a year. 188, the Department of Justice has not done surveys to update these figures, another case of missing. 157. Information on class and criminal justice. To get an idea of what part of society is in prison, we should compare these figures with comparable figures for the general population. Because more than 90% of inmates are adult males, we can look at employment and income figures for adult males in the general population. In 2002, prisoners were unemployed prior to arrest at a rate more than 3 times that of their counterparts in the general population. 189, about half the adult males in the general population who had any income at all were earning $29,238 or less, 190 compared to jail inmates, about half of whom earned $12,000 a year or less in the year before they were arrested. Since this figure includes only jail inmates with income, and 20% did not have income before they were arrested, we can say that 70% of inmates earned less than half the median income for American males with income. 191. Our prisoners are not a cross-section of America. They are considerably poorer and considerably less likely to have been employed than the rest of Americans. Moreover, they are also less educated, which is to say less in possession of the means to improve their sorry situations. As of 1999, 41% of U.S. prison inmates had not graduated from high school, compared to 20% of the U.S. adult population. 192 in 2002, 44% of jail inmates were not high school graduates compared to 16% of the general population. 193. The criminal justice system is sometimes thought of as a kind of sieve in which the innocent are progressively sifted out from the guilty, who end up behind bars. We have tried to show that the sieve works another way as well. It sifts the affluent out from the poor, so it is not merely the guilty who end up behind bars but the guilty poor. With this information, we have proven the hypotheses set forth in Chapter 2 in the section titled Criminal Justice as Creative Art. The criminal justice system does not simply weed the peace-loving from the dangerous, the law-abiding from the criminal. At every stage, starting with the very definitions of crime and progressing through the stages of investigation, arrest, charging, conviction, and sentencing, the system weeds out the wealthy. It refuses to define as crimes or as serious crimes the dangerous and predatory acts of the well-to-do, acts that, as we have seen, result in the loss of thousands of lives and billions of dollars. Instead, the system focuses its attention on crimes likely to be committed by members of the lower classes. Thus, it is no surprise to find that so many of the people behind bars are from the lower classes. The people we see in our jails and prisons are no doubt dangerous to society, but they are not the danger to society, not the gravest danger to society. Individuals who pose equal or greater threats to our well-being walk the streets with impunity. Chapter 1 argued that the society fails to institute policies that have a good chance of reducing crime. Chapter 2 argued that the criminal justice system works to make crime appear to be the monopoly of the poor. By restricting the label crime to the dangerous acts of the poor and rarely applying it to the dangerous acts of the well-off. Chapter 3 argued that the society does this by more actively pursuing and prosecuting the poor, rather than the well-off for the acts that are labeled crime. The joint effect of all these phenomena is to maintain a real threat of crime that the vast majority of Americans believes is a threat from the poor. The criminal justice system is a carnival mirror that throws back a distorted image of the dangers that lurk in our midst and conveys the impression that those dangers are the work of the poor. Chapter 4 suggests who benefits from this illusion and how. Summary. This chapter has mainly tried to document that, even among those acts that our criminal justice system labels as crimes, the system works to make it more likely that those who end up in jail or prison will be from the bottom of society. This works in two broad ways. For the same crime, the system is more likely to investigate and detect, arrest and charge, convict and sentence to prison, and for a longer time, a lower-class individual than a middle or upper-class individual. To support this, we reviewed a large number of studies performed over a long period of time comparing the treatment of high and low socioeconomic status offenders and of white and non-white offenders, from arrest through sentencing for the same crimes. Between crimes that are characteristically committed by poor people, street crimes, and those characteristically committed by the well-off, white-collar and corporate crimes, the system treats the former much more harshly than the latter, even when the crimes of the well-off take far more money from the public or cause far more death and injury than the crimes of the poor. To support this, we compared the sentences meted out for street crimes with the treatment of those responsible for death and destruction in the workplace, as well as those responsible for the SNL scandal, recent financial cheating at Enron and other major corporations, and the 2008 financial crisis. And remember, both of these processes only affect those acts that have been labeled crimes, which, as we saw in Chapter 2, largely excludes the harmful acts of the well-off. Taken together, these facts show why it should come as no surprise that our prisons are filled with poor people. Chapter 4. 169. To the vanquished belong the spoils. Who is winning the losing war against crime? In every case the laws are made by the ruling party in its own interest. A democracy makes democratic laws, a despot autocratic ones, and so on. By making these laws they define as just for their subjects whatever is for their own interest, and they call anyone who breaks them a wrongdoer and punish him accordingly. Thrasymachus, Plato's Republic. When plunder becomes a way of life for a group of men living together in society, they create for themselves in the course of time a legal system that authorizes it and a moral code that glorifies it. Frederick Bastiat, The Law. Chapter 4 of The Rich Get Richer examines how a failing criminal justice system that neither protects society nor achieves justice is allowed to continue. The criminal justice system actually fails in three ways. It fails, 1. To implement policies that stand a good chance of reducing crime, 2. To treat as crimes the harmful acts of the rich and powerful, and 3. To eliminate economic bias in the criminal justice system itself. This chapter argues that this happens because the current system's failure produces benefits for the wealthy in America. This is due not to a conspiracy but to historical inertia, the persistence of a criminal justice system dating from pre-industrial times, which does not recognize many of the harmful acts of the well-off. They can go on performing harmful acts without punishment, while the country remains focused on street crime and poor minority criminals. A key idea here is that the criminal justice system contributes to an ideology, a widely held set of false or misleading beliefs that justify the status quo and its inequalities. The criminal justice system does this by conveying the message that the poor are the worst threat to society and that their criminality is the result of individual failings rather than social inequities. 170. Why is the criminal justice system failing? The streams of our argument flow together at this point in a question: why is it happening? We have shown how it is no accident that the offender at the end of the road in prison is likely to be a member of the lowest social and economic groups in the country. 1. We have shown that this is not an accurate group portrait of who threatens society. It is a picture of whom the criminal justice system selects for arrest and imprisonment. From among those who threaten society, it is an image distorted by the shape of the criminal justice carnival. Mirror. This much we have seen, and now we want to know, why is the criminal justice system allowed to function in a fashion that neither protects society nor achieves justice? Why is the criminal justice system failing? Answering these questions will require looking at who benefits from this failure and who suffers from it. We will argue that the rich and powerful in the United States, those who derive the greatest advantage from the persistence of the social and economic system as it is currently organized, reap benefits from the failure of criminal justice that has been documented in this book. However, as noted in the introduction, this analysis is not a conspiracy theory. A conspiracy theory would argue that the rich and the powerful, seeing the benefits to be derived from the failure of criminal justice, consciously set out to use their wealth and power to make it fail. There are many problems with such a theory. First, it is virtually impossible to prove. A conspiracy is only successful if it is kept secret. Thus, evidence for a conspiracy would be as difficult to obtain if the conspiracy were successful. Second, conspiracy theories strain credibility precisely because the degree of secrecy they would require seems virtually impossible in a society as open and fractious as our own. If there is a ruling elite in the United States that comprises a group as small as the richest 1,000th of 1% of the population, it would still be made up of more than 3,000 people. To think that a conspiracy to make the criminal justice system fail in the way it does could be kept secret among this number of people in a country like ours is unbelievable. Third, conspiracy theories are not plausible because they do not correspond to the way most people act most of the time. Although there are plenty of conscious misstatements and manipulation by interest groups and politicians, most people most of the time seem sincerely to believe that what they are doing is right. Whether this is a tribute to human beings' creative capacities to rationalize what they do or merely a matter of their short-sightedness, it seems a fact. For all these reasons, it is not plausible that so fateful and harmful a policy as the failure of criminal justice could be intentionally maintained by the rich and powerful. Rather, we need an explanation that is compatible with believing that policy makers, on the whole, are doing what they sincerely believe is right. To understand how the Pyrrhic defeat theory explains the current shape of our failing criminal justice policy, note that this failure is really three failures that work together. First, there is the failure to implement policies that stand a good chance of reducing crime and the harm it causes. This was argued in Chapter 1. Second, there is the failure to treat as crimes the harmful acts of the rich and powerful. This is the first of the hypotheses listed on page 73 and confirmed by the evidence presented in Chapter 2. Third, there is the failure to eliminate economic bias in the criminal justice system so that the poor continue to have a substantially greater chance than better off people of being arrested, charged, convicted, and penalized for committing the acts that are treated as crimes. This corresponds to the second through fourth hypotheses listed in Chapter 2 and is confirmed by the evidence presented in Chapter 3. 171. The effect of the first failure is that there remains a large amount of crime even if crime rates dip largely. As a result of factors outside the control of the criminal justice system, such as the declining use of certain drugs and the reduction of lead in the environment. The effect of the second failure is that the acts treated as crimes are those done predominantly by the poor. The effect of the third failure is that the individuals who are arrested and convicted for crimes are predominantly poor people. The effect of the three failures working together is that we are largely unprotected against the harmful acts of the well-off, while at the same time we are confronted on the streets and in our homes with a real and large threat of crime, and in the courts and prisons with a large and visible population of poor criminals. And lest it be thought that the public does not feel threatened by crime, consider that polls shows that, though crime has generally declined since the early 1990s, 63% of Americans in 2014 believed that there was more crime than there was the year before. During more than 20 years of declining crime rates, a majority of the public has never believed that there was less crime than the year before. 2. The Pyrrhic defeat theory aims to explain the persistence of this failing criminal justice policy rather than its origins. It is not the origin of criminal justice policy and practices that is puzzling. The focus on one-on-one harm reflects the main ways in which people harmed each other in the days before large-scale industrialization, the refusal to implement policies that might reduce crime, such as legalization of drugs or amelioration of poverty, reflects a defensive and punitive response to crime that is natural and understandable, even if neither noble nor far-sighted. The existence of economic bias in the criminal justice system reflects the real economic and political inequalities that characterize the society in which that system is embedded. What is puzzling, then, is not how these policies came to be what they are but why they persist in the face of their continued failure to achieve either security or justice. The explanation we offer for this persistence is called historical inertia. The historical inertia explanation argues that current criminal justice policy persists because it fails in two ways that do not give rise to an effective demand for change. First, this failing system provides benefits for those with the power to make changes, while it imposes costs on those without such power. Second, because the criminal justice system shapes the public's conception of what is dangerous, it creates the impression that the harms it is fighting are the real threats to society. Thus, even when people see that the system is less than a roaring success, they only demand more of the same, more police and more prisons with few opportunities for rehabilitation, and so on. Consider first the benefits that the system provides for those with wealth and power. We have argued that the triple failure of criminal justice policy diverts attention from the harmful non-criminal acts of the well-off, and confronts us in our homes and on our streets with a real, substantial threat of crime, and in the courts and prisons with a large and visible population of poor criminals. This conveys a vivid image to the American people, namely, that there is a real threat to our lives and limbs, and it is a threat from the poor. This image provides benefits to the rich and powerful in America. It carries an ideological message that serves to protect their wealth and privilege. Speaking generally, the message is this: the threat to law-abiding middle America comes from below them on the economic ladder, not above them. The poor are morally defective, and thus their poverty is their own fault, not a symptom of social or economic injustice. 172. The effect of this message is to create, or reinforce, in Americans fear of, and hostility toward, the poor. It leads Americans to ignore the ways in which they are injured and robbed by the acts of the affluent, as catalogued in Chapter 2, and leads them to demand tough doses of law and order aimed mainly at the lower classes. Most important, it nudges Americans toward a conservative defense of American society with its large disparities of wealth, power, and opportunity, and nudges them away from a progressive demand for equality and a more equitable distribution of wealth and power. On the other hand, but equally important, is that those who are mainly victimized by the failure to reduce our high rates of street crime are by and large the poor themselves. The people who are hurt the most by the failure of the criminal justice system are those with the least power to change it. Households with annual income below the poverty level were victims of violent crimes at a rate nearly twice that for high-income households. Indeed, as Table 4.1 shows, rates of victimization by all categories of common crime are substantially higher for the poorest segment of the population and drop dramatically as we ascend the economic ladder. The difference in the rates of property crime victimization between rich and poor understates the difference in the harms that result. The poor are far less likely than the affluent to have insurance against theft, and because they have little to start with, what they lose to theft takes a much deeper bite out of their ability to meet their basic needs. Needless to add, the various non-criminal harms documented in Chapter 2. Occupational hazards, pollution, poverty, and so on, also fall more harshly on workers and those at the bottom of society than on those at the top. To summarize, those who suffer most from the failure to reduce street crime, and the failure to treat non-criminal harms as crimes, are not in a position to change criminal justice policy. Those who are in a position to change the policy are not seriously harmed by its failure. Indeed, they actually benefit from that. 173. Failure. Note that we have not said that criminal justice policy is created in order to achieve this distribution of benefits and burdens. Instead, the claim is that the criminal justice policy that has emerged piecemeal over time and usually with the best of intentions happens to produce this distribution of benefits and burdens, with the result that there is no inclination to change the criminal justice system among people with the power to do so. Moreover, because the criminal justice system shapes the public's conception of what is dangerous, it effectively limits the public's conception of how to protect itself through incremental changes in existing policy. Thus, though it fails, it persists. Before proceeding, it is worth noting that private prisons and elements of the larger criminal justice industrial complex make money from the system as it is, so they consciously lobby to protect and improve their profits. The National Academy of Sciences panel on incarceration noted that by the mid-1990s, the new economic interests including private prison companies, prison guards unions, and the suppliers of everything from bonds for new prison construction to taser stun guns were playing an important role in maintaining and sustaining the incarceration increase. 3 politicians who fanned public outrage to collect votes, as well as the media that dramatically expanded sensational crime coverage for advertising revenue, also played important roles in maintaining the incarceration increase. The nature of these vested interests can most clearly be seen with the private prisons that are multi-billion dollar for-profit businesses in which commercial firms are contracted to build and/or manage government prisons. Get tough policy initiatives such as mandatory minimum sentences and the 3 strikes and you're-out statutes led to the rapid and enormous increase in the U.S. prison population over the past 40 years. That growth placed strains on government budgets, strains that continue because of the financial crisis. Even as lawmakers now work to reduce the number of inmates in order to control expenditures on corrections. This has given states an incentive to hire out their prison facilities to private contractors, who claim to be able to run prisons at 10 to 20% less cost than state governments, though the National Institute of Justice found it was about 1%. For the result is 131,261 inmates in private prisons in 2014, and although that number has been declining slightly, private prison contractors are expanding their operations into various aspects of community corrections. 5. Wall Street noticed and supported this trend, and many stock analysts urged their clients to invest in the major corporations in the field, such as Corrections Corporation of America, CCA, and Wackenhut Corrections, now the Geo Group. Writes Paulette Thomas, in a Wall Street Journal article titled Making Crime Pay. The gritty work of criminal justice has become the kind of big-ticket commerce to attract the loftiest names in finance. Goldman Sachs & Co., Prudential Insurance Co. of America, Smith Barney Shearson, Inc., and Merrill Lynch & Co. Inc. are among those competing to underwrite prison construction with private tax-exempt bonds, no voter approval required. 6. Ms. Thomas likened the new development to that of the old military-industrial complex, of which President Eisenhower warned in his farewell address. Eisenhower's concern was that a large and permanent defense industry would have a negative effect on public policy. 7. The expansion of the criminal justice system, combined with the involvement of Wall Street investment banks, created a similar critical mass that can 174. Distort policy in its own interests. The American Legislative Exchange Council, an organization that lobbies state legislators and that received contributions from CCA, said proudly that lawmakers on its crime task force have been actively leading in the drive for more incarceration in the states. 8. In Punishment for Sale, Donna Selman and Paul Layton critique the growth of incarceration and note that private prisons were born from an incarceration binge that has fostered injustice and that these entities, pursuing their own economic interests rather than the public good, perpetuate policies causing injustice because they profit from them. 9. The two largest private prison firms are traded on the stock exchange and required to discuss risk factors to their business in their Securities and Exchange Commission filings. GEO Group's annual report notes, the demand for our correctional and detention facilities and services could be adversely affected by changes in existing criminal or immigration laws, crime rates in jurisdictions in which we operate, the relaxation of criminal or immigration enforcement efforts, leniency in conviction, sentencing, and the decriminalization of drugs. 10. CCA's annual report includes similar language and adds as factors that may limit growth, legislation that could lower minimum sentences for some nonviolent crimes and make more inmates eligible for early release based on good behavior. 11. In short, a multibillion-dollar industry has a powerful economic interest in maintaining existing harsh policies. Beyond private prisons, the prison industrial complex includes companies that regard the $80 billion in corrections expenditures each year not as a burden on American taxpayers but as a lucrative market. 12. There's also a larger criminal justice industrial complex, which includes the prison industrial complex, plus all those who supply goods or services to police and private security. Thus far in this book we have been pointing out how the rich get richer while the poor get prison, but the privatization movement and analysis of the criminal justice industrial complex point to how the rich get richer because the poor get prison. Our argument in the remainder of this chapter turns from considering the direct influence of big business to examining ideology. Ideology involves ideas that distort reality in ways that hide society's injustices and thus secure uncritical allegiance to the existing social order. The people who have little far outnumber those who have plenty, so the wealthy need the poor to believe that they are not being exploited or treated unfairly, and that the existing distribution of wealth is about the best that human beings can create. The criminal justice system plays a role in promoting this belief. The section titled The Poverty of Criminals and the Crime of Poverty spells out in detail the content of the ideological message broadcast by the failure of the criminal justice system. The section titled Ideology, or How to Fool Enough of the People Enough of the Time discusses the nature of ideology in general and the need for it in America. For those who doubt that our legal system could function in such questionable ways, we also present evidence on how the criminal justice system has been used in the past to protect the rich and powerful against those who would challenge their privileges or their policies. These sections, then, flesh out the historical inertia explanation of the failure of criminal justice by showing the ideological benefits that the failure yields and to whom. Ultimately, the test of the argument in this chapter is whether it provides a plausible explanation of the failure of criminal justice and draws the arguments of the previous chapters together into a coherent theory of contemporary criminal justice policy and practice. 175. 176. The poverty of criminals and the crime of poverty. Criminal justice is a very visible part of the American scene. As fact and fiction, countless images of crime and the struggle against it assail our senses daily, even hourly. In newspapers, TV, radio, blogs, and social media are numerous criminal justice stories. It is as if we live in an embattled city, besieged by the forces of crime, and bravely defended by the forces of the law, and as we go about our daily tasks, we are always conscious of the war raging not very far away. News brings us daily, and sometimes hourly, reports from the front. Between reports, we are vividly reminded of the stakes and the desperateness of the battle by fictionalized portrayals of the struggle between the enforcers of the law and the breakers of the law. There is scarcely an hour on television without some dramatization of the struggle against violent crime. According to the American Academy of Pediatrics, before the average American child leaves elementary school, researchers estimate that he or she will have witnessed more than 8,000 murders on television, and by age 18, the average child will have seen some 200,000 acts of violence on television. Although a few of these are performed by science fiction monsters, the figure still suggests that the extent of the impact of the televised portrayal of crime and the struggle against it on the imaginations of Americans is nothing short of astounding. Particularly on children, who are said to spend as much as 28 hours a week watching television. 13. If we take detective, police, and other criminal justice related programs and add to this the news accounts, the panel discussions, the movies, the novels, the video games, the comic books, and the TV cartoon shows, as well as the political speeches about crime, there can be no doubt that, as fact or fantasy, criminal justice is vividly present in the imaginations of most Americans. This is no accident. Everyone can relate to criminal justice in personal and emotional terms. Everyone has some fear of crime, and as we saw in Chapter 3, just about everyone has committed some crime. Everyone knows the primitive satisfaction of seeing justice done and the evildoers served up their just deserts. Furthermore, in reality or in fiction, criminal justice is naturally dramatic. To identify with the struggle against crime is to expand one's experience vicariously to include the danger, the suspense, the triumphs, and the meaningfulness, in a word, the drama often missing in ordinary life. Whatever the interest, Americans have a seemingly bottomless appetite for the endless repetition, in only slightly altered form, of the same theme, the struggle of the forces of law against the forces of crime. Criminal justice has a firm grip on the imaginations of Americans and is thus in a unique position to convey a message to Americans and to convey it with drama and with conviction. Let us now look at this message in detail. Our task falls naturally into two parts. There is an ideological message supportive of the status quo built into any criminal justice system by its very nature. Even if the criminal justice system were not failing, even if it were not biased against the poor, it would still by its very nature broadcast a message supportive of established institutions. This is the implicit ideology of criminal justice. Beyond this, there is an additional ideological message conveyed by the failure of the system and by its biased concentration on the poor. This is the bonus of bias. The implicit ideology of criminal justice. Any criminal justice system like ours conveys a subtle yet powerful message in support of established institutions. It does this for two interconnected reasons. First, it concentrates on individual wrongdoers. This 177 means that it diverts our attention away from our institutions, away from consideration of whether our institutions themselves are wrong or unjust or indeed criminal. Second, the criminal law is put forth as the minimum neutral ground rules for any social living. We are taught that no society can exist without rules against theft and violence, and thus the criminal law seems to be Politically neutral, the minimum requirements for any society, the minimum obligations that any individual owes his or her fellows to make social life of any decent sort possible. Because the criminal law protects the established institutions, the prevailing economic arrangements are protected by laws against theft, and so on. Attacks on those established institutions become equivalent to violations of the minimum requirements for any social life at all. In effect, the criminal law enshrines the established institutions as equivalent to the minimum requirements for any decent social existence, and it brands the individual who attacks those institutions as one who has declared war on all organized society and who must, therefore, be met with the weapons of war. Let us look more closely at this process. What is the effect of focusing on individual guilt? Not only does this divert our attention from the possible evils in our institutions, but it also puts forth half the problem of justice as if it were the whole problem. 2. Focus on individual guilt is to ask whether the individual citizen has fulfilled his or her obligations to his or her fellow citizens. It is to look away from the issue of whether the fellow citizens have fulfilled their obligations to him or her. To look only at individual responsibility is to look away from social responsibility. Writing about her stint as a story analyst for a primetime TV real crime show based on videotapes of actual police busts, Deborah Segal describes the way focus on individual criminals deflects attention away from the social context of crime, and how television reproduces this effect in millions of homes daily. By the time our 9 million viewers flip on their tubes, we've reduced 50 or 60 hours of mundane and compromising video into short, action-packed segments of tantalizing, crack-filled, dope-dealing, junkie-busting cop culture. How easily we downplay the pathos of the suspect, how cleverly we breeze past the complexities that cast doubt on the very system that has produced the criminal activity in the first place. 14. Segal's description illustrates as well how a television program that shows nothing but videos of actual events can distort reality by selecting and recombining pieces of real events. A study of 69 TV crime dramas finds that fictional presentations of homicide focus on individual motivations and ignore social conditions. Television crime dramas portray these events as specific psychological episodes in the characters' lives, and little, if any, effort is made to connect them to basic social institutions or the nature of society within which they occur. 15. Criminology, 2, focuses on why individuals break the law, and the study of neighborhoods, cities, and larger regions is the road not taken. 16. To look only at individual criminality is to close one's eyes to social injustice and to close one's ears to the question of whether our social institutions have exploited or violated the individual. Criminologists James Unnever and Sean Gabaldon, in their important book A Theory of African American Offending, link black criminality with a long history of public dishonor and ritualized humiliation, including by the criminal justice system due to racism. 17. As a result, African Americans are less likely to have respect for the law and weaker bonds with conventional institutions. Focusing only on individual responsibility obscures the 178th contribution of racism to African American criminality. Justice is a two-way street, but criminal justice is a one-way street. Individuals owe obligations to their fellow citizens because their fellow citizens owe obligations to them. Criminal justice focuses on the first and looks away from the second. Thus, by focusing on individual responsibility for crime, the criminal justice system effectively acquits the existing social order of any charge of injustice. This is an extremely important bit of ideological alchemy. It stems from the fact that the same act can be criminal or not, unjust or just, depending on the circumstances in which it takes place. Killing someone is ordinarily a crime, but if it is in self-defense or to stop a deadly crime, it is not. Taking property by force is usually a crime, but if the taking is retrieving what has been stolen, then no crime has been committed. Robin Hood's thefts from the rich to give to the poor are seen as heroic and just, even though the legal system run by the rich declared him a criminal. Further, acts of violence are ordinarily crimes, but if the violence is provoked by the threat of violence or by oppressive conditions, then, like the Boston Tea Party, 18 what might ordinarily be called criminal, even terrorist, is celebrated as just. This means that when we call an act a crime, we are also making an implicit judgment about the conditions in response to which it takes place. When we call an act a crime, we are saying that the conditions in which it occurs are not themselves criminal or deadly or oppressive or so unjust as to make an extreme response reasonable or justified or non-criminal. This means that when the system holds an individual responsible for a crime, it implicitly conveys the message that the social conditions in which the crime occurred are not responsible for the crime, that they are not so unjust as to make a violent response to them excusable. Judges are prone to hold that an individual's responsibility for a violent crime is diminished if it was provoked by something that might lead a reasonable person to respond violently, and that criminal responsibility is eliminated if the act was in response to conditions so intolerable that any reasonable person would have been likely to respond in the same way. In this vein, the law acquits those who kill or injure in self-defense and treats leniently those who commit a crime when confronted with extreme provocation. The law even occasionally treats understandingly the man who kills his wife's lover and the woman who kills her brutal husband, even when she has not acted directly in self-defense. By this same logic, when we hold an individual completely responsible for a crime, we are saying that the conditions in which it occurred are such that a reasonable person should find them tolerable. In other words, by focusing on individual responsibility for crimes, the criminal justice system broadcasts the message that the social order itself is reasonable and not intolerably unjust, due to inequality of opportunity, racism, or other forms of discrimination, or the widespread poverty that our rich nation tolerates. Thus, the criminal justice system focuses moral condemnation on individuals and deflects it away from the social order that may have either violated the individual's rights or dignity or pushed him or her to the brink of the crime. This sends the message that the justice of our institutions is obvious, not to be doubted. The second way in which a criminal justice system always conveys an implicit ideology arises from the presumption that the criminal law is nothing but the politically neutral minimum requirements of any decent social life. As already suggested, this presumption transforms the prevailing social order into justice incarnate, and all violations of the prevailing order into injustice incarnate. This process is so obvious that it may be easily missed. Consider, for example, the law against theft. It does seem to be one of the minimum requirements of social living. As long as there is scarcity, any society, capitalist or socialist, will need rules to 179. Deter individuals from taking what does not belong to them, but the law against theft is a law against stealing what individuals presently own. Such a law has the effect of making the present distribution of property part of the criminal law. Because stealing is a violation of the law, this means that the present distribution of property becomes the implicit standard of justice against which criminal deviations are measured. Because criminal law is thought of as the minimum requirements of any social life, the result is that the present distribution of property is treated as the equivalent of the minimum requirements of any social life. The criminal who would alter the present distribution of property becomes someone who is declaring war on all organized society. The question of whether this war is provoked by the injustice or brutality of the society is swept aside. Indeed, This suggests yet another way in which the criminal justice system conveys an ideological message in support of the established society. By blaming the individual for a crime, the society is acquitted of the charge of complicity in that crime. This is a point worth developing because many observers have maintained that modern competitive societies, such as our own, have structural features that tend to generate crime. Thus, holding the individual responsible for his or her crime serves the function of taking the rest of society off the hook for their role in sustaining and benefiting from social arrangements that produce crime. Let us take a brief detour to look more closely at this process. Cloward and Olin argued in their book, Delinquency and Opportunity, 19 that many crimes are the result of the discrepancy between social goals and the legitimate opportunities available for achieving them. The same point is basic to strain theory, including variations like Messner and Rosenfeld's crime and the American dream. 20 Simply put, in our society everyone is encouraged to be a success, usually defined in terms of possessing wealth, but the legitimate avenues to success are open only to some. The conventional wisdom of our free enterprise democracy is that anyone can be a success if he or she has the talent and the ambition. Thus, if one is not a success, it is because of one's own shortcomings, laziness, lack of ability, or both. On the other hand, opportunities to achieve success are not equally open to all. Access to the best schools and the best jobs is effectively closed to all but a few of the poor and becomes more available only as one goes up the economic ladder. The result is that many are called, but few are chosen. Many who have accepted the belief in the importance of success and the belief that achieving success is a result of individual ability must cope with feelings of frustration and failure that result when they find the avenues to success closed. Cloward and Olin argue that one method of coping with these stresses is to develop alternative avenues to success. Crime is such an alternative avenue. Crime is a means by which people who believe in the American dream pursue it when they find the traditional routes barred. It is plain to see that the goals pursued by most criminals are as American as apple pie. One of the reasons that American moviegoers enjoy gangster films, movies in which outlaws like Al Capone, Bonnie and Clyde, or Butch Cassidy and the Sundance Kid 21 are the heroes, as distinct from police and detective films, whose heroes are defenders of the law, is that even when we deplore the hero's methods, we identify with his or her notion of success because it is ours as well, and we admire the courage and cunning displayed in achieving that success. It is important to note that the discrepancy between success goals and legitimate opportunities in America is not an aberration. It is a structural feature of modern, competitive, industrialized society, a feature from 180, which many benefits flow. Cloward and Olin write that a crucial problem in the industrial world is to locate and train the most talented persons in every generation, irrespective of the vicissitudes of birth, to occupy technical work roles. Since we cannot know in advance who can best fulfill the requirements of the various occupational roles, the matter is presumably settled through the process of competition. But how can men throughout the social order be motivated to participate in this competition? One of the ways in which the industrial society attempts to solve this problem is by defining success goals as potentially accessible to all, regardless of race, creed, or socio-economic position. 22. Because these universal goals encourage a competition to select the best, there are necessarily fewer openings than seekers. Because those who achieve success are in a particularly good position to exploit their success to make access for their own children easier, the competition is rigged to work in favor of the middle and upper classes. As a result, many lower-class persons are the victims of a contradiction between the goals toward which they have been led to orient themselves and socially structured means of striving for these Goals. 23. The poor experience a desperation made all the more poignant by their exposure to a cultural ideology in which failure to orient oneself upward is a moral defect. 24. The outcome is predictable. Under these conditions, there is an acute pressure to depart from institutional norms and to adopt illegitimate alternatives. 25. This means that the very way in which our society is structured to draw out the talents and energies that go into producing our high standard of living has a costly side effect. It produces crime. By holding individuals responsible for this crime, those who enjoy that high standard of living can have their cake and eat it too. They can reap the benefits of the competition for success and escape the responsibility of paying for the costs of the competition. William Bonger, the Dutch Marxist criminologist, maintained that competitive capitalism produces egotistic motives and undermines compassion for the misfortunes of others and thus makes human beings literally more capable of crime, more capable of preying on their fellows without moral inhibition or remorse than earlier cultures that emphasized cooperation rather than competition. 26. Here again, the criminal justice system relieves those who benefit from the American economic system of the costs of that system. By holding criminals morally and individually responsible for their crimes, we can forget that the motives that lead to crime, the drive for success, linked with the beliefs that success means outdoing others and that violence is an acceptable way of achieving one's goals, are the same motives that powered the drive across the American continent and that continue to fuel the engine of America's prosperity. Appendix I presents the Marxian critique of criminal justice and spells out the Marxian understanding of the motives and moral status of criminals. Political economist David Gordon maintains that nearly all crimes in capitalist societies represent perfectly rational responses to the structure of institutions upon which capitalist societies are based. 27. Like Bonger, Gordon believes that capitalism tends to provoke crime in all economic strata. This is so because most crime is motivated by a desire for property or money and is an understandable way of coping with the pressures of inequality, competition, and insecurity, all of which are essential ingredients of capitalism. In Capitalism 181, Gordon writes, individuals must fend for themselves, finding the best available opportunities to provide for themselves and their families. Driven by the fear of economic insecurity and by a competitive desire to gain some of the goods unequally distributed throughout the society, many individuals will eventually become criminals. 28. To the extent that a society makes crime a reasonable alternative for a large number of its members from all classes, that society is itself not very reasonably or humanely organized and bears some degree of responsibility for the crime it encourages. Because the criminal law is put forth as the minimum requirements that can be expected of any reasonable person, its enforcement amounts to a denial of the real nature of the social order to which Gordon and the others point. Here again, by blaming the individual criminal, the criminal justice system serves implicitly but dramatically to acquit the society of its criminality. The bonus of bias. We now consider the additional ideological bonus derived from the criminal justice system's bias against the poor. This bonus is a product of the association of crime and poverty in the popular mind. This association, the merging of the criminal classes and the lower classes into the dangerous classes, was not invented in America. The word villain is derived from the Latin villainus, which means a farm servant. 29. In this respect, our present criminal justice system is heir to a long tradition of associating crime with the lower classes. The value of this association was already seen when we explored the average citizen's concept of the typical criminal and the typical crime. It is quite obvious that throughout the great mass of Middle America, far more fear and hostility are directed toward the predatory acts of the poor than toward the predatory acts of the rich. Compare the fate of politicians in recent history who call for tax reform, income redistribution, prosecution of corporate crime, and any sort of regulation of business that would make it better serve American social goals with that of politicians who erect their platform on a call for smarter and tougher criminal justice system along with deregulation, less policing, of business, and consider this in light the real dangers posed by corporate crime and business as usual. It seems clear that Americans have been effectively deceived as to what are the greatest dangers to their lives, limbs, and possessions. That Americans continue to tolerate the comparatively gentle treatment meted out to white-collar criminals, corporate price fixers, industrial polluters, and political influence peddlers 30. While voting in droves to lock up more poor people faster and for longer sentences indicates the degree to which they harbor illusions as to who most threatens them. The vivid portrayal of the poor and, of course, blacks as hovering birds of prey waiting for the opportunity to snatch away the workers' meager gains serves also to deflect opposition away from the upper classes. A politician who promises, through racially coded language, to keep working class communities free of blacks and the prisons full of them can get votes even if these policies amounts to continuation of the favored treatment of the rich at that community's expense. 31. The most important bonus derived from the identification of crime and poverty is that it paints the picture that the threat to decent middle Americans comes from those below them on the economic ladder, not from those above. For this to happen, the system must not only identify crime and poverty but also fail enough in the fight to reduce crime so that crime remains a real threat. Doing this deflects the fear and discontent of middle Americans away from the wealthy. 182. There are other bonuses as well. For instance, if the criminal justice system sends out a message that bestows legitimacy on the present distribution of property, its dramatic impact is greatly enhanced if the violator of the present arrangements is without property. The crimes of the well-to-do redistribute property among the haves. They do not pose a symbolic challenge to the larger system in which some have much and many have little or nothing. If the criminal threat can be portrayed as coming from the poor, then the punishment of the poor criminal becomes a morality play which dramatically affirms the sanctity and legitimacy of the system in which some have plenty and others have little or nothing. There is yet another bonus for the powerful in America produced by the identification of crime and poverty. It might be thought that the identification of crime and poverty would produce sympathy for the criminals. But, in fact, it produces or at least reinforces the reverse, hostility toward the poor. There is little evidence that Americans are very sympathetic to poor criminals. Very few Americans believe poverty to be a cause of crime. 6% of those questioned in a 1981 survey, although 21% thought unemployment was a cause. In keeping with our general blindness to class, these questions are not even to be found in recent surveys. Other surveys find that most Americans believe that courts do not deal harshly enough with criminals, 58% of those questioned in 2014, and that the death penalty should be used for convicted murderers, most of whom are poor, 63% of those questioned in 2014. 32. Our view is that, because the criminal justice system, in fact and fiction, deals with individual legal and moral guilt, the association of crime with poverty does not mitigate the image of individual moral responsibility for crime. It does the reverse, it generates the association of poverty and individual moral failing, and thus the belief that poverty itself is a sign of poor or weak character. The clearest evidence that Americans hold this belief is to be found in the fact that attempts to aid the poor are regarded as acts of charity rather than as acts of justice. Our welfare system has all the demeaning attributes of an institution designed to give handouts to the undeserving and none of the dignity of an institution designed to make good on our responsibilities to Our fellow human beings. If we acknowledged the degree to which our economic and social institutions themselves breed poverty and maintain economic inequality, we would have to recognize our own responsibilities toward the poor. If we can convince ourselves that the poor are poor because of their own shortcomings, particularly moral shortcomings, such as incontinence and indolence, then we need acknowledge no such responsibility to the poor. Indeed, we can go further and pat ourselves on the back for our generosity in handing out the little that we do, and, of course, we can make our recipients go through all the indignities that mark them as the undeserving objects of our benevolence. By and large, this has been the way in which Americans have dealt with their poor. 33. Obviously, no ideological message could be more supportive of the present social and economic order than the association of crime and poverty. It suggests that poverty is a sign of individual failing, not a symptom of social or economic injustice. It tells us loud and clear that massive poverty in the midst of abundance is not a sign pointing toward the need for fundamental changes in our social and economic institutions. It suggests that the poor are poor because they deserve to be poor, or at least because they lack the strength of character to overcome poverty. When the poor are seen to be poor in character, then economic poverty coincides with moral poverty and the economic order coincides with the moral order. As if a divine hand guided its workings. Capitalism leads to everyone getting what he or she morally deserves. If this association takes root, then when the poor individual is found guilty of a crime, the criminal justice 183 system acquits the society of its responsibility not only for the crime but for poverty as well. With this, the ideological message of criminal justice is complete. The poor rather than the rich are seen as the enemies of the majority of decent Americans. Our social and economic institutions are held to be responsible for neither crime nor poverty and thus in need of no fundamental questioning or reform. The poor are poor because they are poor of character. The economic order and the moral order are one. To the extent that this message sinks in, the wealthy can rest easily even if they cannot sleep the sleep of the just. We can now understand why the criminal justice system is allowed to create the image of crime as the work of the poor and to fail to reduce it, so that the threat of crime remains real and credible. The result is ideological alchemy of the highest order. The poor are seen as the real threat to decent society. The ultimate sanctions of criminal justice dramatically sanctify the present social and economic order, and the poverty of criminals makes poverty itself an individual moral crime. Such are the ideological fruits of a losing war against crime whose distorted image is reflected in the criminal justice carnival mirror and widely broadcast to reach the minds and imaginations of America. 184. Ideology, or how to fool enough of the people enough of the time. What is ideology? The view that the laws of a state or nation are made to serve the interests of those with power, rather than to promote the well-being of the whole society, is not a new discovery. It is a doctrine with a pedigree even older than Christianity. Writing during the 4th century BCE, virtually at the dawn of Western thought, Plato expressed this view through the words of Thrasymachus. 34. A more contemporary and more systematic formulation of the idea is found in the works of Karl Marx, written during the 19th century, not long after the dawn of Western industrialism. Marx, and Engels, observed that the bourgeoisie, the class of owners of businesses and factories, the class of capitalists, has conquered for itself, in the modern representative state, exclusive political sway. The executive of the modern state is but a committee for managing the common affairs of the whole bourgeoisie. 35. Anyone who thinks this is a ridiculous idea ought to look at the backgrounds of our political leaders. The vast majority of the president's cabinet, the administrators of the federal regulatory agencies, and the members of the two houses of Congress come from the ranks of business or are lawyers who serve business. Many still maintain their business ties or law practices, with no sense of a conflict of interest with their political role. 36. Even those who start from humble beginnings are usually quite rich by the time they finally make it into office. If either Thrasymachus or Marx is right, there is no conflict with their political role because that role is to protect and promote the interests of business. It is clear that the most powerful criminal justice policy makers come from the have-plenties, not from the have-littles. It is no surprise that legislators and judges, those who make the laws that define criminality and those who interpret those laws, are predominantly members of the upper classes, if not at birth then surely by the time they take office. Richard Quinney compiled background data on key members of criminal justice policy making and policy advising committees and agencies, such as the President's Commission on Law Enforcement and Administration of Justice, the Federal Bureau of Investigation, and, last but not least, the U.S. Department of Justice. With few exceptions, Quinney's report reads like a who's who of the business, legal, and political elites. 37. Further, there is considerable evidence that the American criminal justice system has been used throughout its history in rather unsubtle ways to protect the interests of the powerful against those of the lower classes and political dissenters. The use of the FBI and local police forces to repress dissent by discrediting, harassing, and undermining dissident individuals and groups has been abundantly revealed. The FBI, often with active cooperation or tacit consent of local police, has engaged in literally hundreds of illegal burglaries of the offices of law-abiding left-wing political parties, 38, and in political sabotage against the Black Panthers. Example: a Catholic priest, the Reverend Frank Curran, became the target of FBI operations because he permitted the Black Panthers to use his church for serving breakfasts to ghetto children. 39. It conducted a campaign to discredit the late Martin Luther King Jr. The FBI secretly categorized King as a communist months before it ever started investigating him. 40 directors of the FBI have said that the Bureau is truly sorry for these past abuses and that they are over. Later reports indicate that abuses have continued. 41. The latest chapter is police. 185. Arresting and discharging pepper spray in the faces of nonviolent Occupy Wall Street protesters. 42. These acts of repression are part of a long tradition. The first organized uniformed police force in the English-speaking world was established in London in 1829. They came to be called Bobbies because of the role played by Sir Robert Peel in securing passage of the London Metropolitan Police Act, which established the force. The first full-time uniformed police force in the United States was set up in New York City in 1845-43. It was also in the period from the 1820s to the 1840s that the movement to build penitentiaries to house and reform criminals began in New York and Pennsylvania and spread rapidly through the states of the young nation. 44. That these are also the years that saw the beginnings of a large industrial working class in the cities of England and America is a coincidence too striking to ignore. The police were repeatedly used to break strikes and harass strikers. 45. The penitentiaries were used mainly to house the laborers and foreigners, often one and the same, whom the middle and upper classes perceived as a threat. 46. Throughout the formative years of the American labor movement, public police forces, private police like the Pinkertons, regular army troops, and the National Guard were used repeatedly to protect the interests of capital against the attempts of labor to organize in defense of its interests. The result was that the United States has had the bloodiest and most violent labor history of any industrialized nation in the world, with most of the casualties on the side of labor. 47. Marx, of course, went further. Not only are the laws of a society made to protect the interests of the most powerful economic class, but also, Marx argued, the prevailing ways of thinking about the world from economic theory to religion to conventional moral ideas about good and evil, guilt and responsibility are shaped in ways that promote the belief that the existing society is the best of all possible worlds. Marx wrote that the ideas of the ruling class are in every epoch the ruling ideas. The class which has the means of material production at its disposal, has control at the same time over the means of mental production. 48. Because those who have economic power own the newspapers, endow the universities, finance the publication of books and journals, and, in our own time, control television, radio, and other electronic media. They have a prevailing say in what is heard, thought, and believed by the millions who get their ideas there. Picture of reality from these sources. This does not mean that the controllers of the means of mental production consciously deceive or manipulate those who receive their message. What it means is that the picture of reality held by these controllers believed by them, no doubt sincerely, to be an accurate representation of reality will be largely the picture of reality that fills the heads of the readers and viewers of the mass media. The average man or woman is almost wholly occupied with the personal tasks of earning a living, piloting a family, and the like. He or she lacks the time, and usually the training, necessary to seek out and evaluate alternative sources of information. Most people are lucky when they have the time to catch a bit of news on television, in the papers, or on the internet. Moreover, except when there is division of opinion among those who control the media, the average person is so surrounded by unbroken consensus that he or she takes it simply as the way things are. Consequently, the vast majority of people will accept, as a true picture of reality, the picture held by those who control the media. This is likely to be a distorted picture, even if those who create it act with the best of intentions and sincerity. The point is that, for a wide variety of reasons, people tend to view the world in ways that make their own role in it, particularly the advantages and privileges they have in it, seem morally just. 186. Indeed, part of the best of all possible worlds. Thus, without any intention to deceive at all, without any conspiracy, those who control the content of the mass media are virtually certain to convey a picture of reality that supports the existing social order. As a result, even in a society such as ours, where freedom of expression has reached a level unparalleled in history, there is almost never any fundamental questioning of our political or economic institutions on television and radio, in the major newspapers, or the news weeklies such as Time or Newsweek. There is much criticism of individuals and of individual policies. How often, though, does one find the mass media questioning whether the free enterprise system is really the best choice for America or whether our political and legal arrangements systematically promote the domination of society by the owners of big business? These issues are rarely, if ever, raised. Instead, it is taken for granted that, though they need some reform from time to time, our economic institutions are the most productive, our political institutions the freest, and our legal institutions the most just that there can be. We are told that the interests of the powerful coincide with the common interests of us all. 49. What's good for General Motors is good for the country. This old slogan echoes eerily now as GM has teetered on the brink of bankruptcy, and the government must cope with firms that are too big to be allowed to fail. Where this picture of reality shows up some blemishes, they will always be portrayed as localized problems that can be remedied without fundamental overhaul of the entire social order, aberrations in an otherwise well functioning social system. Indeed, the very willingness to publicize these blemishes proves that there is nothing fundamentally wrong with the social system, because if the media are free, willing, and able to portray the blemishes, they would surely portray fundamental problems with the social system if there were any, and because they do not, there must not be any. When ideas, however unintentionally, distort reality in a way that justifies the prevailing distribution of power and wealth, hides society's injustices, and thus secures uncritical allegiance to the existing social order, we have what Marx called ideology. 50. Appendix I discusses in greater detail the Marxian theory of ideology and of the role of criminal justice in capitalist society. Ideology is not conscious deception. People may spout ideology because it is all they know or all they have been taught, or because they do not see beyond the conventional wisdom that surrounds them. This can be just as true of scholars who fail to see beyond the conventional assumptions of their disciplines as it is of laypersons who fail to see beyond the oversimplifications of what is commonly called common sense. Such individuals do not mouth ideology out of a willful desire to deceive and manipulate their fellows, but rather because their own view of reality is distorted by untruths and half-truths, and criminal justice is one source of such distortion. One way in which this works without conscious deception is that we have become so used to the criminal justice carnival mirror, described in Chapter 2, that we don't notice its curves. It looks flat, and thus we take it as an accurate picture of who threatens us in society. Not everyone uses the term ideology as Marx did and as we have, namely to point to what is necessarily deceptive. Some writers speak of ideology as if it meant any individual or group's belief system or value system or Weltanschauung, that is, worldview. 51. This moral neutralization of the concept of ideology is itself a good example of the work of ideology. It dulls a conceptual instrument that thinkers such as Marx and others had sharpened into an effective tool for cutting through the illusions that dog our political life. Such tools are few and hard to come by. Once we have them, they should be carefully preserved, especially when 187. Concepts such as belief system and worldview are available to perform the more neutral function. The need for ideology. A simple and persuasive argument can be made for the claim that the rich and powerful in America have an interest in conveying an ideological message to the rest of the nation. The have-nots and have-littles far outnumber the have-plenties. This means, to put it rather crudely, that the have-nots and the have-littles could have more if they decided to take it from the have-plenties. This, in turn, means that the have-plenties need the cooperation of the have-nots and the have-littles. Because the have-plenties are such a small minority that they could never force this cooperation on the have-nots and have-littles, this cooperation must be voluntary. For the cooperation to be voluntary, the have-nots and the have-littles must believe it would not be right or reasonable to take away what the have-plenties have. In other words, they must believe that for all its problems, the present social, political, and economic order, with its disparities of wealth and power and privilege, is about the best that human beings can create. More specifically, the have-nots and have-littles must believe that they are not being exploited or being treated unfairly by the have-plenties, and these beliefs must be in some considerable degree false, because the distribution of wealth and power in the United States is so evidently arbitrary and unjust, ergo the need for ideology. A disquisition on the inequitable distribution of wealth and income in the United States is beyond the scope and purpose of this book. This subject, as well as the existence of a dominant or ruling class in America, has been documented extensively by others. We will make only 2 points here. First, there are indeed wide disparities in the distribution of wealth and income in the United States. Second, these disparities are so obviously unjust that it is reasonable to assume that the vast majority of people who must struggle to make ends meet put up with them only because they have been sold a bill of goods, that is, an ideology. In 2014, the richest 20% of American households received 51.2% of the income received by all families, whereas the poorest 60% of American households received 25.6% of the total income. In crude terms, this means that while the wealthiest 25 million American households have more than half the money pie to themselves, the least wealthy 75 million American households share about a quarter of that pie among them. At the outer edges the figures are more extreme. For 2014, the richest 5% of households received 21.9% of total income, substantially more than the poorest 40% of households, who received 11.3%. This means that the richest 6 million households have nearly twice as much money to divide among themselves than the 48 million households who make up the bottom 40%. 52. The distribution of wealth, property such as homes and stocks, as well as ownership of businesses and land that generate income and tend to give one a say in major economic decisions, is even more unequal than the distribution of income. 53. The top 20% of wealth holders own 87% of the wealth, including 88% of stocks and financial assets and 94% of businesses and non-financial assets. 54. The survey shows that the top 1% own 35% of the wealth, but the survey on which this data is based does not sample the Forbes 400, the 400 wealthiest individuals in the United States. To be on that list requires $1.55 billion. They collectively own $2.29 trillion, while collectively the bottom 40% of the country owns nothing. The debt of the poorest 20% is cancelled out by the small holdings of the next group. 55. 188. Americans generally underestimate the amount of inequality in the country, and when asked to construct their ideal distribution of wealth, it is more equal still. Some of the results of Michael Norton and Dan Ariely's survey of 5,522 Americans are shown in Table 4.2. They note that analysis of responses by sex, political party, and current income showed much more consensus than disagreement among these different demographic groups. 56. Ideology is at work in making people perceive a lower level of inequality than actually exists and in accepting the vast difference between what exists and what they believe is fair. We offer no complicated philosophical argument to prove that these disparities are unjust, although such arguments abound for those who are interested. 57. It is a scandal that, in a nation as rich as ours, some 46.7 million people, somewhat less when reckoned with the most generous valuation of in-kind benefits, such as food stamps, live below what the government conservatively defines as the poverty level, and that many millions more must scramble to make ends meet. 58. It is shameful that more than a third of the individuals below the poverty line are children. It is tragic that in our wealthy nation so many millions cannot afford a proper diet, a college education, a decent place to live, and good health care. Because we are nowhere near offering all Americans a good education and an equal opportunity to get ahead, we have no right to think that the distribution of income reflects what people have truly earned. The distribution of income in America is so fundamentally shaped by factors such as race, educational opportunity, and the economic class of one's parents. 59. That few people who are well off can honestly claim they deserve all that they have. Those who think they do should ask themselves where they would be today if they had been born to migrant laborers in California or to a poor black family in a ghetto. Enough said. We take it, then, as established that the disparities of wealth and income in America are wide and unjustified. For the vast majority, the many millions struggling hard to satisfy basic needs, to acquiesce to the vast wealth of a small minority, it is necessary that the majority come to believe that these disparities are justified, that the present order is the best that human beings can accomplish, and that they are not being exploited by the have-plenties. In other words, the system requires an effective ideology to fool enough of the people enough of the time. This account of the nature and need for ideology, coupled with the historical inertia explanation of the persistence of criminal justice in its current form and the analysis of the ideological benefits produced by the criminal justice system, add up to an explanation of the continued failure of criminal justice in the United States and its persistent bias against the poor. We believe that we have proven the Pyrrhic defeat theory of American criminal justice. Summary. This chapter has presented the Pyrrhic defeat theory's explanation of the triple failure of criminal justice in the United States. 1. To institute policies likely to reduce substantially the high incidence of crime. 2. To treat as crimes the dangerous acts of the well-off, and 3. To eliminate the bias against the poor in the treatment of those acts labeled crimes. The persistence of this triple failure was explained by appeal to the notion of historical inertia. The current shape of criminal justice policy emerged at an earlier time when it corresponded to the real threats to people's bodies and possessions, and it has persisted, in spite of its failures. Because its failures mainly harm the poor while they benefit the well-off, thus criminal justice policy does not generate incentives to change the system for those with the power to do so. The failing criminal justice system benefits those with the power to change things by broadcasting the message that the threat to Americans' well-being comes from below them on the economic ladder, not from above them, and that poverty results not from social causes but from the moral depravity of the poor. It was also argued that, aside from these bonuses of bias, there is an implicit ideological message of any criminal justice system, insofar as such systems, by focusing on individual guilt, implicitly broadcast the message that the social system itself is a just one. Conclusion. 197. Criminal justice or criminal justice. Justice being taken away, then, what are kingdoms but great robberies? St. Augustine, The City of God. Unjust social arrangements are themselves a kind of extortion, even violence. John Rawls, A Theory of Justice. The policeman moves through Harlem, therefore, like an occupying soldier in a bitterly hostile country, which is precisely what, and where he is, and the reason he walks in twos and threes. James Baldwin, Nobody Knows My Name. A criminal justice system is a system of justice only if it protects equally the rights and interests of all members of society. For that it must punish even-handedly the rich as well as the poor who violate these rights or endanger these interests. When it does not do this, the system is criminal. The biased use of the system's coercive power, police, courts, prisons, is force used against some members of society to promote the interests of others. This is to say, it does precisely what crime does, and thus its force is morally equivalent to criminal violence. Later in this conclusion, we point out several policies that must be put in place if our system is to be a system of justice. The crime of justice. Robbers, extortionists, and occupying soldiers are terms used to characterize those who enforce an unjust law and an unjust order. This is not merely rhetoric. There is a very real and very important sense in which those who use force unjustly or who use force to protect an unjust social order are no different from a band of criminals or an occupying army. If this isn't understood, you are likely to think that what has been described in the first 3 chapters, and accounted for in the 4th, amounts to only another call for reform of the criminal justice system to make it more effective and fairer, when in fact it is much more. A criminal justice system that functions like ours, that imposes its penalties on the poor and not equally on all who threaten society, that does not protect us against threats to our lives and possessions equal to or graver than those presently defined as crimes, and that fails even to do those things that could better protect us against the crimes of the poor, is morally no better than the criminality it claims to fight. In the next section, Rehabilitating Criminal Justice in America, we propose some reforms. These should not be taken as proposals aimed merely at improving the effectiveness or fairness of American criminal justice. In our view, these proposals represent the necessary conditions for establishing the moral superiority of criminal justice to criminality. Thus they are a matter of rehabilitating the system, not merely reforming it. They are the conditions that must be fulfilled if the criminal justice system is to be acquitted of the indictment. Implicit in the statements above from St. Augustine, Rawls, and Baldwin. Bear in mind that the criminal justice system does not mean only police, courts, and prisons. It includes the entire legal system, from lawmakers to law enforcers to judges and prison guards and parole boards. What is common to the charge in the statements of St. Augustine, Rawls, and Baldwin is the idea that injustice transforms a legal system into its opposite. What is common to the robber, the extortionist, and the occupying soldier is that each uses force, or the threat of force, to coerce people to serve the interests of others at the expense of their own. The occupying soldier uses force to subject one people to domination by another. The robber and the extortionist use force to make other people hand over things of value. The injustice that characterizes criminal acts is the forcing of people to serve the interests of others. A legal system, of course, also uses force. Its defenders, however, maintain that it uses force to protect people's bodies, private property, and destinies. They claim that the legal system protects people's possessions against robbers and extortionists and protects their autonomy against those who would try to impose their will on them by force. In short, although both a legal system and its opposite, either criminality or military domination, use force, the moral superiority claimed for the legal system lies in the fact that it uses force to protect the interests of all people equally, whereas criminals and occupying troops use force to subject some people to the interests of others. The moral legitimacy of a legal system and the lack of legitimacy of crime and military domination hinge, then, on the question of whether coercion is being used in the interests of all equally or to promote some people's interests at the expense of others. This adds up to something that should be obvious but is not. A criminal justice system is criminal to the extent that it is not truly a system of justice. A criminal justice system is a system of justice to the extent that it protects equally the interests and rights of all and to the extent that it punishes equally all who endanger these interests or who violate these rights. When it veers from these goals, the criminal justice system is guilty of the same sacrificing of the interests of some for the benefit of others that it exists to combat. It is, therefore, morally 199. Speaking, guilty of crime. Which is it? Criminal justice or simply criminal? The experience of the 20th century has taught us that we should not take for granted that every legal system is a system of justice. Hitler's Germany and Stalin's Soviet Union, as well as South Africa when it practiced apartheid, are testimony to the fact that what is put forth as law may well be outrageously unjust. An example closer to home would be the U.S. legal system that, under the Supreme Court's Dred Scott decision of 1857, defined black slaves as property. In such instances, we easily recognize the truth implicit in the statements of St. Augustine, Rawls, and Baldwin that open this chapter. What is put forth under the authority of law may be morally no better than crime or tyranny. Therefore, we cannot take for granted that Our own legal order is just merely because it is legal. We must subject it to the moral test of whether it serves and protects the interests of all, to make sure it is not injustice disguised as justice or criminality wearing the mask of law. Appendix 2, Between Philosophy and Criminology, argues that criminology requires a moral evaluation of crime as part of its identification of its object of study. We do not, of course, equate the U.S. legal system with that of Hitler's Germany or Stalin's Soviet Union. There is much in the system that is legitimate, and many are caught by the system who should be. Stated precisely, our claim is this. To the extent that the American criminal justice system fails to implement policies that could significantly reduce crime and the suffering it produces, as argued in Chapter 1. To the extent that the American criminal justice system fails avoidably to protect Americans against the gravest dangers to their lives and property, as argued in Chapter 2. To the extent that the American criminal justice system apprehends and punishes individuals not because they are dangerous but because they are dangerous and poor, as argued in Chapter 3. Then, to that same extent, the American criminal justice system fails to give all Americans either protection or justice, aids and abets those who pose the greatest dangers to Americans, and uses force in ways that do not serve equally the interests of all who are subject to that force, and thus its use of force is morally no better than crime itself. 200. Rehabilitating criminal justice in America. The criminal justice system in America is morally indistinguishable from criminality insofar as it exercises force and imposes suffering on human beings while violating its own morally justifying ideals, protection and justice. Once this is understood, the requirements for rehabilitating the system follow rather directly. The system must institute policies that make good on its claim to protect society and to do justice. The remainder of this chapter briefly sketches the outlines of a treatment strategy for helping the system go straight. It cannot be reiterated too frequently that these proposals are not offered merely as means of improving the system. Nor are we under any illusion that these proposals will be easily adopted or implemented. They are presented as the necessary requirements for establishing the criminal justice system's moral difference from, and moral superiority to, crime, and even if not implemented, they stand as a measure against which this moral difference and superiority can be judged. The proposals fall under the headings of the two ideals that justify the existence of a criminal justice system: protecting society and promoting justice. Protecting society. Every day that we refuse to implement those strategies that have a good chance of cutting down on the predatory and violent street crimes people fear, the system is an accomplice to those crimes and bears responsibility for the suffering they impose. Thus, we must put an end to the crime-producing poverty in our midst. Throughout this book we have documented the striking persistence of large-scale poverty in the United States, which links with much of the crime people fear the most. The elimination of poverty, concentrated disadvantage, and family disruption are the most promising crime-fighting strategies there are and, in the long run, the most cost-effective. It is sometimes observed that poverty itself doesn't cause crime, because, for example, there was more poverty in earlier times than now and yet less crime. There is an important truth here, but it is easy to miss it. The truth is that it is not poverty as such that breeds crime, but the things that poverty brings with it in a modern, free enterprise society like ours: lack of good education, because public schools are financed primarily out of local property taxes and the best schools are expensive private ones; lack of parental authority, because unemployed parents easily lose their children's respect; lack of cohesive local community, because those who can will escape the poor inner cities as quickly as possible; lack of allegiance to social institutions, due to feeling left out, and so on. It is these things, rather than lack of money itself, that lead to crime. Investing in our inner cities and providing high-quality public education, job training, and jobs for the unemployed will give us more productive citizens with a stake in playing by the rules. And it will be cheaper than paying for police and prisons to house those who break the rules. Eliminating the debilitating and crime-producing poverty around us is essential to any serious, long-term effort to protect society from crime. But along with it, we must let the crime fit the harm and the punishment fit the crime, treat the harmful acts of the well-off as crimes. 201. And decriminalize victimless crimes. For the criminal justice system to justify its methods, it must make good on its claim to protect society. This requires that the criminal law be redrawn so that the list of crimes reflects the real dangers that individuals pose to society. We must make new and clear laws against imposing certain dangers on workers and citizens generally, and then hold people to those laws no matter what their economic class is and no matter how big their corporation is. Crime in the suites should be prosecuted and punished as vigorously as crime in the streets, and in proportion to the harm it does. The law must be drawn carefully so that individuals are not punished for harm they could not foresee or could not have avoided or that others have freely consented to risking. Moreover, this is not a matter of punishing people for anything and everything they do that might lead to harm. The pursuit of security must not swamp the legitimate claims of liberty and progress. Some risks are the inevitable companions of freedom. And some are part of modern life. For every mile of highway we build, we can predict the number of people who will be killed in accidents on it. This does not justify treating the highway engineer as a murderer. Rather, we must have an open and ongoing discussion about risk, especially where some profit by imposing unreasonable risks on workers, consumers, and citizens generally. Within this framework, we must stop treating indirect harm as merely a regulatory matter and start treating all intentional harm-producing acts in proportion to the actual harm they produce. We must enact and implement punishments that fit the harmfulness of the crime without respect to the class of the criminal. Because responsibility for corporate actions tends to be spread or even blurred in large organizations, we need legal requirements that make corporations identify in advance the individuals who are legally responsible for specific acts. Kip Schlegel recommends that a standard of reckless supervision be built into sentencing guidelines for corporate offenses so that individuals with supervisory authority could be held responsible for failure to exercise that authority when there is substantial risk of harm. 1. The Sarbanes-Oxley financial reform legislation takes a step in this direction by requiring executives to certify the accuracy of financial statements so that they cannot get paid big money to run a company and then claim they had no idea about massive, systemic, billion-dollar frauds. The principle is sound and should be applied more widely in the business world. But this is only the beginning. There is much more that can and should be done. In his book, Corporate Crime and Violence, Russell Mokhiber sets out a 50-point law and order program to curb corporate crime. 2. Mokhiber's suggestions are quite realistic, and many fit well within the framework just outlined. A current list of recommendations for new laws would require corporate executives to report activities that might cause death or injury, make it a criminal offense to willfully, recklessly, or negligently fail to oversee an assigned activity that results in criminal conduct, enable federal prosecutors to bring federal homicide charges against companies that have caused death on a national scale, hold corporations responsible for how they respond to wrongful acts, for example, do they cover up or take measures to prevent recurrence, facilitate class action suits against corporations, require convicted companies to make their misdeeds public by advertising them, better protect whistleblowers from reprisal, increase the penalties for convicted corporate executives, use fines to support independent watchdog organizations, track the extent and cost of white-collar crime, establish a specialized corporate crime task force within the Department of Justice, and for serious or repeated offenses execute corporations, by stripping them of their corporate charters. Such laws, duly 202 applied, would begin to make the criminal justice system's response proportionate to the real dangers in our society. 3. The other side of the coin is the decriminalization of victimless crimes, acts such as prostitution, gambling, vagrancy, and recreational drug use, acts that produce no harm to individuals who have not freely chosen to risk it. As long as these acts involve only adults who have freely chosen to participate, they are no threat to the liberty of any citizen. This also means that there is generally no person who is harmed by these acts and who is ready and able to press charges and testify against the wrongdoers. Therefore, police have to use a variety of shady tactics involving deception and actions bordering on entrapment, which undermine the public's respect for the police and the police officers' respect for themselves. The use of such low visibility tactics increases the likelihood of corruption and arbitrariness in the enforcement of the law. Beyond this, because these acts produce no tangible harm to others, laws against them make criminals out of people who have no intention to injure or take advantage of others. In short, such laws fill our prisons with people who aren't dangerous, while we leave truly dangerous people on the streets and in the suites. To make good on its claim to protect society, the criminal justice system must not only treat the dangerous acts of business executives as crimes but also decriminalize those acts that are not clearly dangerous. 4. More than 150 years ago, John Stuart Mill formulated a guiding principle, still relevant to our time, for the design of legislation in a society committed to personal liberty. That principle is, that the sole end for which mankind are warranted, individually or collectively, in interfering with the liberty of action of any of their number, is self-protection. That the only purpose for which power can be rightfully exercised over any sane adult member of a civilized community, against his will, is to prevent harm to others. 5. Although this principle needs to be modified in recognition of some of the ways in which individuals can cause future harm to themselves in modern society where people must deal with machines and chemicals beyond their understanding, 6. The core of the principle is still widely accepted. This is the notion that a necessary condition of any justifiable legal prohibition is that it forbids an act that does foreseeable harm to someone other than the actor himself. Because priority should be given to freedom of action, this harm should be demonstrable, i.e., verifiable by some widely agreed upon means, say, those used by science, and it should be of sufficient gravity to outweigh the value of the freedom that is to be legally prohibited. 7. This principle should not only guide legislators and those engaged in revising and codifying criminal law, but should also be raised to the level of an implicit constitutional principle. The U.S. Supreme Court recognizes certain traditional principles of legality as constitutional requirements even though they are not explicitly written into the Constitution. For instance, some laws have been held unconstitutional because of their vagueness, and others because they penalized a condition, such as being a drunk or an addict, rather than an action, such as drinking or using drugs. 9. The tenor of the Bill of Rights is to enshrine and protect individual liberty from the encroachment of the state, and thus Mill's principle is arguably already implicitly there. Whether as a legislative or a judicial criterion, however, applying Mill's principle would undoubtedly rid our law of the residues of our puritanical moralism, and it would eliminate the forced induction into criminality. 203. Of the individuals, mainly those of the lower class, who are arrested for victimless crimes. It would eliminate the pressure towards secondary crime, the need of the prostitute for a pimp to provide protection, theft by drug addicts to support their habits, violent turf wars between drug gangs, and so on. And it would free up resources for the fight against the really dangerous crimes. Thus, we must legalize the production and sale of illicit drugs and treat addiction as a public health problem. When drug addicts cannot obtain their fix legally, they will obtain it illegally. Because those who sell it illegally have a captive market, they will charge high prices to make their own risks worthwhile. To pay the high prices, addicts must, will, and do resort to crime. Thus, every day in which we keep the acquisition of drugs a crime, we are using the law to protect the high profits of black marketeers in the drug trade, and we are creating a situation in which large numbers of individuals are virtually physically compelled to commit theft. There can be little doubt that our present cure, arrests and incarceration, for narcotics use is more criminal, and crime-producing, than the narcotics themselves. Ethan Nadelmann, of the Woodrow Wilson School of Public and International Affairs, points out that there is no single legalization option. Legalization can mean a free market, or one closely regulated by the government, or even a government monopoly. Legalization under almost any regime, however, does promise many advantages over the current approach. Government expenditures on drug law enforcement would drop dramatically. So would organized crime. Revenues. 10. Many observers seem to agree that the British system in which doctors may prescribe heroin for addicts is superior to our own punitive system. For example, an editorial in the Montreal Gazette states, a Dutch study found prescribing heroin to abusers is not only cost-effective, but provided better quality of life to addicts. Savings to society were estimated at more than $20,000 a year per addict in reduced policing costs and property crime. Without this program, addicts on average were spending $1,500 a month on heroin, and were involved in a crime every 3 days to get extra money for drugs. 11. A number of experts have gone even further. Norval Morris and Gordon Hawkins urge that narcotics use be decriminalized and the drugs be sold in pharmacies by prescription. Kurt Schmoke, who, prior to being president of the University of Baltimore, was the mayor of Baltimore and Maryland's state attorney, has called for permitting health professionals to give drugs to addicts as part of a treatment and detoxification plan. Jerry Wilson, former Washington, D.C., police chief, has suggested the possibility of treating opiates and cocaine derivatives the way alcohol currently is treated, while keeping some psychoactive drugs available only at pharmacies with a doctor's prescription. 12. Because marijuana is arguably the least harmful drug, any reasonable plan of legalization will start by decriminalizing pot, not just allowing for medical use by those who can afford an exam and license. On the other hand, there may be some drugs that are so addictive or so likely to stimulate people to violence that we must keep them illegal. This may be the case with crack cocaine and with PCP, also known as angel dust. If this turns out to be true, and the government has so exaggerated the dangers of illicit drugs over the years that healthy skepticism is warranted about these recent claims, it may be necessary to exclude these from the general program of decriminalization. With less dangerous drugs decriminalized, however, many users of 204 crack or PCP might switch to the less dangerous ones, and, in any event, already overstretched law enforcement resources would be freed up to concentrate on the really dangerous drugs and on the crucial problem of keeping drugs away from youngsters. Ending poverty, criminalizing the really dangerous acts of the well-off, and decriminalizing victimless Crimes will protect society, reduce crime overall, and free up our police and prisons for the fight against the criminals who really threaten our lives and limbs. For these, however, we must develop correctional programs that promote rather than undermine personal responsibility, and we must offer ex-offenders real preparation and a real opportunity to succeed as law-abiding citizens. Numerous experts on corrections believe that our prison sentences are far too long, in light of the extreme deprivations of prison life and the lack of evidence that lengthy sentences significantly reduce crime. But sentencing reform must be accompanied by prison reform because the scandal of our prisons has been amply documented for decades, most recently by the National Academy of Sciences panel on incarceration. 13. Like our drug policy, our prisons seem more calculated to produce than to reduce crime. The enforced childhood of imprisonment may be the painful penalty that offenders deserve, but if it undermines their capacity to go straight after release, we are cutting off our noses to spite our faces. Philosopher Richard Lipp contends that, if we punish people because they have failed to act morally, we must respect and preserve their capacity to act morally. 14. But, people cannot learn to control themselves responsibly if they have spent years living in a violent environment, having every aspect of their lives, the hour they wake, the number of minutes they spend washing up, the time and content of eating and working and exercising, and the hour at which lights go out, regulated by someone else. Add to this the fact that convicts usually emerge with no marketable skill and little chance of getting a decent job, with the stigma of a criminal record excluding them from many aspects of the society they are re-entering. The result is a system in which we never let criminals finish paying their debt to society and instead give them every incentive to return to crime. What's needed is the encouragement of restorative justice, the adoption of proven rehabilitative programs, and a transformation of prisons to infuse hope, personal responsibility, and respect for human dignity into our correctional practices. 15. Lipp contends that the harsh conditions that generally characterize American prisons should be replaced with what he calls the minimum conditions of confinement. These minimum conditions are already enough to deprive offenders of freedom of movement and association, attenuate their ties with loved ones and friends, curtail their privacy, subject them to low levels of amenities, limit their work options and access to forms of entertainment, make them subservient to extensive bureaucratic control, and impose upon them a lasting stigma. Greater deprivations than these cause near extinction of the agency, the capacity to form responsible judgments and act on them of inmates, and thus run afoul of the requirement that offenders be respected and preserved as autonomous moral agents. 16. The National Academy of Sciences panel on incarceration suggests that policy makers take steps to provide better conditions for those in prison and improve the experience of incarcerated men and women and reduce the unnecessary harm to their families and communities. 17. Francis Cullen goes further, the rehabilitative ideal draws its power from its nobility and its 205. Rationality from the promise that compassionate science, rather than vengeful punishment, is the road to reducing crime. Rehabilitation allows us to be a better and safer people. 18. Former National Institute of Justice Director, Jeremy Travis, points out that 630,000 people leave prison each year and re-enter society. He writes that re-entry is not an option. Re-entry reflects the iron law of imprisonment, they all come back. 19. Yet criminologist Joan Peters-Illey poignantly notes, the average inmate coming home will have served a longer prison sentence than in the past, be more disconnected from family and friends, have a higher prevalence of substance abuse and mental illness, and be less educated and less employable than those in prior prison release cohorts. Each of these factors is known to predict recidivism, yet few of these needs are addressed while the inmate is in prison or on Parole. 20. Thus, if we are going to continue to punish people by depriving them of their liberty, we must do it in a way that prepares them for the life they will lead when their liberty is returned. Anything less than this is a violation of the Constitution's Eighth Amendment guarantee against cruel and unusual punishment. Depriving a person of his or her liberty may be an acceptable punishment, but depriving people of their dignity and a chance to live a law-abiding life when their punishment is supposed to be over is cruel and, should be but sadly, is not, unusual. To release them back into a safer and more peaceful society, however, we must enact and vigorously enforce stringent gun controls. Americans are armed to the teeth. The handgun is the most easily concealed, the most effective, and the deadliest weapon there is. Its ubiquity is a constant temptation to would-be crooks who lack the courage or skill to commit crime without weapons or to chance hand-to-hand combat. Its ubiquity also means that any dispute may be transformed into a fatal conflict beyond the desires or expectations of the disputants. A large number of accidental injuries and deaths are also linked to the prevalence of guns. And the problem is not limited to handguns. In recent years, it has become relatively easy to obtain rapid-firing assault rifles. Trying to fight crime while allowing such easy access to guns is like trying to teach a child to walk and tripping him each time he stands up. In its most charitable light, it is hypocrisy. Less charitably, it is complicity in murder. 21. If, because of the Second Amendment, we continue to allow private individuals to own guns, we can at least require that gun owners be registered and perhaps certified after completing a course on safe use of guns. Safety classes are already commonly required as part of qualifying for gun permits. We can surely ban assault rifles and require all guns to have trigger locks that children and gun thieves cannot open. 22. These changes, taken together, would be likely to reduce dangerous crime and to bring us a legal order that actually punished and, it is hoped, deterred all and only those acts that really threaten our lives, limbs, and possessions and punished them in proportion to the harm they really produce. Such a legal system could be truly said to protect society. Promoting justice. 206. The changes recommended above would, in part, make the criminal justice system more just because people would be punished in proportion to the seriousness of their harmful acts, and the number of innocent persons victimized by those acts would be reduced. At the same time, however, we have seen that the criminal justice system is biased against the poor, and until poverty is eliminated, much must be done to assure justice for the poor people who get caught up in the criminal justice system. Thus, to begin with, the criminal justice system should arrest, charge, convict, and sentence individuals with an eye only to their crime, not to their economic class. More frequent arrests or harsher penalties for poor persons than for others accused of the same crime constitute a grave injustice that undermines the legitimacy of the criminal justice system. Unfortunately, the criminal justice system is fraught with class bias, but it collects almost no statistics on income, wealth, or occupation, so the bias remains under-scrutinized. Further, many of the decisions that work to the disadvantage of the poor, police decisions to arrest, prosecutors' decisions to charge, and judges' decisions on how long to sentence are exercises of discretion often out of public view. So, we must narrow the range in which police officers, prosecutors, and judges exercise discretion, and we must develop procedures to hold them accountable to the public for the fairness and reasonableness of their decisions. Unlike prosecutors' or judges' decisions, the police officer's decision not to arrest is not a matter of record. Thus it is the least visible exercise of discretion and the most difficult to control. Our best hope to make arrests by police more just lies in increased citizen awareness and education of police officers so that they become aware of the operation and impact of their own biases and are held more directly accountable to, and by, the public they serve and sometimes arrest. As for prosecutorial and judicial discretion, two approaches seem potentially fruitful. First, lawmakers ought to spell out the acceptable criteria that prosecutors may use in deciding whether or what to charge. The practice of multiple charging an accused burglar with the lesser included crimes of breaking and entering, possession of burglar's tools, and so on, should be eliminated. It is used by prosecutors to coax accused persons into pleading guilty to one charge by threatening to press all charges. Of all the dubious features of our system of bargain justice, this seems most clearly without justification because it works to coerce a plea of guilty that should be voluntary if it is to be legally valid. 23. Federal sentencing guidelines, followed by the adoption of sentencing guidelines by many states, are an important step toward reducing discretion, and thus discrimination, in the criminal justice system. But they are only a step. They have not eliminated discrimination. D'Alessio and Stolzenberg found that lower socioeconomic status, SES, offenders were likely to receive harsher sentences for non-property and morals offenses than higher SES offenders and that sentencing guidelines did not reduce these disparities. 24 And, as pointed out in Chapter 3, for similar charges white defendants are more likely to get sentences below the guideline minimums than blacks. What's more, sentencing guidelines have not so much eliminated discretion as shifted it from judges to prosecutors, who decide what to charge, and because prosecutors are less insulated. 207. From political pressures than judges, that makes discretion even harder to control. Thus, sentencing guidelines must be matched with charging guidelines. 25. Neither sentencing nor charging guidelines should be so rigid as to leave no room for the expert judgment of judges or prosecutors. In 2005, the Supreme Court decided that sentencing guidelines are only advisory and not legally binding on judges, but research by the U.S. Sentencing Commission indicates that sentencing practices in the year following the court's decision are consistent with earlier sentencing under the guidelines. So all the problems with them remain. 26. Rather than rigid rules, we need public accountability, timely release of data about the status of cases, and explanations for decisions about cases that are dropped. Moreover, the sentencing guidelines that we have arose during the Reagan era, with its emphasis on extreme punitiveness. They often call for draconian mandatory minimum sentences for small crimes, particularly drug crimes, or life sentences for a third offense no matter how minor. In response to this, an advocacy group called Families Against Mandatory Minimums was formed, whose files bulge with cases of citizens serving drug sentences of 5, 10, and 20 years without parole chances for first and often minor offenses. 27. California sentenced a man to 50 years in prison for 2 shoplifting incidents involving the theft of 11 videocassettes from Kmart, and the Supreme Court upheld the sentence in 2003 as not unreasonable or disproportionate. 28. Because this very punitive approach has dramatically expanded our prison populations with only small gains in crime reduction, it is time to separate the task of assuring even-handed sentencing from that of hard-fisted sentencing. Whichever way we achieve it, it is clear that to make the criminal justice system function justly, the criminal justice system must be used for public safety and community justice, not for raising revenue. In response to the police shooting of an unarmed black teenager in Ferguson, Missouri, in 2014, a Department of Justice, DOJ, investigation found that the city finance director and city manager asked the Police chief to aggressively issue citations so that revenue from court fees could be increased because of other budget shortfalls. Management carefully monitored police productivity, number of citations issued, so DOJ found that many officers appear to see some residents, especially those who live in Ferguson's predominantly African American neighborhoods, less as constituents to be protected than as potential offenders and sources of revenue. 29 They found further that this emphasis on revenue has compromised the institutional character of Ferguson's police department. 30 And of its municipal court, which does not act as a neutral arbiter of the law or a check on unlawful police conduct. 31 These practices especially harm the poorer residents because minor offenses can generate crippling debts, and result in jail time because of an inability to pay. 32. Unfortunately, the problem is not confined to Ferguson. The Justice Department's top civil rights prosecutor noted, the Ferguson report really does highlight some issues that jurisdictions around the country are plagued with. 33 Indeed, a year after the Ferguson report, DOJ sent out a letter to courts around the country expressing concern over the illegal enforcement of fines and fees. It reminded them that in Bearden v. Georgia, 1983, the court prohibited the incarceration of indigent probationers for failing to pay a fine, because to do otherwise would deprive the probationer of his conditional freedom simply because, through no fault of his own, he cannot pay the fine. 34. 208. Also, at a time when governments increasingly use private, for-profit businesses to provide services, some of those businesses share revenue with the government in ways that take advantage of people caught up in the criminal justice system. Whether through the courts or for-profit contractors, excessive fines and fees create additional economic hardship on the poor, who are already struggling. Incarceration for being poor is not only unfair and unconstitutional, it makes it much harder for them to get decent jobs. Because even a criminal justice system genuinely working for public safety and community justice will still process people accused of crimes. We must transform the equal right to counsel into the right to equal counsel. All these changes still leave standing what is probably the largest source of injustice to the poor in the system: unequal access to quality legal counsel. We know that privately retained counsel will have more incentive to put in the time and effort to get their clients off the hook. The result is that, for equal crimes, those who can retain their own counsel are more likely to be acquitted than those who cannot. The present system of allocating assigned counsel or public defenders to the poor and privately retained lawyers to the affluent is little more than a parody of the constitutional guarantee of equal protection under the law. In our system, even though lawyers are assigned to the poor, justice has a price. Little over a century ago, before there was a public police force in every town and city, people got police protection by hiring private police officers or bodyguards if they could afford it. Protection was available for a price, and so those who had more money were better protected under the law. Today, we regard it as every citizen's right to have police protection, and we would find it outrageous if police protection were allocated to citizens on a fee-for-service basis. But this is precisely what we do with respect to the legal protection provided by lawyers. Both police officers and lawyers are essential to the individual's legal protection. It is hypocrisy to acknowledge everyone's right to equal protection under the law by the police and then to allocate protection under the law by lawyers on the basis of what individuals can pay. As long as this continues, we cannot claim that there is anything like equal treatment before the law in the criminal justice system. Although this would appear to be a clear requirement of the equal protection and due process clauses of the Constitution, the Supreme Court has avoided it, perhaps because it surely poses great practical problems. However, the creation of public police forces to protect everyone posed great practical problems in its time as well. It would not be appropriate to use the police as a model for resolving the problem of equal counsel. 2. Establish a government legal service for all. In effect, to nationalize the legal profession might make equal legal representation available to all. It would, however, undermine the adversary system by undercutting the independence of defense attorneys from the state. Some form of national legal insurance to enable all individuals to hire private attorneys of their own choice, however, could bring us closer to equal legal protection without compromising the adversarial relationship. Such insurance would undoubtedly have to be subsidized by the government, as are the police, courts, and prisons, but it would not necessarily have to be totally paid for out of taxes. People can rightly be expected to pay their legal bills up to some fraction of their income, if they have one. The rest would be paid for by a government subsidy that would make up the difference between what the accused could afford and the going. 209. Rate for high-quality legal counsel. Nothing in the system need interfere with the freedom of the accused to select the lawyer of his or her choice or interfere with the independence of the lawyer. Undoubtedly, such a system would be costly. Our commitment to equal justice, however, remains a sham. Until we are willing to pay this price. Americans have paid dearly to protect the value of liberty enshrined in the Constitution. Is it too much to ask that they pay to realize the ideal of justice enshrined thereto? One final recommendation remains to be made. We must establish a more just distribution of wealth and income, and make equal opportunity a reality for all Americans. We have already argued that the criminal justice system, by its very nature, protects the prevailing economic distribution. Therefore, it is an error to think of the criminal justice system as an entity that can be reformed in isolation from the larger social order. A criminal justice system protects that social order, and it can be no fairer than the order it protects. A law against theft may be enforced with an even and just hand, but if it protects an unjust distribution of wealth and property, the result is injustice evenly enforced. Without economic and social justice, the police officer in the ghetto is indeed an occupying soldier with no more legitimacy than his or her gun provides. When the criminal justice system protects an unjust distribution of property, it uses coercion to force some to serve the interests of others at the expense of their own and is thus morally indistinguishable from the criminal. A criminal justice system can be no more just than the society its laws protect. Along with the other recommendations made in this chapter, the achievement of economic and social justice is a necessary condition for establishing the criminal justice system's moral superiority to crime. The National Academy of Sciences panel on incarceration noted that sentencing reform will not relieve the underlying problems of economic insecurity, low education, and poor health that are associated with incarceration in the nation's poorest communities. 35. This is not merely a matter of throwing money in the direction of poor people. It is a call for investment in our most important resource, human beings, and for targeting that investment where it is most urgently needed and morally required. The report suggests that solutions require changes in policies that address school dropout, drug addiction, mental illness, and neighborhood poverty. 36. It also requires a real opportunity for poor people to lift themselves out of poverty without lowering themselves into dependency. This would amount to a redistribution of wealth and income in the direction of greater social and economic justice. Because it would also reduce the temptations to crime produced by poverty, as well as the alienation from social institutions that it produces. It brings us full circle to the first recommendation that we made for protecting society. Here the requirements of safety and justice converge. Summary. Every step toward reducing poverty and its debilitating effects, toward criminalization of the dangerous acts of the affluent and vigorous prosecution of white-collar crime, toward decriminalization of recreational drug use and other victimless crimes, and toward domestic disarmament, every step toward creating a correctional system that promotes human dignity, toward giving ex-offenders a real opportunity to go straight, toward giving all individuals accused of crime equal access to high-quality legal expertise in their defense, toward making the exercise of power by police officers, prosecutors, and judges more accountable and more just, and every step toward establishing economic and social justice are steps that move us from a system of criminal justice to a system of criminal justice. The refusal to take those steps is a move in the opposite direction. Appendix I. The Marxian Critique of Criminal Justice. Jeffrey Ryman. In the first appendix, 1, I shall try to present the reader with an overview of Marxian theory that goes from Marxism's theory of capitalism to its theory of law, and from there to criminal justice. This addresses some of the same aspects of criminal justice discussed in the main text of this book, but it sets them in a theoretical framework different from, although not incompatible with, the Pyrrhic defeat theory, with its historical inertia explanation of the peculiar failure of criminal justice. I shall close with comments on the ethical implications of the Marxian analysis. Criminal justice has a concrete reality comprising police, prisons, courts, guns, and the rest. What is most important for our purposes, however, is the particular shape that this concrete reality takes in capitalism. This shape is governed according to certain principles that spell out what shall count as violations, what shall be done to violators, and so on. For simplicity's sake, I shall use the term criminal justice as shorthand for the principles that normally govern criminal justice practices and practitioners in capitalism, and use the term criminal justice system as shorthand for the concrete reality of the practices and practitioners so governed. Marxian analysis is in the first instance directed toward these governing principles. It aims to show that these principles are economic reflexes, that is, they reflect and thus support the existing economic arrangements. In our case, the capitalist mode of production. Criminal justice plays an ideological role in support of capitalism because people do not recognize that the principles governing criminal justice practices are reflections of capitalism. The principles of criminal justice appear instead to be the result of pure reason, and thus a system that supports capitalism is, mistakenly, seen as an expression of rationality itself. Engels, Marx's longtime collaborator, writes that the jurist imagines he is operating with a priori, i.e., purely rational principles, whereas they are really only economic reflexes, so everything is upside down. And it seems to me obvious that this inversion, so long as it remains unrecognized, forms what we call ideological conception. 2. As a consequence of this inversion, criminal justice embodies and conveys a misleading and partisan view of the reality of the whole capitalist system. Because capitalism requires laws that give individual capitalists the right to own factories and resources, a view of these laws that makes them appear to be purely rational makes capitalism appear purely rational as well. Before proceeding, a few words about the nature of Marxian theory are in order. First of all, Marx's theory of capitalism is separate from his advocacy of socialism and communism. Marx might be right about how capitalism works or about capitalism's unjust nature, even if socialism or communism would in fact be worse. Or even if they are merely utopian dreams that cannot be made real. This is important because of the tendency to think that the collapse of communism in Eastern Europe and the former Soviet Union, as well as the unpalatable features of that communism before it collapsed, refutes Marxian theory generally. This is quite untrue. What the collapse of Eastern European and Soviet communism refutes is, if anything, the theories of Lenin and Stalin about how to establish communism. Marx himself said very little about such things, and what he does say generally favors a much more democratic kind of socialism and communism than what Lenin and Stalin managed to bring about. Accordingly, it is still useful to look at what Marx thought about capitalism, even if one is convinced by recent events of the undesirability of actual communism or the 215 impossibility of ideal communism. Second, when we turn to Marx's theory of capitalism, we see that Marx portrays capitalism in pure form. He does so not to claim that that is how it actually exists anywhere, but rather to show the shape to which it tends everywhere. Actual systems will be a product of the force of that tendency versus the force of local factors, traditions, talent, innovation, luck, resources, the success or failure of particular human actions, and so on. Likewise, a Marxian analysis of criminal justice will indicate the pure form toward which criminal justice systems tend insofar as they support the functioning of capitalism. Actual criminal justice systems will be approximations of this tendency. Actual criminal justice systems will also clearly be shaped by human actions, often substantially so. No Marxist need to deny that the criminal justice system in the capitalist United States is much different from the criminal justice system in, say, capitalist Chile. What she must claim, rather, is that as capitalism develops in both countries, their criminal justice systems will increasingly tend to take on the shape that the theory implies. I shall try to show how Marxism leads to a theory of the structure that criminal justice systems tend to have under capitalism, while at the same time recognizing that any existing criminal justice system is only an approximation of this structure. To give the reader as complete a picture as possible, in this short space, of the whole of Marxian theory from general theory of capitalism to particular theory of criminal justice, and from there to ethical evaluation, I will have to sacrifice a lot of detail. I shall largely ignore the differences that individual actions may make in determining the shape of actual systems. I hope I have said enough to suggest that this in no way implies that human actions are irrelevant to actual historical outcomes. I proceed in the following way. In the first section, Marxism and Capitalism, I sketch out enough of Marx's theory of the capitalist mode of production as is necessary to lay the foundation for a Marxian theory of law. Because law is, for Marxism, a form of ideology, we shall have to see how ideology works in capitalism. I take this up in the next section, Capitalism and Ideology. In Ideology and Law, I develop the Marxian theory of law and from it the Marxian theory of criminal justice. Then, in the final section, Law and Ethics, I consider the characteristic Marxian moral judgments about criminal justice, particularly about guilt and punishment, that are appropriate in light of the Marxian account. 216. Marxism and Capitalism. Marx says that capitalism is a system of forced labor, no matter how much it may seem to result from free contractual agreement. 3. Here is both the truth that Marx asserts about capitalism and the legal ideology that shrouds that truth. To understand precisely how this works, we must consider the nature of the coercion that Marx discovered in capitalism. For Marx, the value of any commodity is equivalent to the average amount of labor time necessary to produce it. For under capitalism, the worker's ability to labor, Marx calls this labor power, is sold to the capitalist in return for a wage. Because labor power is also a commodity, its value is equivalent to the average amount of labor time necessary to produce it. Producing labor power means producing the goods needed to maintain a functioning worker. The value of labor power then is equivalent to the labor time that on the average goes into producing the goods, food, clothing, shelter, and so on, necessary to maintain a functioning worker at the prevailing standard of living, which Marx understood to differ among countries depending on their respective histories. Capital, Volume 1, p. 171. The worker receives this in the form of a wage, that is, in the form of the money necessary to purchase these goods. The capitalist obtains the money she pays as a wage by selling what the worker produces during the time for which he is employed. If the worker produced an amount of value equivalent only to his wage, there would be nothing left over for the capitalist and no reason for her to hire the worker in the first place. Labor power, however, has the unique capacity to produce more value than its own value. Capital, Volume 1, pages 193 to 94. The worker can work longer than the labor time equivalent of the value of the wage he receives. Marx calls the amount of labor time that the worker works to produce value equivalent to his wage necessary labor. The additional labor time that the worker works beyond this is called surplus labor, and the value it produces. Surplus value. The surplus value, of course, belongs to the capitalist and is the source of her profit. Capital, Volume 1, pages 184 to 86, that is, when the capitalist sells the product made by the worker, the capitalist gives some of the money she gets back to the worker as wage. This corresponds to the value that the worker put into the product during his necessary labor time, and the capitalist keeps the rest as profit. This corresponds to the surplus labor time that the worker puts in after his necessary labor time. Profit, then, rests on the extraction of unpaid surplus labor from the worker. To see this, one need to only recall that although all products in the economy are produced by labor, only a portion of those products are wage goods that the workers get paid with. Wages only have value because they can be traded for wage goods. The remainder belongs to their bosses and is effectively uncompensated. The wage goods only compensate necessary labor time to which they are equivalent in value. What workers produce beyond this goes to the capitalist gratis. Thus, writes Marx, the secret of the self-expansion of capital, that is, the secret of profit, resolves itself into having the disposal of a definite quantity of other people's unpaid labor. Capital, Volume 1, p. 534. For Marx, however, capitalism is not only a system in which unpaid labor is extracted from workers, it is also a system in which workers are forced to provide this unpaid labor. Workers are not merely shortchanged. They are enslaved. Capitalism is a coercive relation. Capital, Volume 1, p. 309. The coercion, however, is not of the direct sort that characterized slavery or feudal serfdom. It is, rather, an indirect force built into the very fact that capitalists own the means of production and laborers do not. Means of production are things, such as 217. Factories, machines, land, and resources that are necessary for productive labor. Lacking ownership of means of production, workers lack their own access to the means of producing a livelihood. By this very fact, workers are compelled to sell their labor to capitalists for a wage because the alternative is, depending on conditions, either painful or fatal, relative pauperization or absolute starvation. This compulsion is not in conflict with the fact that the terms upon which the worker works for the capitalist are the result of free contractual agreements. Indeed, the compulsion works through free agreements. Because the agreements are free, each side must offer the other a reason for agreeing. If workers offered capitalists only as much labor as went into the wage goods they will get back in return from the capitalists, the capitalists would have no reason to purchase their labor. It follows that, no matter how free the wage contract is, as long as it occurs in a context in which a few own all the means of production, those who do not own means of production will be compelled to give up some of their labor without compensation to those who do. Thus, Marx describes the wage worker as a man who is compelled to sell himself of his own free will. Capital, Volume 1, p. 766. The compulsion of the worker operates through the structure of property relations. The dull compulsion of economic relations completes the subjection of the laborer to the capitalist. Direct force, outside economic conditions, is of course still used, but only exceptionally. Capital, Volume 1, p. 737. The very existence of the social roles of capitalist and worker defined by ownership and non-ownership of means of production, respectively, is what coerces the worker to work without compensation. It coerces in the same way that a social structure that allotted to one group ownership and thus control of all the available oxygen, would coerce beyond what was necessary to defend this group against challenges to its ownership of the oxygen. No additional force would be necessary for the coercion to operate. Indeed, it would operate quite effectively by means of bargains freely struck, in which the non-oxygen owners had to offer something to the owners to get the chance to breathe. They, too, would be compelled to sell themselves of their own free will. The same can be said of capitalism. Once its structure of social roles is in place, all that is necessary is that individuals choose, from among the alternatives available to them in their roles, the course of action that best serves their self-interest, and the extraction of unpaid surplus labor is enforced without further need for overt force. As with the oxygen-owning society, so too with capitalism, overt force is used or threatened to defend owners against challenges to their ownership. That is just another way of saying that, in capitalism, the state uses overt force to protect private property. And this force is used to protect both the property of the capitalist, her factories and resources, and the property of the worker, his labor power. This differs crucially from the way in which overt force is exercised in social relations like slavery. In slavery, the use of overt force is part of the normal exercise of the master's power. In capitalism, overt force is used to defend all against forceful interference with their right to dispose of whatever property they happen to own, be it means of production or labor power. Accordingly, such force is not part of the capitalist's power, but is left to a third party that, in this respect, functions neutrally toward all owners, the state. With both capitalists and workers protected in their capacity to dispose of what they own, the process by which workers are forced to work gratis can proceed apace. This effect can be achieved with the state functioning neutrally. Although the state normally favors the interests of capitalists over workers, 5. It can serve the process of forced extraction of unpaid labor by protecting both capitalists and workers alike in their freedom to dispose of what they happen to own. Thus, the state can treat capitalists and workers as having the 218 same or equal property rights over what they own. It just turns out that what capitalists happen to own is means of production, and what workers happen to own is the muscles in their arms. Capitalism, then, naturally appears as a system of free exchanges between people with equal rights, over unequal amounts of property. This brings us to the phenomenon of ideology. 219. Capitalism and ideology. Of the study of social revolutions, Marx writes, "In considering such transformations, a distinction should always be made between the material transformation of the economic conditions of production, which can be determined with the precision of natural science, and the legal, political, religious, aesthetic, or philosophic, in short, ideological forms in which men become conscious of this conflict and fight it out." 6. The legal, then, is an ideological form. This is not to say that it is merely mental. It has a material reality in the form of police and prisons and guns and courts and legislators and law books, and the rest. What is crucial is how this material reality is shaped, and for that we must understand how ideology is shaped. As its etymology suggests, ideology means the science of ideas, where science can be taken in the ordinary sense as the study of causal connections. Recall the discussion of ideology in Chapter 4. In the context of Marxian theory, ideology comes to mean the ideas caused by the mode of production, in our case, the capitalist mode of production, and, equally important for Marxism, the caused ideas are in some important way false. Thus understood, for Marxism, the study of ideology denotes the study of how the mode of production gives rise to people's false beliefs about society. In the German ideology, Marx writes, "If in all ideology men and their circumstances appear upside down as in a camera obscura, this phenomenon arises just as much from their historical life process as the inversion of objects on the retina does from their physical life process. The phantoms formed in the human brain are also, necessarily, sublimates of their material life process, which is empirically verifiable and bound to material premises." 7. As this statement makes clear, the study of ideology requires that both the existence and the falsity of ideological beliefs be given a materialist explanation. To understand this requirement, consider that Marxian materialism is the conjunction of two distinct claims, an ontological claim and a social scientific one. The ontological claim is that what exists is material, that is, physical objects in space. Mind and spirit, in any immaterial sense, are chimera. From the start the spirit is afflicted with the curse of being burdened with matter, which here makes its appearance in the form of agitated layers of air, sounds, in short, of language. German ideology, p. 19. The social scientific claim is that the way in which a society is organized for the production of the material conditions of its existence and reproduction, the mode of production, plays the chief, though by no means the only, causal role in determining the nature and occurrence of social events. The mode of production of material life conditions. The social, political, and intellectual life process in general. 8. According to this social scientific claim, the belief that societies are shaped primarily by their members' attitudes, or that history is shaped by the progressive development of knowledge or ideals, is false. Rather, it is primarily the organization of production that shapes people's attitudes, and the progressive development of modes of production that shapes history. That is to say, we do not set out from what men say, imagine, conceive, nor from men as narrated, thought of, conceived, in order to arrive at men in the flesh. We set out from real, active men, and on the basis of their 220 real-life process we demonstrate the development of the ideological reflexes and echoes of this life process. German ideology, p. 14, it is not the consciousness of men that determines their being, but, on the contrary, their social being that determines their consciousness. 9. Of these two claims, the social scientific is more restrictive than the ontological. The ontological claim requires only that we attribute ideology to material realities, be they brains or agitated layers of air or modes of production. The social scientific claim requires that among these material realities, priority be given to the mode of production as the primary cause of ideological beliefs. This means that the main source of false ideology is to be found not in the perceiving subject but in the perceived objects. It is not a subjective illusion, the result of faulty perception by individuals of their material conditions, but an objective illusion, the result of more or less accurate perception of those conditions. 10. Viewing ideology this way has the added benefit of leaving the door open just wide enough so that the theory of ideology does not exclude the possibility of all true beliefs and thus of the very science upon which it is based. A materialist theory of ideology, then, must show that false ideology is an objective illusion arising primarily from more or less accurate perception of the organization of material production, rather than from some subjective error. 11. Bear in mind that this is a matter of placing primary emphasis on objective factors, not of absolutely excluding subjective ones. We can fix the idea of an objective illusion by considering a very common example of one, namely, the illusion that the sun goes around the earth. Any illusion, any erroneous belief that an individual holds, can be stated as a subjective error, but not every erroneous belief arises primarily because of a subjective error. A person who believes that the sun rises above a stationary horizon in the morning makes a mistake. However, this sort of mistake differs crucially from, say, the mistake that a color-blind person might make of believing that the light is green when it is red, or the mistake a person balancing her checkbook might make of believing that a number is 4 when it is 2. In these latter cases, the mistaken beliefs are not merely held by the individuals, they arise in the individuals primarily as the result of a defective perceptual faculty or misuse of a sound one. These are subjective illusions. In these cases, correcting the defect in the perceptual faculty, or in its use, should undo the mistake. The mistaken belief that the sun goes around the earth, by contrast, arises as a result of a sound perceptual faculty properly exercised. This is an objective illusion. Neither healthier vision nor looking more carefully will enable an individual to correct this mistake and see that what occurs at dawn is not the sun rising above the horizon, but the horizon tipping down below the sun. The ideology of capitalism is the illusion that capitalism is non-coercive. This illusion is a mistake of the same type as the illusion that the sun goes around the earth. What corresponds in capitalism to the movement of the sun seen from the earth is the free exchange of wages and labor power between capitalists and workers. That the sphere of exchange is the objective basis of ideology is recognized in effect by Marx, when he writes that this sphere, within whose boundaries the sale and purchase of labor power goes on, is in fact a very Eden of the innate rights of man. There alone rule freedom, equality, property. Freedom, because both buyer and seller of a commodity, say of labor power, are constrained only by their free will. Capital, Volume 1, p. 176. The normal perception of what goes on in exchange gives rise to the ideological illusion that capitalism is 221. Uncoercive. This is not because the freedom in exchange is an illusion. The fact is that, for Marx, capitalism works only because the moment of exchange, through which the circuit of capital continually passes, is truly free. For the conversion of his money into capital, therefore, the owner of money must meet in the market with the free laborer, free in the double sense, that as a free man he can dispose of his labor power as his own commodity, and that on the other hand, he has no other commodity for sale, is short of everything necessary for the realization of his labor power. Capital, Volume 1, p. 169. That the second of these senses of freedom is the worker's freedom from ownership of means of production does not deny the reality of the first sense, without which we would have slavery or serfdom rather than capitalism. In exchange, the power that capitalists have over workers recedes from view. If we distinguish two sorts of power, the power to withhold one's commodity until offered something preferable, and the power to command obedience and back this up with violent force, then it is clear that, in the sphere of exchange, the latter power is suspended and all that remains is the former power. This former power is a power that all parties to the exchange have equally. Thus, the unequal power of capitalist and worker appears as their equal power to withhold from exchange what they happen to own, and their social inequality appears as the difference between the things that they happen to own. To use the famous words of Marx's analysis of the fetishism of commodities, a social relation between men assumes, in their eyes, the fantastic form of a relation between things, Capital, Volume 1, p. 72. If this accurate perception of what goes on in exchange is to explain how capitalism appears uncoercive, we need to understand how the sphere of exchange, which is only part of capitalism, should be the source of beliefs about the whole of capitalism. Why should the experience of freedom in exchange, rather than, say, the experience of taking orders on the production line, determine the beliefs that members of capitalist societies come naturally to have? How is the representation of exchange generalized into a view of capitalism as a whole? Marx offers a clue to the answer to this question when he says that the fetishism of commodities results because the producers do not come into contact with each other until they exchange. Capital, Volume 1, p. 73. Exchange transactions are the salient points of social contact for economic actors in capitalism. They punctuate capitalist social relations. Every social interaction between individuals playing roles in the capitalist mode of production begins with such a transaction, say, the signing of a wage contract exchanging labor power for money, and can be ended with such a transaction, say, the dissolution of the wage contract. Each of these beginnings and endings is characterized by the absence of either party having the power to command the other's obedience and use violence to get it. Each party knows that he can enter or withdraw from any capitalist social interaction without being subject to the command or the overt force of the other. What constraint either feels seems to be only a matter of what they happen to own, which naturally appears as a feature of their own good or bad fortune rather than a condition coercively imposed by the other. Thus, all capitalist social interactions, not just the exchanges themselves, appear as voluntary undertakings between equal people who happen to own different things. Exchange accurately perceived and then generalized is what leads workers in capitalist societies to believe. 222. That they are free, although they take orders most of their waking lives. Thus, ideologically false beliefs about capitalism result from accurate perception of exchange, when the rest of capitalism is, by default, assumed to be more of the same. The law follows suit. 223. Ideology and law. Law, wrote Marx in The Poverty of Philosophy, is only the official recognition of fact. 12. For capitalist law, the fact is exchange. Law in capitalism is the official recognition of the fact of the economic relations in which the exchangers stand to one another. This insight, which will guide the materialist explanation of criminal law that I shall develop in this section, must be credited to the work of the Soviet legal theorist Yevgeny Pashikhanes, whose general theory of law and Marxism was published in Russian in 1924. 13. Among the things for which Pashikhanes argued was that law was a product of capitalism and consequently had no legitimate place in socialism. As Stalin took firm control of the Soviet Union and saw fit to use the law to shore up that control, Pashikhanes came eventually into disfavor. He recanted his views to some extent, but it was too late. By 1937 he had been declared an enemy of the people, and he disappeared shortly thereafter. Recently rediscovered by Western Marxists, Pashikhanes's work was first the object of lavish praise and subsequently the target of harsh criticism. I do not intend to endorse or defend the whole of Pashikhanes's theory. He aimed at a general theory of law and made only a few observations about criminal law, which is my main concern here. I shall try to show that his basic insight about the relation between law and exchange can be developed into an explanation of the content of the criminal law and of the constitutional protections relevant to criminal justice. Marx writes that parties to an exchange must behave in such a way that each does not appropriate the commodity of the other, and part with his own, except by means of an act done by mutual consent. They must, therefore, mutually recognize in each other the rights of private proprietors. This juridical relation, which thus expresses itself in a contract, whether such contract be part of a developed legal system or not, is a relation between two wills, and is but the reflex of the real economic relation between the two. Capital, Volume 1, pages 88 to 89. Exchangers must in fact refrain from forcing those with whom they would trade to part with their goods or services or money. Official recognition of this fact takes the form of granting to exchangers the rights of private proprietors. Because this recognition is related to the ideological failure to perceive the coerciveness reproduced in exchanges between proprietors of capital and proprietors of labor, exchanges are understood legally as acts of the free will of the parties as long as no overt violence is used or threatened. Consequently, exchangers treat one another as free subjects whose freedom is expressed in their right to dispose of their property without interference from others. It is the difference between what capitalists own and what workers own that, for Marx, makes it possible to reproduce a coercive relation through free exchange. If the law follows ideology in representing the relation between exchangers as non-coercive, then the law must abstract from this difference in what is owned and treat each party as having the same right to dispose of his property regardless of what that property is. The law reflects this in its formality. The legal right of property is an empty form to be filled in with different content, depending on what an individual owns. Capitalists and workers have the same right of property, they just happen to own different things. It just happens that what some people own are factories and what others own are their bodies, but their property rights in these things are the same. Their freedom to dispose of their 224 property also is the same. 14 Thus, exchangers treat each other as equal free subjects with equal property rights. That is to say, as legal persons. 15. We saw in the previous section that ideology is not to be understood as merely a subjective illusion. Ideology reflects the real way in which capitalism appears to its participants. By the same token, the ideological nature of law reflects the real relations in which exchangers stand to one another. The written law, even the institutions of law, from lawmakers to law enforcers, are not the source of law. They reflect real, objective relations between members of a capitalist society, relations that exist, so to speak, on the ground first, and only later on the page or in the courts for that matter. It is here that the inversion of which Engels wrote does its ideological work. Although the law is a reflection of the relations of exchangers on the ground, it appears that the law is an expression of rationality itself, with the consequence that the relations among exchangers seem so as well. Here, however, a problem arises for the Marxian materialist. If law is the reflection of the actual practice of economic exchange, how does law come to function as a norm? A simple reflection would represent whatever occurs and thus could not identify some actions as infractions. How can the materialist account for the normative dimension of law that arises as a reflection of economic relations? The answer to this is that law is not a simple reflection of economic relations, but an idealized reflection. Actual exchanges will be characterized by the full range of violations and deviations, from failure to meet agreed upon deadlines to gross expropriation with the threat or use of violence. Such violations tend to undermine the likelihood of the same parties exchanging again, because it is generally in people's long-term interest that stable trading relationships be maintained, it will generally be in people's interest to eliminate such violations. Accordingly, over time the vast majority of exchanges, particularly those between people in continuing exchange relationships, will tend to be free of violations. Thus, an average core of exchange, characterized by absence of violence and fraud as well as by dependable fulfillment of agreements, will emerge as the norm. The law in general will represent this norm. This tendency to go from what happens on average to what is normative is a common feature of human social existence. People tend to take what usually happens as what should happen. This tendency of the statistical norm, what people can generally be expected to do, to become the moral norm, what is expected of people, is visible in early civilization, where, for example, natural and moral law are not distinguished from each other, and in advanced civilization, where, for example, existing business practice is often taken by courts as creating legally enforceable obligations. This brings us to a second question. It would seem that law that reflects, even the idealized average core of exchanges would include not only the criminal law but also what we currently understand as contract or civil law. How can the theory that traces law to exchange account for the nature of the criminal law per se, with its special content and its unique remedies? To answer this, note first that there is considerable overlap in the content of criminal and civil law. Criminal acts, such as theft or battery, also can be causes of civil action. This overlap, however, is largely asymmetrical. Virtually any criminal act can be a cause of civil action, but only some civil causes are subject to criminal prosecution. This suggests that the criminal law is more distinctive in its remedies than in its content. In general, criminal prosecution seeks punishment of the guilty, and civil action seeks recovery of damages from the one responsible for a loss. Now, on the materialist theory, both sorts of law, criminal and civil, represent 225. 1. 2. The essential core of normal exchange and aim to rectify violations of or deviations from that core. Thus, to explain the nature of the criminal law per se, we must show why some class of deviations from normal exchange is singled out for the distinctive criminal remedy, namely, punishment. Because punishment is generally a graver matter than recovery of damages, we should expect the criminal law to be addressed to the most serious violations of normal exchange, whereas the civil law can be addressed to all violations. Violations of normal exchange can be distinguished in the following way: some threaten the very possibility of free exchange by depriving people of the ability to dispose of their property. Other violations threaten not the possibility of free exchange but its success in meeting the wishes of the exchangers. What threatens the very possibility of exchange are acts of violence that overtly block the capacity of individuals to exercise their wills, acts of theft that overtly bypass the capacity of individuals to choose how their property is disposed of, and acts of deception that have the same effect, so to speak, behind the backs of their victims. These are so serious that they must be prevented in advance and that requires a standing threat of punishment. Accordingly, the criminal law is primarily aimed at acts of violence, theft, and fraud. 16. Less serious violations are compatible with the existence of exchange, but cause exchanges in some way to fall short of the legitimate expectations of the exchangers. These violations are mainly failures to live up to the terms of explicit or implied contracts. They can be remedied by requiring performance or payment from the one responsible. These are suitable targets for the civil law, although nothing is lost by allowing the civil law to apply to recovery of losses due to the more serious violations as well. On the whole, then, although the entire law in capitalism reflects the conditions of normal exchange, the Content of the criminal law is composed of those acts that threaten the very possibility of normal exchange. These are the acts that are identified as crimes. Moreover, because the normal relations of exchange are not only idealized but also, as we saw in the previous section, generalized to the whole of capitalism, they will shape people's normative expectations beyond exchange. Thus, they determine the limits that will be imposed on officials tasked with the job of finding and prosecuting criminals, the shape of court proceedings, the relation of punishment to offense, and the emphasis on the free will of the offender. Accordingly, by tracing law to its source in exchange, we can account for at least the general content of criminal law and the general shape of the criminal justice system and of the constitutional limits within which that system operates. Here, briefly sketched and numbered for ease of identification, are the main ways in which this works. Normal exchange presupposes that people are treated as having property rights in whatever they are to trade, and that must mean not only goods but their bodies as well, because bodily actions are what workers trade with capitalists for their wage. Crime, then, is any violation by one individual of the property rights of another in whatever he owns, including his body. This explains why the criminal law is directed primarily against acts of violence, theft, and fraud. Moreover, because criminal law protects an individual's body because he owns it, and not, say, because it is the earthly vessel of his immortal soul. The law will be concerned primarily with injuries done to people's bodies against their will otherwise. Such injuries do not violate the individual's ownership of his body. This accounts for the liberal principle. Volenti non fit injuria, no injustice is done to one who consents, and thus, via generalization, for the tendency in capitalism to decriminalize, or reduce in importance, victimless crimes or morals offenses. This account also tells us what we are not likely to see as crime in capitalist society, namely, exercises of 226. 3. 4. The power inherent in the ownership of property itself. Thus, we will not generally find that death due to preventable dangers in the workplace will be taken as murder, because that would assume that the worker was somehow forced into the workplace by the power inherent in his boss's private ownership of the means of production. Because that is just the power that is invisible in capitalism, the worker is taken as freely consenting to his job and thus freely accepting its risks. Accordingly, when the criminal law is used against employers to get them to eliminate occupational hazards, it is never with the understanding that employers who do not eliminate such hazards are violent criminals. If the criminal law is used in these cases at all, it is as a regulatory mechanism applied to employers because this is the most efficient way to reduce the social costs of occupational injury and disease. The treatment of guilty employers is generally light-handed, even though far more people lose their lives due to preventable occupational hazards than as a result of what the law currently treats as murder. In capitalism, subjection to one person is seen as arbitrary and thus unlawful coercion, but subjection to the capitalist class is not seen at all. Here is how the Marxian theory understands the phenomena discussed in the main text of this book and accounted for with the historical inertia explanation. The other side of criminal law, the limits placed on legal officials in their pursuit of suspected criminals. For example, in the Bill of Rights, likewise reflects the generalized conception of people as owners of their bodies and other property. Accordingly, we find protections against official invasions of suspects' property, for example, the Fourth Amendment protections against unreasonable search and seizure, and against penetration of suspects' bodies or minds, for example, the Fifth Amendment protection against self-incrimination. Moreover, this explains why corporal punishment, which was the norm in feudalism and slavery, tends to be eliminated in capitalism. The bodies of slaves are literally owned by their masters, and lords have natural, that is, parent-like, authority over their serfs. In those cases, corporal punishment fits the existing social relations. In capitalism, employer and employee meet as owners of their respective bodies, and thus corporal punishment looks increasingly out of place. The existence of these various limitations on what can be done to enforce the law is evidence that the Marxian view of law includes recognition of the way law functions not only to control the working class but also as a limit on the behavior of the ruling class. Indeed, the Marxian view can be taken as claiming that it is precisely as a system that protects everyone alike in their property, including their body, by limiting both what citizens and law enforcers can do to the bodies, and other property, of other citizens, that the law most effectively serves the purpose of keeping the working class selling its labor power to the owners of means of production, both classes safe in the knowledge that no one can interfere with their right to dispose of what they happen to own. As crime is a violation of normal exchange, punishment is thought of on the same model of equivalence as exists in exchange. Punishment emerges as an equivalent which compensates the damage sustained by the injured party. 17. The commercial model doesn't end here. The adversary system reproduces it in court. The public prosecutor demands a high price, that is to say a severe sentence. The offender pleads for leniency, a discount, and the court passes sentence in equity. 18. Crime deforms exchange by taking with force rather than payment. Punishment restores exchange by using force to pay back the criminal for his force. This is the tribute in retribution. The court is the extraordinary market where this extraordinary exchange is negotiated. The scales in justice's hands are the same as those used by the 227. 5. Merchant. Because exchange normally brings payment to an individual only when she freely chooses to offer up her goods or services for it, the payment of punishment comes due only when the offender has freely chosen to commit the offense for which the punishment is payment. Accordingly, liability for punishment is subject to conditions of the same sort as apply to liability to contractual obligations. One is not bound by a contract that she has not signed freely, or that she signed while insane or in ignorance of its contents, and so on. Likewise, the offender is liable to punishment, and thus is truly a criminal, only if he has committed his violation freely, sanely, and with knowledge of what he was doing. By the same logic, the law generally prohibits ex post facto attribution of criminal liability because a person cannot choose freely to violate a law before it has been passed. Here, then, we read off the face of exchange, albeit idealized and generalized, the main contours of criminal justice as it develops in capitalism. As I suggested at the outset, this is no more than a skeleton. It does not aim to account for the full, rich detail of any particular criminal justice system. Actual criminal justice systems exist in societies with other modes of production present alongside capitalism, are affected by the complex interplay of human actions, and so on, so that each actual system, like each actual face, will have a distinct physiognomy while sharing in the basic structure. Some criminal justice systems will be slower in eliminating morals offenses, some will be stricter on occupational hazards, some will abolish the death penalty while others will retain it, and so on. 19. These specific outcomes will be a function of the strength that various social groupings, such as religious organizations, labor unions, academia, the press, and the like, come to have in the specific history of specific countries, and of all the largely unpredictable features that determine the outcome of particular battles over the content of the law and the funding of the legal apparatus. This notwithstanding, The Marxian claim is that criminal justice, principles and systems, in capitalist countries will tend toward the shape sketched out above. 228. Law and Ethics. We now reach the question of the moral stance toward capitalist criminal justice that is appropriate if the Marxian account is correct. Marxism describes capitalism as an exploitative system, meaning one in which workers are forced to work for capitalists without compensation. Marxists characteristically regard exploitation, and consequently capitalism, as unjust or immoral. Broadly speaking, they reach this condemnation by one of three routes. One is to view capitalist exploitation as wrong because it promotes antagonistic or alienated relations between human beings. 20. The second way is to view capitalist exploitation as wrong because it is a form of forced servitude or slavery. 21. The third way is to view capitalist exploitation as wrong because it is based on an unjust distribution of wealth, namely, the unjustifiable exclusive ownership by a few of the means of production. 22. I shall call these three views, respectively, the alienation charge, the slavery charge, and the maldistribution charge. Each of these has moral implications for capitalist criminal justice. The task of identifying these implications is simplified by the fact that the second and third charges incorporate each other. The slavery charge accepts that private ownership of means of production is a case of unjust maldistribution, because it is a means of forcing servitude, and the maldistribution charge accepts that private ownership of means of production is a means of enslavement, because it is a power wrongly monopolized by a few. For our purposes, then, the charges against capitalism can be reduced to two, the alienation charge and the slavery, maldistribution charge. Those who raise the alienation charge point out that capitalism is a system in which each person's well-being is in conflict with that of others. Capitalism pits class against class, competing over the division of the economic product into wages versus profit, worker against worker, competing for jobs, and capitalist against capitalist, competing for market shares. Moreover, proponents of this charge hold that antagonism of interests is neither a necessary feature of human life nor a desirable condition. It is caused by capitalism. It was less marked in feudalism and might be eliminated in the future if a more cooperative arrangement, such as socialism, could be established. Criminal justice as it emerges in capitalism is understood as a means to regulate this antagonism of interests. Because it assumes that this antagonism is inevitable, criminal justice serves to confer permanent validity on capitalism. Moreover, criminal justice promotes this antagonism by teaching people that the rights of each are in conflict with the rights of others rather than mutually supportive. That freedom is freedom from invasion by others rather than freedom to develop with others, that what people owe each other is non-interference rather than a helping hand. Also important is the fact that a society based on antagonism of interests is one in which people earn their daily bread only as long as someone else can profit as a result. When that changes, workers may find themselves in need and with little in the way of help from the rest of society. On this view, then, the high crime rates characteristic of capitalism are due to the fact that people in capitalism are taught to see their interests as in conflict with others, and thus they are trained to have limited altruism and fellow feeling, and to the fact that a society based on antagonism of interests is one in which economic need and insecurity are endemic. When limited fellow feeling meets economic need and insecurity, the result is crime. Recall the views of Bonger and Gordon, discussed in Chapter 4. The same system that calls criminals individually guilty, then, is responsible for the antagonism of interests that breeds crime in the first place. The upshot of this charge is that criminals are not, or at least not wholly, guilty of the crimes they commit. On this charge. 229. Criminals are in large measure unjustly punished for actions caused by the very system that punishes them. On the slavery, maldistribution charge, the emphasis is on the wrongness and coerciveness of private ownership of means of production. Capitalism promotes a system of criminal justice based on protecting the freedom of individuals to dispose of what they rightly own, but the system itself is based on the wrongful appropriation of means of production, and with it the power to coerce others to labor without compensation. On this view, socialism would cure capitalism not so much by replacing antagonism of interests with harmony, but by replacing private ownership of means of production by a few with social ownership by everyone. To understand the moral implications for criminal justice of this charge, imagine for a moment that we see someone take a sheep from a field owned by another. In response, suppose that we make the normal judgment that a theft, an unjust expropriation, has occurred. Now suppose further that we learn that the field owner had himself stolen the sheep from the sheep taker some time before. According to these new facts, we shall change our views about the moral status of the sheep taking. Now we are likely to say that the one we saw take the sheep was not, morally speaking, a criminal but the opposite, a victim responding justifiably to an earlier crime. Likewise, if we come to see ownership of means of production as itself a violation of justice, because it is unjustly maldistributive or unjustifiably coercive, we will see the crimes that people do in response to it as more just than they appeared when we didn't question the justice of ownership of means of production. Recall the discussion in Chapter 4 of how a judgment that an individual is guilty of a crime presupposes that the social context in which his act occurred was just. By the same logic, judgment that the social context is unjust weakens the judgment that the individual is guilty of a crime. On the slavery, maldistribution view, then, the individuals normally labeled criminal are seen as the victims of a prior crime to which they are responding. That criminals may not, and usually do not, see themselves as doing this only reflects the fact that they are taken in by capitalist ideology no less than law abiding folks are. The criminal, then, is not a doer of injustice, but the reverse. He is a victim of injustice, trying to improve his situation by means that have been made necessary by the fact that capitalism leaves him few alternatives. The upshot of this charge is that criminals are not really morally guilty. They are in large measure unjustly punished for reacting against crimes perpetrated by the very system that punishes them. In sum, the Marxist critique of criminal justice does lead to a moral condemnation of criminal justice under capitalism. This moral condemnation comes in two forms, both of which share the claim that capitalist criminal justice wrongly punishes people who do not deserve to be punished. In the first form, the alienation charge, criminals are thought not to deserve punishment because their acts are caused by socially conditioned antagonism to their fellows in conjunction with limited and unstable opportunities to satisfy their needs and desires. In the second form, the slavery, maldistribution charge, criminals are thought not to deserve punishment because their apparent crimes are legitimate reactions against conditions that are themselves, morally speaking, criminal. Needless to say, it is possible for the same person to endorse both forms of condemnation. Several things that apply to both charges are worth noting. First of all, in both cases, the features of capitalist criminal justice that come in for ethical condemnation reflect the failure to see the way criminal justice reflects the mode of production mentioned at the outset. In the case of the alienation charge, the failure is that of not seeing that capitalist criminal justice emerges to regulate the antagonistic relations 230 between human beings that capitalism produces. Seeing capitalist criminal justice as the product of independent reason, it sees those antagonistic relations as a natural feature of human life that always must be so regulated. Then, capitalist criminal justice rather than protecting the interests of capitalists appears merely to be the necessary condition of any peaceful social coexistence. In the case of the slavery, maldistribution charge, the failure is of not seeing how property in capitalism is an expression of a particular and morally questionable constellation of social forces. Seeing capitalist criminal justice as the product of independent reason, it sees the property that criminal justice protects as a natural feature of human life that is always in need of such protection. Then, capitalist criminal justice, rather than protecting the interests of capitalists, appears merely to be protecting everyone's interest. What's more, it follows that the continued and heavily publicized activities of criminal justice serve to reinforce ideological blindness, on the first view, blindness to capitalism's role in causing the alienated and antisocial attitudes and conditions that lead to crime, and, on the second view, blindness to the moral dubiousness of capitalist property relations. It also must be borne in mind that the ethical implications of both charges are general propositions that will fit actual criminals in varying degrees. For example, while the alienation charge suggests that criminals are not culpable because they are shaped by an antagonistic society, in actual cases the degree to which individual lawbreakers have been so shaped will vary. There may be some who have largely escaped the deleterious influences and yet, out of selfishness or greed, commit crimes. Marxism naturally claims that the number of criminals of this sort is small compared with the number of criminals all told. Marxism, however, need not deny that there are some criminals like this and that they deserve punishment. Likewise, on the slavery maldistribution charge, whereas criminals are generally taken to be victims of the prior injustice of private ownership of means of production, actual criminals differ in the degree to which they are so victimized and in the degree to which their actual crimes can be thought of as reactions thereto. Relatively privileged persons, or others whose crimes bear little relation to their class position, some rapists, for example, may well be more culpable than the general run of criminals. It seems to me appropriate for Marxists to view responsibility and thus guilt as existing in varying degrees, relative to the actual impact of the social structure on a given individual's criminal act. Finally, note that on neither of the two views we have discussed does the criminal emerge as any kind of proto-revolutionary, as is sometimes asserted of Marxism. On the alienation charge, the criminal is at best relieved of responsibility because he has been shaped by the social system to have antisocial attitudes and fated by that system to experience need and insecurity that, together with those attitudes, lead to crime. On the slavery maldistribution charge, the criminal is at best a victim because he is the object of the unjust coercion or expropriation characteristic of private ownership of means of production. His crime, rather than being a kind of rebellion against what victimizes him, is most often a narrowly self-interested striking out against whatever he can get his hands on. On both charges, Marxism does imply reduced or no blame for most criminals, but it does not imply any celebration of their acts. This is particularly so in light of the fact that most victims of crime are other exploited people, members or would-be members of the working class. Crime and criminality must on the whole be placed by Marxism among the costs of capitalism, lined up alongside poverty, unemployment, pollution, and the rest. Appendix 2. 235. Between Philosophy and Criminology. Jeffrey Ryman. Though the rich get richer and the poor get prison is more frequently assigned in criminology courses than in philosophy courses, it raises a philosophical question, perhaps the central philosophical question of criminology, namely, what should be a crime, and it aims to use that question to shed a special kind of light on the criminal justice establishment in the United States, but I suspect as well on just about any criminal justice system anywhere. 2. I say this by way of introduction because my aim here is to explore the relationship between philosophy and criminology. In light of criminology's multidisciplinary nature, however, criminology might be thought already to include philosophy. Thus, to be precise, I should say that I want to explore the relationship between philosophy and the non-philosophical aspects of criminology, that is, between philosophy and criminology, considered as a social science. In general, this is what I shall mean when I speak of criminology. To give you a hint about where I am headed, I shall argue that criminology needs philosophy, and not only in the way that, as I also believe, everything and everyone need philosophy, but also in very special ways. For example, I shall argue that criminology has a special need for philosophy because criminology is in the unusual position of being a mode of social inquiry whose central concept crime is defined officially by governments. We hear a lot these days about the politics of knowledge and of research, but this is politics with a vengeance. Politics openly, necessarily, insinuates itself into the heart of criminology. Political systems hand criminology a ready-made research agenda. And so I shall argue that criminology needs philosophical reflection on the concept of crime in order to establish its intellectual independence of the state, which to my mind is equivalent to declaring its status as a social science rather than an agency of social control, as critical rather than servile, as illumination rather than propaganda. This is not, however, where I shall start. Rather, I will start, so to speak, at the outer ring of a series of concentric circles, by indicating the philosophical assumptions that I think are necessary to all forms of social science. I shall proceed from there to talk about the philosophical assumptions that I think are special to criminology, the ones it especially needs. And then, arriving at the smallest inner circle, I shall say something about my own particular philosophical commitments, the ones that underlie the rich get richer and the poor get prison. I hope that somewhere along the line, readers will recognize some of their own philosophical assumptions, and thus be in a better position to reflect on them, to consider what else they entail, and to decide whether in the end they are ready to endorse them explicitly, or want to consider others. Before starting this, I want to make one thing clear. I shall be talking about what criminology needs, but this is shorthand for what I think people who practice criminology need in order to do criminology in a coherent and plausible way. Moreover, when I say, for example, that criminology needs a theory of crime, I do not mean that it needs one particular theory. This too is shorthand, in this case for the idea that everyone who practices criminology needs some theory of crime, not that all need the same one. I put these all as claims about what criminology needs rather than as about what criminologists need, to emphasize that the needs are disciplinary and conceptual, not personal or psychological. 236. 237. Philosophical assumptions of social science generally. First of all, to engage in social science, you must believe that there is such a thing as society, and that it can become an object of knowledge. That there is such a thing as society means that there are real human beings in real social relations, in a real world, manipulating real objects, and so on. That there can be knowledge of society means that knowledge is possible, and that we can know when we have got some. In short, a social scientist cannot be a thoroughgoing ontological skeptic or agnostic. 3. He or she cannot suppose that society is only an idea or a construct, and all the more so, he or she cannot suppose society to be an illusion. Nor can a social scientist be a thoroughgoing epistemological skeptic or agnostic. For to seek knowledge of society is to assume that such knowledge is possible for us. Along the same lines, I believe that social scientists must believe it is important to aim at scientific objectivity, and that this aim can be adequately achieved. Some authors writing about the development of modern science in the time of Bacon and Galileo speak of the attempt at scientific objectivity as nothing but following certain conventions aimed at giving science a higher status than, say, religious inspiration. 5. My claim is that, even if the attempt at scientific objectivity is this, it cannot be only this. No one could use conventions of objectivity without believing that they were effective ways of getting at the way things are, any more than one can use language without believing that one is speaking about things beyond the words one uses. Even those who think of objectivity as just so many conventions, think that that is the objective truth. They think that they are telling us the way things are, not the way they would like them to be. Notice here that I am not claiming that we always succeed in freeing ourselves of our biases. What a social scientist must believe is that the attempt to represent the world as it is, as opposed to how we wish it were, can succeed generally and does succeed in many particular cases. In affirming that, as social science, criminology must presuppose that there are real people performing real actions in a real world and that we can have knowledge of them, I do not mean to resurrect some hoary positivistic model of science. I grant that the facts we study may be the product of the interaction of beliefs and language and objects. However, for the study of those facts to be fruitful, the process by which beliefs and language and objects interact must itself be knowable as an objective reality. It is a general philosophical requirement of social theorizing that one's theory leave open the possibility of its own status as knowledge. This is a test that many statements of postmodernist theory, and of relativism generally, seem to me to fail. Even as their practitioners produce valuable objective knowledge in spite of what they say they are doing. Before leaving the discussion of the general philosophical requirements of social science, I want to say a word about value neutrality. Value neutrality is related to objectivity, but it's not the same thing. Later I shall suggest that criminology needs some value commitments, at least to some conception of justice. Thus, I do not think that criminology should be value neutral all the way down, even though I think it should aim at objective knowledge. There is no contradiction here. The point is this. I believe that the proper study of crime requires taking some position on the justice of the social system in which certain acts are treated as criminal. Suppose that I make explicit the ideal of justice that I endorse. This doesn't mean I am no longer objective. First of all, I believe, and I may try to show, that my ideal of justice is appropriate, not merely what I want or what serves my interests. Second, and equally important is that, once I have stated my ideal of justice, I want to know objectively whether or to what extent 238. That ideal is realized. If I misperceive or bend the facts because I want to show that the criminal justice system is unjust, I fool myself as much as anyone else. I am not honestly committed to my ideal of justice unless I am willing to apply it as objectively as I can. I turn now to consider the special philosophical needs of criminology. 239. Special philosophical needs of criminology. I shall make 3 arguments aimed at showing that criminology has a special need for philosophical reflection. First, I will contend that criminology has such a need because it is a multidisciplinary study and thus requires an explanation for why crime is worthy of its own organized inquiry. Second, I will make the political argument for criminology's need for philosophy, at which I hinted in my opening remarks. And third, I will argue that the need for philosophy arises from the topic itself, that crime cannot be studied without coming to some judgment about its moral status, which requires philosophical reflection. Consider first the fact that criminology is a multidisciplinary mode of inquiry. The traditional disciplines, history or sociology or philosophy, are not defined by their topics. Rather than study something in the world, some problem or problem area, they study everything, but from a particular angle. Criminology is the reverse. It studies the problem area of crime and criminal justice, from a wide variety of angles. But, then, why this problem area? What makes crime an interesting focus of study? That it is crime, or a violation of a rule, is not enough of an answer. Why not study people who cheat at solitaire, or those who arrive late for dates with friends, or drivers who fail to put on their turn signal before turning left, or folks who have bad manners, or speakers who say NT? They are all rule violators. And these rule violations are all subject to penalties of some sort, but hardly worth devoting a special discipline to their study. What makes crime worthy of its own study? Since the mere fact that crime is a rule violation does not earn it special treatment, the mere fact that it is a law violation will not do so either. Responding to this need for explanation requires you to say what you think. Crime is, such that it is an important occurrence in a society. Is crime a breakdown in social order, an alternative career route, a way of coping with acute need or insecurity, a rebellion against injustice, a cry for help, a form of play, a form of self-defense, an exciting walk on the wild side, a symptom of individual or social pathology, a label and accompanying treatment applied for political purposes? Choosing among alternatives like these requires you to say what you think a society is, such that crime is important to it. Is society a rational association among individuals, a site of conflict or consensus or of continual negotiation? Between the two, is it a mechanism of control of labor and resources, a struggle among classes, a pluralistic ragbag of interest groups? I do not mean to suggest that these ways of thinking about crime and about society exhaust the possibilities. My point is that unless you have some thought like this about crime and society, you don't really have an answer to why crime is worth studying. And, then, you do not have an answer to why there should be a field of social inquiry devoted specially to the study of crime. A thought like this about crime is a theory of crime. And a theory of crime is a part of a theory of society. And a theory of society is a work of philosophizing. To move now to the political dimension of the issue, consider this question: what's the difference between what criminologists do and what the FBI does in compiling the annual Uniform Crime Report, UCR? Both seek to amass and disseminate knowledge about crime, both chart trends and correlations. There are numerous differences, but one is, to my mind, of chief importance. The UCR simply accepts the legal system's definitions of crimes as well as the legal system's grading of their gravity. It needs no more; in fact, it would exceed its mandate if it varied from this. But criminology cannot simply accept the legal definition of crimes and the legal system's determination of their gravity, because criminology is not a branch of law or of the legal 240 system. Unless criminologists have their own view of what crime is and what makes it especially important, if they simply study what the legal system calls crimes in the order of gravity the legal system assigns them, then criminology accepts the research agenda handed to it by the government. Criminology is then an arm of the state. Even if it comes up with some news that the state would rather not hear, it is doing the state's work, which is to amass and disseminate knowledge about law violations. To affirm its intellectual independence from the state as a social science, criminology must look at crime, while staying open to the idea that the legal definitions and, just as crucially, all the righteous beliefs that normally surround a legal enterprise are less than the whole truth, and perhaps even misleading or ideological. This means that criminology must keep its distance from the legal system as such, and this in turn requires that criminology seek its own understanding of what crime is. And I contend again that this requires a theory of crime, and a theory of crime is part of a theory of society, and a theory of society is a work of philosophizing. You may think that this argument only amounts to showing that criminologists need a bit of social theory, which may be an interesting fact, but not very startling. You may think that social theory is a thing different from social philosophy, something that sociologists do rather than philosophers. I disagree. I think that social theorizing is philosophizing, but that doesn't mean that it can or should only be done by philosophers. Every discipline has a place where it overlaps with philosophy, where its questions become philosophical questions. When art historians ask what art or beauty is, when psychologists ask what a mind is, when political scientists ask what a state is, and when sociologists or criminologists or anyone else asks what crime or society is, the questions they ask are philosophical ones. One clear reason that they are philosophical questions is that they are distinctively about the validity of norms or criteria. What makes the Mona Lisa beautiful? What makes a property mental rather than physical? When is a group a state? What should be prohibited by criminal law? To be sure, sociologists and others also study norms and criteria. Their focus is on the existence and consequences of norms and criteria. The questions that are distinctive to philosophy are those about the justification of norms and criteria. Philosophy aims to evaluate their credentials and, where those credentials pass muster, to defend the norms and criteria as valid ones. That said, be clear that I do not think that philosophical questions can only be asked or competently answered by people with PhDs in philosophy. I think rather that whoever answers them should recognize that he or she is no longer in the realm of empirical scientific endeavor, but is engaged in the conceptual and normative reflection that is properly philosophy's domain. I do not want to leave the issue here. There is a dimension to the theorizing needed about crime that I think is uncontroversially philosophical. We reach this dimension by recognizing that crime is a violation, and not just any old violation. It is not just the sort of rule violation that is involved in saying NT. It's not the sort of violation that occurs when someone cheats at solitaire. Because crime affects other people and often in very serious ways, it is a morally consequential act. And, as a result, you cannot say what crime is without taking a position on its moral status. That in turn will require a position on the moral obligation to obey the law. I am not saying that you must believe that the criminal does a moral wrong or violates a moral obligation. My point rather is that you must have some position on this. You cannot be neutral. If you are neutral, you treat crime as no different from any old rule violation, which is less. 241. Then what crime is, and thus a distortion of your object of study. This, then, is my third argument. Crime itself requires moral assessment. To be studied, it must be identified for what it is, and that includes its moral nature. Even if you do not think that criminals violate a moral obligation in committing crimes, you probably do think that many, if not most, crimes would, under normal circumstances, constitute immoral actions. After all crimes with victims violate the golden rule. The criminal does things to people that he wouldn't want done to him. And this is important. It constitutes, so to speak, the default position on the moral status of crimes. Suppose you think that violating laws against illicit drug use or prostitution involves no violation of a moral obligation. Then, you probably think that those acts should not be crimes. This implies that you assume that the sorts of things that should be crimes are the sorts of things the doing of which do violate moral obligations. Or, suppose you think something rather radical, say, that inner-city violence against the police is not immoral because it is a kind of legitimate self-defense or even retribution. Even here, you are taking a position on the moral status of criminal acts. Most importantly, calling an act self-defense or retribution is a way of saying that an act that is normally immoral is morally permissible in light of what it is a response to. You are assuming that the same acts, if not done in self-defense or as retribution, would be immoral. That is what I mean by saying that the view that crime is a moral violation is the default position. Crime is prima facie a moral violation, that is, it is a moral violation, unless reasons to the contrary can be given. To hold that crime is a moral violation is to affirm part, not just of a social theory of crime, but of a moral theory about what human beings owe to their fellows in the way of conduct. And, insofar as you affirm such a moral theory, not blindly, but after reflecting on its validity, you are squarely in philosophy's jurisdiction. There's another way to make this argument. Many criminologists believe as I do that the legal catalogue of crimes is biased in certain ways. For example, it focuses on the acts of poor people and ignores much of the antisocial behavior of the well-off. Those criminologists may also believe as I do that this bias weakens in some measure the obligations of the poor to obey the law. Other criminologists disagree on both the claim of bias and on the weakening of obligation, or they might accept one of these and not the other. What is this disagreement about? Well, certainly, it is a disagreement about what should be crime. This is clearly a normative disagreement. In disagreeing about what should be crime, we are disagreeing more generally about what kind of conduct individual human beings owe to each other. This is a disagreement about the requirements of interpersonal justice. In disagreeing about how bias in the legal determination of crime affects the moral obligations of the victims of that bias, we are disagreeing about what society as a whole owes its members. This is a disagreement about the requirements of social justice. Both are philosophical disagreements that arise from trying to say what crime really is in the society that we are studying. And since all criminologists must believe either that the definitions of crime are biased or that they aren't, or that some are and some aren't, and they must believe as well that this does or does not weaken obligation, it follows that all criminologists must hold philosophical views that fill out their notions of what crime is, and the reflection that leads them to believe that these philosophical views are valid is philosophical reflection. I now turn to the specific philosophic commitments that underlie the rich get richer and the poor get prison. 242. 243. The rich get richer and the poor get philosophy. I got the idea for the rich get richer while reading Richard Quinney's seminal work, The Social Reality of Crime. 6. That provocative book contended that crime was not some real, objective event in the world, but the creation of a labeling process, the crucial step in which was the definition of crimes by lawmakers. In short, crime has a social rather than a physical reality. What's more, Quinney held that this social reality was created in a politically biased way. Quinney contended that the labeling of some acts as crimes by lawmakers reflected the interests of the wealthy and powerful in the society at the expense of the rest. I found this conclusion very believable, but I was dissatisfied with the argument by which Quinney arrived at it. In effect, he contended that lawmakers were from the wealthy and powerful groups in society, that they tended to act in their own self-interest, and consequently, that the criminal laws they wrote must reflect their interests, which is to say, the interests of the wealthy and powerful and not the interests of the rest of society. 7. This argument has the advantage of being neat and economical, but the disadvantage of being inconclusive. It assumes that, because people tend to act in their self-interest, then we can conclude of anything they do that it is in their self-interest. But, sometimes people act contrary to their self-interest. They may occasionally act to do their duty, or to do what they think is right. Think, for example, of people who risk their own lives and the lives of their families to hide Jews from the Nazis during the Second World War. It can happen that people are motivated to do the morally right thing. And it's just possible that lawmakers were doing this at the moment that they were writing criminal laws, even if in general they tend to act in their own interest. Moreover, that something is in the interest of the wealthy and powerful doesn't entail that it is not in the interests of others. It might be that what is in one person's interest is also in that of others, such that when the person acts in his own self-interest, he serves the interests of the others in spite of himself. And this is arguably the case regarding the criminal law, since both wealthy people and poor ones have an interest in, say, not being robbed or murdered. Then, even if the wealthy and powerful draw up laws against robbery and murder to serve their own interests, they would be serving the interests of the rest of society at the same time. To get to the politically critical conclusion that Quinney wanted to reach, a different sort of argument was needed. What sort? First of all, as I have been suggesting all along in this essay, it was necessary to take some distance from the legal system's list of crimes. That required establishing some normative standard of what should be crime, against which the actual legal definitions could be assessed as fair or biased. The normative standard with which I stated in The Rich Get Richer was simple and uncontroversial. I contended that a criminal justice system ought to be protecting the lives and limbs and possessions of the citizenry, and thus the legal list of crimes ought to follow this imperative. The most serious crimes should be the gravest threats to life, limb, or property, and the gravest threats to life, limb, or property should be the most serious crimes. With this notion in mind, I looked at the most serious threats to life, limb, and property in society and compared them to the law's list of crimes. What I found was that, while the criminal law did treat some acts that posed great threats as crimes, many equally or even more dangerous acts were not treated as crimes. Either they were not labeled crimes, or they were not labeled serious crimes in proportion to the danger they threatened, or, if they were labeled serious crimes, they were rarely treated as such in practice. I noted as well that some acts labeled crimes did not seem to be threatening or dangerous to society at all. Here I have in mind the so-called victimless crimes of voluntary recreational drug use by adults, consensual commercial sex, 244, and so on. This, in turn, led me to ask what the acts labeled crimes had in common and what the dangerous acts not labeled crimes had in common. And my conclusion was that the acts labeled crimes, instead of being all dangerous acts, were predominantly acts of the poor in society. And the dangerous acts not labeled crime were predominantly acts of the well-off. With these conclusions, I could show that Quinney's conclusion was indeed largely correct. The law's definitions of crime serve the interests of the wealthy and powerful at the expense of the rest of society. I say largely correct because there are crimes in the law's list that are acts that threaten the poor. Many of the crimes tracked in the FBI's UCRs certainly do, and there are dangerous acts of the well-off that are occasionally treated as serious crimes, as Enron's Andrew Fastow and WorldCom's Bernard Evers have recently learned. But largely correct is correct enough to support the critical conclusion. My point here is that reaching this conclusion required a reflection on what crime is that could not rest satisfied with legal or conventional understandings. It had to be a normative, and thus philosophical, reflection on what crime should be in order to compare reality to this and find it lacking. The route from which acts are and are not crimes to the conclusion that the legal definitions of crime serve the interests of the wealthy and powerful had to pass through a theory of what should be crime. In sum, the social inquiry that leads to the view defended in The Rich Get Richer, namely, that the criminal justice system is biased against the poor, relies on an irreducibly normative and thus philosophical conception of crime. Moreover, this conception of crime was not simply pulled out of a hat. It was the product of philosophical reflection. This philosophical conception of crime is based on an equally philosophical conception of social and political justice. I contend that the ways in which the coercive apparatus of the law is used must be justified in principle to all citizens. This is so for three reasons. First, both our tradition and our social order take freedom, the right of sane adults to do what they want, as a paramount value. Freedom is important because people tend to enjoy acting as they wish, and because it is the necessary condition of having a life that can be seen as one's own accomplishment, a life of which one can be proud. Without freedom, we are playing out a script of which we are not the author. Freedom is also important as a source of new ideas and creativity and thus of social progress. For these reasons and others, I start with the idea that freedom is a great value and thus that those who would limit it owe a satisfactory justification to those whose freedom is to be limited. Second, on the social contract tradition in political and moral philosophy, which is enshrined in the Declaration of Independence, and, indeed, on any democratic view, the coercive power of the state police, prisons, and so on represents the people's own power, and thus can only legitimately be used for the people's own purposes. Consequently, the exercise of that power must be justifiable to the people in terms of their own purposes. Third, the legal system appeals to the citizens morally, that is, it implicitly and explicitly asserts that the citizens are morally obligated to comply with it. But, on the contract model, obligation is a matter of owing fair compensation for benefits one receives. And, thus, only laws that benefit people can obligate people. Ultimately, this has to be cashed out individually, because it is as individuals that we are obligated or not. The law must benefit me, protect me against something that really threatens me, for me to be morally obligated to obey it. The law must serve people's interests to be morally binding on them. And thus the claim of the law to morally obligate citizens requires that it be justifiable to them in light of their interests. 245. This is not the whole story. I am, for example, also benefited by the fact that the law is the product of a democratic process, whose benefits are only available on the assumption that laws will be binding even on those who do not approve of them or find them in their interest. And, I am benefited by order itself, by the predictability and regularity of my fellow citizens' conduct that come of their obeying the law even if they are unhappy with it. Consequently, the argument as to whether I am or am not obligated to a particular law starts with consideration of whether it serves an interest I have, but it doesn't end there. Even if a particular law doesn't benefit me, some weight must be given to the fact that democratic lawmaking systems are beneficial generally, and order is as well, and that both democracy and order require people to accept laws which they don't think serve their interests. Nonetheless, if a law or a whole legal system significantly veers from serving all citizens' interests and towards serving the interests of some segment of society at the expense of the rest, the weight of democracy and order will not be enough to preserve the obligatory nature of the law. Such veering away from serving all citizens' interests will weaken, if not eliminate, the obligations of those whose interests are served less or not at all. This is the philosophical reflection that underlies the simpler claim that the criminal law should be protecting citizens' life and limb and possessions generally. Because it must serve all citizens' interests, a just legal order must criminalize behavior that threatens the interests of all citizens, and it must do so in proportion to the gravity of the threat posed. It must not be protecting citizens only or even mainly against threats posed by the poor, while leaving the threats posed by the wealthy either untouched or only lightly grazed. This philosophical argument also creates a presumption against the legitimacy of laws against victimless crimes, because laws that criminalize actions that do not clearly have victims, actions that some people detest but others accept, will surely appear to many in society as nothing more than the majority building its moral preferences into the law with no more justification than that they are the majority. Large numbers of citizens will tend not to view themselves as obligated by such laws, and, in my view, they will often be correct. Thus, not only does my argument pass through a normative theory of crime, but also that theory is itself based on a theory of social justice. Moreover, since a theory of crime is part of a theory of society, this conception of crime reflects a conception of how society works that is, to my mind, equally a matter of philosophical reflection. Basically, my view of U.S. society is that it works roughly the way Marx supposed it would. It is dominated by the capitalist mode of production, which brings with it a crucial class divide between those who own means of production and those who don't. This has the consequence that, in a certain significant sense, the non-owners are forced to work for the owners. The divide between owners and non-owners amounts to an inequality in power between the two classes, which goes far toward explaining what is and what is not treated as crime in capitalist societies. However, the Marxian view has even richer resources for explaining this bias. It holds that the capitalist mode of production is accompanied by an ideology, the core of which is blindness to the coerciveness of ownership of means of production vis-a-vis non-owners. 8. I believe, by the way, that, within these coercive relations, a capitalist economy works pretty much the way neoclassical economists such as Milton Friedman think it does, and Marx generally believed this as well. This accounts for the general success of neoclassical economics, while its blindness to the coerciveness explains how neoclassical economics can be ideological even as it accurately describes market tendencies. 246. Blindness to the coerciveness of private ownership of means of production is not primarily due to active deception by those in power. It is rather the way in which capitalism normally looks to its participants who view it, so to speak, up close. The illusion that capitalist transactions are fully free is similar to the illusion that the sun goes around the earth. It's just what you would expect people to see from where they are standing. Up close, the fact that capitalists, unlike feudal lords or slave owners, cannot use violence to get people to work for them makes the transactions between owners and non-owners of means of production appear free. They are, of course, free in important ways, but not as free as they seem. Workers are free to choose among capitalists, but not free to avoid working for one of them after all, leaving aside the marginal alternatives. Working for the church or the government, stealing, or begging, and, for the few who have the initiative and willingness to sacrifice as well as plenty of luck, the possibility of going into business on one's own. Since most of the ways that the wealthy pose dangers to the rest of society are as threats either to employees, subjecting them to preventable occupational hazards, or to consumers, subjecting them to shoddy products or to higher prices due to corporate skullduggery, blindness to the coerciveness of capitalism makes it appear as if employees and consumers, who are, of course, the same people, have signed on freely to the risks involved. Consequently, those responsible for these threats don't seem like criminals, because criminals characteristically force dangers on their victims. In light of the coerciveness of capitalism, however, this difference is largely illusory. For all intents and purposes, occupational harms are forced on workers. They must choose among the jobs that are available, and product risks as well as corporate financial shenanigans are forced on consumers. They must choose among the products that are available, and they must pay for the losses due to corporate misdeeds when they are passed on in the form of higher prices. Nonetheless, the law in capitalism continues the illusion that these dangers are voluntarily accepted, by focusing mainly on one theft and violence, while treating deadlier preventable occupational hazards as well as consumer risks and costlier financial misdeeds as merely regulatory matters. Consequently, the Marxian view will lead us to expect just the bias in the legal definition of crimes that the rich get richer documents. I should add that my Marxism is tempered by recognition of two interconnected failings in Marxian analysis. One is the failure to see how dangerous to human freedom socialism could be, even though there is a good Marxian reason for expecting socialism to be dangerous. If ownership of the means of production is the main instrument of coercion in a society, one must have a very idealistic view of human beings to be willing to place that instrument of coercion, whole and entire, into the hands of a single institution, the government. Socialism only has a chance of being a truly liberating social form for a society in which democracy is already very well developed, and in which citizens are already extremely sophisticated about the exercise of their democratic power. This leads me to believe that the likelihood of a truly liberating socialism is way off in the future. For the foreseeable future, the future in which we are all likely to live and die, I can see no truly liberating alternative to capitalism. And, sad to say, the current and recent examples of socialism, China, North Korea, and the former Soviet Union confirm this bleak conclusion. On the other hand, there is a good Marxian reason to expect capitalism to maintain individual freedom. As a system of multiple competing owners of means of production, capitalism distributes the main instrument of social coercion among a multiplicity of separate agents. Thus, capitalism maintains a space for individual freedom that results, not from an enlightened citizenry or officialdom, but rather from the material conditions of capitalist production itself. In a kind of Madisonian fashion, the multiple competing owners each have an 247 interest in resisting the control of the economy by other firms and thus in keeping the market generally open, and the government in a wide variety of hands. Moreover, capitalism does, as Marx very explicitly noted, create enormous technological progress that reduces unwanted toil and increases the material income of the workers. The impoverishment to which Marx thought capitalism led is a matter of workers decreasing relative share of the product of their labor, but, since this is caused by the fact that labor under capitalism becomes increasingly productive, this share buys more and more goods. To be sure, capitalism is also a system that generates large, and, recently, growing, inequalities, which in turn give some people great power to determine the way others live. That is, capitalism not only makes some people richer than others, but also makes some people freer than others. Moreover, capitalism subjects all of us, but the poor most of all, to forces and developments beyond our control, making life uncertain for most, and painful for many. These facts, taken together with the dangerousness of socialism and the freedom maintaining tendency of capitalism, mean that Marxism implies of capitalism roughly what Winston Churchill said of democracy, namely, that it is the worst form of economic system, except for all the others. The second failing in Marxian analysis offers some compensation for this conclusion, which some readers may find too dismal. The second failing is that of not seeing how progressive capitalism is culturally, that is, in the dimension that Marx called the relations of production. Marx and Marxists saw clearly that capitalism is progressive with respect to the means of production, that is, the development and implementation of labor-saving technology. But, Marx and Marxists did not, though Marx did more so than Marxists, see that capitalism is also progressive with respect to the relations of production, that is, the growth and spread of liberal values and institutions. Under these, I include the preference for greater personal freedom, tending toward the requirement of harm as a justification for restricting freedom, and against victimless crimes or other restraints based on faith or tradition or custom, the inclination toward using rational criteria for evaluating people, tending toward use of merit and conduct to judge people rather than race or gender or creed or age, and the insistence on more effective and responsive government, demanding freedom to vote and the progressive extension of eligibility to vote, freedom to assemble, and the rest. These progressive tendencies are, of course, very imperfectly realized. Nonetheless, that does not mean that they are unimportant or without effect. I think that Jürgen Habermas has gone some distance toward integrating this progressive dimension of capitalism's liberal culture into Marxian theory. 9. The second failing is connected to the first in several ways. One way of explaining why existing or recent socialist societies have been as unattractive as they have is that they embraced capitalist technology without embracing capitalist liberalism. Socialists failed to realize that socialism itself is sure to be oppressive unless it is staffed by officials who are deeply imbued with liberal values, and held democratically accountable by a populace that is equally so imbued. But the second failing has a bright side as well. In recognizing the progressiveness of capitalism with regard to the relations of production, we can see a way in which the fact that we are probably stuck with capitalism for our lives and beyond presents a special opportunity. Capitalism produces the cultural tools needed to push it to become fairer. The struggle to make people freer and more equal is a struggle to make capitalism live up to its own liberal ideals. And, there is reason to hope that this struggle can succeed, since the values that guide it are the very ones affirmed by cultural institutions within capitalism. 248. This, to my mind, locates the rich get richer and the poor get prison in philosophical space. It is a radical critique of criminal justice in capitalism that works by confronting capitalist criminal justice with capitalism's own liberal moral philosophy.